Welcome in, everybody. Thank you for being here. We got two things going on here. First, we have a feed from what was yesterday that we didn't see yesterday. And it was the time that right after the defense, right after the prosecution rested, the defense did throw up a motion. And now we're going to get to watch that today because another channel had it. Second, we're going to watch new feed that's already been dropped for today from the courtroom, and it is footage of them inside of her home. It's her own it's her own video footage. So yeah, we're going to get to watch that motion. So I apologize, I was on mute. Yes, go ahead, throw them up, throw up the emoji. I made my own Carrie's muted emoji so y'all could just have a good time with it. Yeah, Northwest, don't give it all away yet. Don't give everything away yet. Did you? Did you already give everything away? Shh. Shh. Okay, let's watch this motion first.
We're going to take a little bit of a break, so if you'll follow Deputy Huff, and then we'll be back in a few minutes.
You may be seated.
People of the state of Michigan versus Marshella Chidester.
Be seated, please. All right, so the people have rested. Do you have a motion you wish to make?
Yes, Your Honor. It's a motion for directed verdict with regard to the proofs the court heard, all the proofs of trial testimony, all the evidence. Your Honor, we ask that the directed verdict of not guilty be based on the counts based on, well, the first is that the alcohol testing was at acetone, and acetone is fermented, actually to be deadly. Solvent sometimes on it, which, in my opinion, it produces inaccurate results. I understand, Your Honor, totally that the expert said that those were accurate results. Number two is that the search, that the warrant was not proper. And I don't arguing this, but I'll just refer to our prior arguments. I did do a rehearing motion that dropped off. I can't roll things in. It was a late hour. Yesterday, dropped it off on the court with regard to the prosecutor that signed and approved. So there was ex parte communication there, knowing that I was representing him. So we asked that that be stricken. And also, it being, we argued this before, so I just refer to our prior motion and ask for a directed verdict based upon part of that reason, is that it was private property membership only. Anything with alcohol would be excluded. Thank you, Your Honor.
Thank you, Judge. As to Mr. Clovis's last 2 points, those are motions that have already been decided by the court and ruled against. I don't think those are valid bases for a directed verdict. As to the first tenet of Mr. Clovis's argument, that's for an expert to say, Judge. Mr. Clovis's opinion doesn't merit the court's time in that round.
Your Honor, there was one third one, and I apologize, that there's been no proofs whatsoever that there was any type of specific intent or any type of intent by my client, which is required for second-degree murder. Thank you.
All right, you can address that.
I'm sorry?
All set.
I'm all set. I apologize. Yes.
So, judges, as to our response, people have established date, venue, and the idea of the defendant. Beginning with counts 3 through 9, the court was able to view the body-worn camera from Sergeant Bomia, Deputy Karina. Defendant acknowledged her operation of the vehicle in both videos. The blood and gabapentin came in without objection. They showed the defendant's level of intoxication at a 0.18. They also show the presence of gabapentin at 1.3. The court would have to refer to the report for the numerical value. The medical examiner's report, which were both stipulated exhibits, established the cause and manner of death for the victim's Zayn and Alanah, that both died as a result of multiple blunt force trauma as a result of a car collision. The medical records, which were stipulated to, and beyond even that, the stipulation that the named victim's injuries rise to the level of a serious impairment under the statute. Those were stipulations. So for victims Diana Medina, Ed Smothers, Zayn Phillips, Mariah Dodds, and Leah Stiff, those are all stipulated to as the result. So you've got operation, intoxication, date, venue, and the resultant injury. There's also ample evidence of causation. But for defendant's operation of the vehicle, none of those things would have happened. So for those reasons, people think they've made a sufficient showing on counts 3 through 9. As to counts 1 and 2, people incorporate the proofs previously noted, and that the named victims died as a result of defendant's actions. The people have established for the court that the defendant knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of her actions. Specifically, the defendant possessed a blood alcohol content of 0.18, the legal limit being 0.08, the high BAC limit or super drunk limit being 0.17. The defendant acknowledged to Deputy Karina that she believed she was a 7 out of 10 for intoxication. Maybe more importantly, though, is that she should not be driving. In the Michigan Supreme Court case 1998, People versus Goki, the Supreme Court found that there were certain factors that a finder of fact may consider to support a charge of second-degree murder, and they relied somewhat on the Michigan Appellate Court case of People v. Aldridge, in which a defendant operated her vehicle at an excessive speed. In that case, it was 45 miles an hour in a parking lot, and excessive speed was held to be a factor that the finder of fact could consider in determining second-degree murder versus a different type of charge. The defendant left the scene of a property damage accident in this case. That was the crash she caused by backing out of her driveway. In the unreported case of People versus Del Piano, it's a 2012 case by the Michigan Court of Appeals. It can be found at Westlaw 304-6157. That case found leaving the scene of a property damage accident prior to causing a death to be a tenet that the court could use to determine that second-degree murder is support. And finally, Judge, the Gecki case, the Supreme Court case, notes that in all cases of this nature, in order to sustain the intent element of second-degree murder, the incident should have an overall egregiousness factor. Here, people point out the defendant's high BAC, not only twice the legal limit, but above that. Also, the gabapentin in her system. She acknowledged to Karina she was intoxicated, scoring herself a 7 out of 10. She left her home in that condition, knowing she was traveling to a small child's birthday party. For those reasons, Judge, people think they have satisfied the intent element for second.
All right, thank you. Last say so, Mr. Close.
By analogy, I argue is somebody sees a yellow light, and this is in relation to intent. Somebody sees a yellow light, they choose to speed through the yellow light, there's a crash, and that's stop. That's intent, and that would be the type of intent in this case. It lacks any intent because she didn't choose to do, whatever they claim she attempted to do is murder somebody. Absolutely not. If anything, that's the furthest of what took place. She didn't even understand what happened, whether it be spasms or whatever.
All right, thank you. So the court is required to review all of the testimony that's been taken in the light of, in favor of the prosecution, making a determination whether there is a sufficient case to send the matter to the jury to make a decision. Let me address some of the preliminary issues. First of all, the testimony and everything we saw, it's clear that this happened in an area that was accessible to the public. In fact, taking a look at those photos, you really can't tell where the road stops and the parking lot begins, but clearly it is all accessible to the public. Second of all, the question regarding the warrant, I ruled on that yesterday. I acknowledge receiving what was called a rehearing, but the allegation was made that an attorney from the prosecutor's office had ex parte communications with the magistrate. That is a serious allegation, and without any support, I find it's a reckless allegation. And when I take a look at what was attached as an exhibit, prosecutors sign off on these all the time. In fact, everyone I've ever seen, prosecutor signed off on. This prosecutor signed off the day before the affiant signed it. There's nothing in here that shows there's been any contact whatsoever with between the prosecutor and the magistrate. So that leaves us really with the charges themselves, what I consider more the core issues. As it pertains to the second-degree murder charge, the elements, as it pertains to both children, is that the defendant caused the death of those children, that they died as a result of the defendant knowingly creating a very high risk of death or great bodily harm, knowing that the death of such harm would likely result from her actions, and by driving while intoxicated or recklessly under the influence of alcohol or gabapentin. Second, that the defendant had one of these three states of mind. She intended to kill, which is the intent question that defense raises. She intended to do great bodily harm. Or the third one, she knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would likely be the result of the actions. And I do find that the testimony supports all of the elements for second-degree murder. The Goki case is exactly on point. We have an overall egregiousness here, at least the argument would be, and certainly it's for the jury to decide. We have a blood alcohol of 0.18, which has been admitted. The issue of the acetone, that's for the jury to decide. We have a high BAC. We have the use of gabapentin with the alcohol. And then we have the video showing the defendant backing out of her driveway and running into the neighbor's car. Maybe that should have been the time to kind of keep an eye on things, but then charging forward all the way through the building. As it pertains to the operating while intoxicated causing death, the elements are different, but it has to do with the intoxication, and clearly the evidence is in, at least for the jury to decide that she was operating with an alcohol content of 0.18, further that it caused the death of both Zayn and Alanah. As to the other charges, those are all operating while intoxicated, causing serious injury. I've mentioned the intoxication, I've mentioned the operation, and there's been no contesting of the injuries. For all of those reasons, a motion for directed verdict is denied. You bring the jury in, please.
That catches us up for yesterday, and now we're going to start off with today.
Sergeant, you testified previously that you executed a search warrant on defendant's home. Is that correct?
Yes,
And when was that done?
that would have been Monday, I believe it was the 22nd
And
of April.
Sorry, you testified that you found some cameras and a DVR recording system.
Yes,
Did you find any cameras inside the home?
yes,
And how many cameras were there?
one.
Where was it located?
In the kitchen area.
In the kitchen area. Were there any were you able to locate any recordings from April 20th of 2024
Yes,
in the kitchen area camera?
yes,
And did you have a chance to review those videos?
yes.
And did you find the timestamp to be accurate on those, or similar problem as the other ones?
Similar with the other one. Again, if it was an hour behind. So if it said 3 o'clock on the timestamp, it would be 2 o'clock.
Did you make a copy of these videos?
Yes,
And You viewed them, correct?
Yes.
Okay. You reviewed what's purported with people's proposed exhibit 38A through 38F.
Yes.
And are these all of the recordings from inside the home?
No.
Just pertinent to the case that you.
Correct.
Judge, I'm going to move to admit people's 38A through 38F.
Response.
I'd like to see what they look like before, Your Honor.
Are you gonna play him?
I'll move to proffer next, Judge.
All right,
All
let's
right,
do that.
can we play 38A, please? 1 second, don't play it just yet. Detective, can you, for me, tell me what the date and time is on this?
So the original date and time is 4/20 of 2024 at 8:24 and 47 seconds in the morning.
And so that would actually be what time?
9:24 and 47 seconds
AM.
a.m.
Okay, please play the video. Please play 38B, or actually bring it up. Detective, what is the timestamp on that?
9:24 and 38 seconds a.m.
What would be the accurate time then?
10:24 and 38 seconds a.m.
Please play the exhibit. Please pull up 38C. Detective, what's the timestamp and date on this one?
9:45 and 12 seconds a.m.
Also from April 20th?
Yes.
So what is the accurate time then?
10:45 and 12 seconds a.m.
Please
on the 20th. Please pull up 38D. Detective, what is the date and timestamp on this one? April 20th, 2024, 11:35 and 1 second a.m.
And what is the actual time, accurate time?
12:35 and 1 second, and that would be p.m.
Please play the video.
Your Honor, for the record, this is 38D.
That's correct.
Okay, thank you.
Please pull up 38.
So she must be back from
Detective, what is
Verna's.
the date timestamp on this one?
April 20th, 2024, 1:10 and 38 seconds PM.
It says 13:10, but that is, the translation is 1:10 PM.
I'm sorry, yes, that's military time.
Sure.
So
1:10
What
p.m.
is the accurate time?
that would be 14:10 and 38 seconds or 2:10 and 38 seconds PM.
Thank you, Jim.
There it is, for the record, it's 38E.
He is in here.
Thank you.
So before and after Verna's is what they're showing. Wine. She's got wine. I wonder if they're going to be able to see her go back and forth into the kitchen and keep refilling.
38, yeah. Detective, what is the date and timestamp on this?
April 20th, 2024, 13:31 and 50 seconds or 1:31 and 50 seconds PM.
And what is the more accurate time based on the timestamp inaccuracy?
It would be 14:31 and 50 seconds or 2:31 and 50 seconds PM.
Approximately 30 minutes before the crash.
Correct.
Please play the video. Judge, people again move to admit exhibits 38A through 38F as in Frank.
Response. Your Honor, we have no objection, just for the record, prior motion that was filed prior concerning this, but no objection.
People's 38A through F, they are admitted.
Thank you, Judge. I have no further questions for this witness, Judge.
Cross?
Officer, did you, were you ever inside my client's home prior to the date you executed the warrant?
No,
And when you obtained this videotape, you obtained the contents of the videotape, correct? Or the video machine or recording machine?
yes,
Okay, with this search warrant, right?
yes,
Okay. Did my client participate in you going through, well, you had a chance to go through and look at hours of videotape, correct?
correct,
And he didn't stop you at all from taking the videotape. You asked for it, and he showed you where it was, and he gave it to you, correct? My client's husband.
correct,
Okay. And you didn't have him come to your office and go through the videotape from start to finish to confirm that that's the videotape, no editing, no nothing, that it's the full videotape. Did you ever have him come do that?
he did not come to my office, no,
But you never went through the entire videotape with him prior to you starting to edit and show certain fragments today, correct? He didn't participate in editing this, correct?
it's not edited, it's just the videos were taken off of the DVR.
Okay. If the DVR has 6 hours of recording and you take 2 or 3 spots, segments, That would be editing, right? Because it's like taking a police report and putting black certain parts.
I can't say one way or another. I don't believe
Is that the
so.
full videotape?
Is that the full
Full
contents
videotape
of,
of
Okay,
4
hang
hours?
on a second, ask him a question, you
Okay.
talk over.
You're right, Judge.
that is not the full contents of all the video for that day. No.
And who decided to participate in, for lack of a better word, editing or picking which versions and how they were obtained? Who did that? Did you do that? Did an IT person do it?
No, I looked through all the video footage.
And you picked those to bring to court today, right?
I notified the prosecutor's office of my findings.
Okay. And your job is to participate in people that are arrested and participate in coming to court and participate in getting convictions. Do you agree with that? You're not here.
The question is argumentative.
That's not argumentative. How's that argumentative, Judge?
Your job is in getting convictions.
Well, what's he doing here today? Is he working for me and saying
I
she's
think what he's
innocent?
doing is telling the truth.
Okay.
That's his job, so in that regard, the objection is sustained.
Okay. Do you come to court to testify in criminal cases in your history of being a police officer to
Right.
prove the innocence of the accused?
The same objection, Judge.
It applies.
All right, thank you. I'll withdraw, Judge.
Ooh, the judge
Any more
snapping
rebuttal?
back.
Briefly, Judge. Detective, you said there are other videos for this, correct?
Yes,
Do they present as one long 6-hour video or however long?
they do not.
How do they appear on the system?
So on the system, they are motion activated. So each time it triggers, it creates a new video. So for that complete day, on that DVR of all 4 cameras, I believe roughly approximately 460 video clips.
They're all short video
They're all-
clips?
Absolutely, all short, maybe a minute long.
You didn't edit down a longer video into short clips.
No,
This is how they came to you.
yes,
Did you make any alterations to the videos?
no.
Nothing further, Judge.
Okay, chill out in the chat, Denny. Y'all chill out. We're going to see it. We just started watching it for the day. We got a lot to watch. So don't worry, you haven't missed anything.
Detective, you're not showing any videos from 6 in the morning, am I correct?
Correct.
And there were activated videos, motion activated from, let's say, 6 in the morning, do you think? Or is this the only time that she walked around?
No, there were other videos of her walking around.
There are other videos of her walking around. All right, so here's what we have up right now. Right now, we don't have the defenses calling the expert. It's probably going to come up in a little bit. So I'm going to go straight to the prosecution's closing arguments, unless you guys want to wait for a little bit. Yeah, the kitchen video, right? No, this was not shown yesterday. This part that we just watched. The part that we just watched actually happened this morning, from what I can understand. It's still part of the day today. But now we've got the closing arguments from the prosecution, which is only about 14 minutes. So what we could do is play that, and then we'll come back, but maybe by then they'll have that other expert witness put up before we play the defense's closing. So let's do that.
Gentlemen, I know it's been a long 4 days. We appreciate your patience and your attentiveness. You've now seen all the evidence and heard all the testimony that you're going to hear in this case. I told you at opening that I'd come back here at closing and go over the evidence with you. There are some photos that the people did not show during the case in chief. Those will go back with you into the jury room. If you feel like those will be helpful in rendering your verdict, you're free to look through them and review them. The same with the defendant's interview. The people did not play that in their case in chief. The defense didn't elect to play it. I think the parties all felt it didn't move the needle too much one way or the other, but you're also going to be free to view that back in the jury room. So what has the evidence in this case shown? It showed that Diane Medina, Leah Stith, Ed Smothers, Jaden Phillips, and Mariah Dodds were all injured as a result of the defendant's operation of the motor vehicle. We could bring up the jury instruction on OWI causing serious impairment. And you'll have this written back in the jury room. But the injuries being the result of the operation of a motor vehicle is one of the elements you need to find. That is not in dispute. The defendant was the factual and proximate cause of those victims' injuries. Further, those injuries rose to the level necessary under the law for you to find that element in counts 5 through 9. This is actually stipulated to by the parties. In other words, we agree the degree of injury is not in dispute. Further, you could bring up OWI causing death. The evidence shows that Zayn and Alanah Phillips died as a result of the defendant driving that day. Their death was a factual and proximate result of her operation of the motor vehicle. They do not dispute this. You did not hear from a medical examiner because the parties agree that that was the cause and manner of death. It is not in dispute. The defendant's willful operation of the motor vehicle is not in dispute. The parties agree. We all saw the video of her leave her house and get in her car.
Judge, I agree that there's willful use of an automobile. But it just said we agree on willful.
No, fair enough. I guess.
I agree there was an automobile accident. It's proximate cause of a horrible thing of injuries and deaths.
All right, your objection is
All
sustained.
right.
People offer to you that the proofs show that the defendant willfully operated the motor vehicle on the date in question. You all saw the video of her get into her vehicle and drive it away from her home. We think that element is met. Her identity as the driver of the vehicle is not in dispute. People would offer that there are two key elements in this case that are in dispute: the defendant's blood alcohol concentration and her intent when she crashed into the Swan Boat Club. As to the BAC, the blood alcohol concentration, you've heard from several credible, experienced, and dedicated professionals about the level of care and the quality that was taken with defendant's blood draw and the subsequent testing. You heard from Deputy Schmidt, who was able to walk you through the blood draw process and confirm that everything was done according to proper and long practice procedure. You heard from Ro Monday, the phlebotomist, who testified she had conducted thousands of blood draws in her career. And she also told you she followed the correct, proper, and accepted procedures. Former Deputy Krieger, Lab Technician Hopner testified. They both told you that not only were the policies and procedures followed, but they went above and beyond. That typically a blood sample would be dropped in the mail. This one was hand delivered by deputy to the Michigan State Police Crime Lab. Finally, our two experts in forensic toxicology, Tabitha Faust and Samantha Beecham, testified to the procedure for testing the blood and their results. Their results, that the defendant's blood was a 0.18, more than twice the legal limit for regular OWI and exceeding the limit for high BAC OWI. Further, there was the presence of gabapentin in her blood. But this is disputed. So what can you folks do? What other evidence can you look at to support the expert's evidence of the blood draw? First, you can look at the testimony from the first day of Miss Sigler and Mr. Wickland. Miss Sigler testified that she smelled alcohol on the defendant immediately after the crash. Mr. Wickland flat out called her drunk when he helped pull her out from behind the wheel of the car. He further testified he smelled alcohol on her as well. Deputy Karina said she smelled of alcohol, and Deputy Schmidt went through the field sobriety testing with you. In his opinion, she failed field sobriety testing. But how else do we know the blood alcohol result was accurate? We know because she told us. We could bring up the first clip from Deputy Karina.
To 10, 0 being like you're so cold sober you can drive perfectly, 10 being you're passed out drunk. Where do you think you're at right now?
7.
A 7? Okay.
What else supports it? When they tested her blood, they found gabapentin in her blood. What did she tell us about her gabapentin?
Run through the medications that you told me about again.
Gabapentin,
When did you take your medications today?
8 o'clock.
8 a.m.?
Yeah.
Oh,
And how do we know she had more than the one drink at Vernus? It's well established in the evidence, and I don't think either side disputes. She left Vernus at the latest at 12:15. Crash was at 3:01. But remember what she told Sergeant Bomia.
over there?
A little bit, yes.
Okay. When's the last time you had something to drink?
Probably half an hour ago.
Half an hour ago, what did you drink?
Wine.
Okay.
And just today, you heard from the clerk at Fermi 3, and you saw the video from inside the defendant's house. It's true that she had one glass of wine at Vernus. That doesn't speak to the rest of the day. All of those other pieces of evidence that I've just talked about, just showed you, work together to show beyond a reasonable doubt that the drink at Vernus wasn't her first or her last drink of the day. It's similar to the mystery story I mentioned to you in voir dire, that all of the evidence lines up to show one result, except one thing. And that one thing is defense's expert. But everything else works to show that the BAC result is accurate and in line with what she did that day. The second element that people believe are in dispute is the defendant's intent. Could bring up the second-degree murder instruction. For the OWI causing death and the OWI causing serious impairment, you only have to find willful operation of the vehicle and that her blood alcohol exceeded the legal limit, or that she was intoxicated, or that she was impaired by alcohol and gabapentin. For the people's first two counts, the two counts of murder in the second degree, you have to find a separate intent. You can find one of three kinds of intent to find the defendant guilty of second-degree murder. You can find that she intended to kill. You can find that she intended to do great bodily harm. Or you can find she knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of her actions. As we talked about in opening statements, you can look at what she said, you can look at what she did, and all the evidence and circumstances surrounding this case that you've heard over the last 3.5 days to decide what her intent was. You can think about her driving toward the boat club, straight as an arrow, right between those two telephone poles. You can think about what she said to Kristen Sigler right after the crash. Where's Don? She wanted to know where her husband was. You can think about her crashing into the neighbor's truck. And then continuing on her way. At the moment she crashed into that truck, she had to know things were not right, but she continued on. She continued on at full speed and drove her car into a 3-year-old's birthday party, into a building, a route that she knew very, very well. Ladies and gentlemen, this is not a typical drunk driving crash. Not at all. She didn't cross a center line and strike oncoming traffic. She didn't misjudge a red light and rear end someone. At almost 45 miles an hour, she drove through the wall of a building that she had been to countless times. That's what makes this worse than OWI causing death alone. She drove her car into an occupied building knowing she was unfit to operate a vehicle. And if she didn't know she was unfit to drive when she got behind the wheel, she knew it after she hit her neighbor's truck. Who started? Five, 4, 3, 2, 1. 44.3 miles an hour on a dusty, pitted dirt road. Look at all those things to determine her intent. As most criminal trials are, the focus of this trial has mostly been on the defendant. How she drove, the contents of her blood, and her state of mind. But let's not forget, a trial is about a fair trial for the defendant and for the victims. The ones you heard testify and the ones you couldn't hear testify. It's about an 8-year-old big sister and her little brother. 2 little kids that had just sat down to eat their hot dog and a cake pop at a birthday party. Sat down to have some lunch without a care in the world. They didn't have a chance. It's about justice for these 2 kids. Thank you.
I thought he did pretty good. What do you guys think? Did he say, I know Teresa says, I wish he'd mentioned how long she had to sober up before testing. Did he not mention that? Did I miss that part? Yeah, so, okay, here's the deal with the doctor. So her doctor went to court. I don't even know what happened with that. But he is now claiming, according to Bama, he's claimed his Fifth Amendment right to remain silent. So he's not going to testify in her trial. Now, I'm going to read to you guys what we have closings coming up here. I mean, I've got the closing for, what's her name? The defense. I've got that video dropped already. Okay, Fox just did it. Okay, they just uploaded it. Okay, guys, here we go. This is 3 hours long, actually. All right, good. I'm so glad. I was worried I was going to have to explain it all.
session. Judge Daniel White now presiding.
People of the state of Michigan versus Marshella Chidester.
We ready to proceed?
Yes, Your Honor.
All right, bring in the jury.
Judge, hang on, sorry. Well, we talked about this in chambers already. We got to put this on the record, Judge. People object to defendant's expert witness being called. We were not providing proper notice under the court's orders, nor does it comply with the court rule. We're providing no notice, no written summary, which is required under 6.201. 6.201J allows the court to prohibit the testimony, and the court in People v. Butler upheld that as an appropriate remedy. We have no idea what this gentleman is going to testify to. He may tell us the earth is flat, and therefore our machines are calibrated improperly.
Judge, if I may reply, is we were informed that we needed one until we found out very late that our expert that we had retained, Dr. Rose, MD, would not be able to testify because the court's regular procedure is that it can't be by videotape, live by videotape, by Zoom or otherwise from where he's at. And as you're well aware, I filed a motion, and as you're well aware, in the motion, it sets forth that he suffers from a very serious
Argument to the court.
very serious issue. And the court's well aware of it. I'm not going to duplicate everything on the record or be repetitious. And that he can't fly. He was not able to drive. He's in his mid to late 70s. And you could have a blood clot in his brain.
Okay, we know all that.
Okay, all right, Judge. So knowing that, and then plus, I did not receive any records concerning the toxicology until February 10th. Okay, so they didn't timely under Brady give me records. So then I received. So then we had to scale. We had to run and get another expert to review everything. Tell me over the phone what he thought of it and anything that's beneficial.
Let me ask you, is there a report?
There is no report. He did not do a report.
All right.
And experts do not have to do reports. And he's not going to be relying on a report, or else, as I informed the court last Friday, I believe, that as soon as we get a report, we would immediately email.
Okay. Here's the thing. The notice was given. It was late. Lots of things have been late in this case. But I do think it was unusual circumstances. The original expert witness was not available or couldn't appear for whatever reason. Notice was given. There's no report. You wouldn't necessarily know what he's going to say anyway unless there was a report. And of course, I would have ordered that. If there was a report, I would adjourn the matter so that you could review it. You had to review it with your witnesses, but there's no report. So I'm going to overrule your objection, and we'll bring in the jury.
Last thing, Judge, just for the record, our expert is in the courtroom for this testimony.
I have no objection to that, Your Honor.
Okay, thank you.
I think you have one matter put on the record just to make it part of the record and take them a minute. Thank you, Judge. We're talking chambers about this, and that is Dr. Gard, MD, is the treating physician. Ram Gard, it's G-A-R-G. He's out of Bloomfield, treating physician out of Taylor, Michigan. He currently, as the court's aware by motion, he has 35 counts against him for holding a criminal enterprise and prescriptions unlawfully given. That's out of Wayne County Circuit Court, Judge McCarthy. That's a trial date of June 2nd of this year. I had asked for an adjournment of court tonight. Michigan Court of Appeals supported this court and said that there was no need because there's no emergency, which I don't get. But so then anyway, we tried to serve him as her treating physician. And we've tried to serve him with the West Bloomfield Police Department where he resides. Last note, all the furniture is pretty much missing out of the house. They tried several times, the police department and a process server. Then I did as an officer of the court, represent that I did a mail trace. There is no change of address, so somebody's picking up his mail. So we attempted all of that. Lastly, Judge, as a desperate means, is I had served professionally attorney Prasad, P-R-A-S-A-D, who's listed in Wayne County as his attorney at 4190 Telegraph Suite 3000 Bloomfield Hills yesterday at 10:09 a.m. in person to say in company of and to
get Dr. Ramgard here at 9 a.m. this morning. I don't see Dr. Ramgard. I called his name, I looked for him. There's a picture I have of him, and he's not here. I've not heard from the attorney.
Okay.
So
You
I
made a record.
wanted to make the record, Judge.
Okay.
Thank you very much.
All right.
Very quickly, Judge, I know this is driving you nuts.
Yes.
Mr. Columbus accused us 5 minutes ago of a Brady violation. I want to make a record that there is no Brady violation here. The documents he received from the lab were received by him on February 10th. His demand for discovery was filed February 3rd, received by us February 4th, well in compliance with the court rules. I just want to make a record.
All right. The record is clear.
Just very quickly, is Brady says you don't have to make a demand. If you've got any evidence at all, you got to turn that.
All right. We've made a record. Let's bring him.
Cut him off again. Yeah, he is going to bring somebody in. He's going to call an expert witness here. Forensic. Wait, and then he recalls. I think another.
May I approach the podium here?
He brings up somebody again with the toxicology.
Who's in the back?
For those of you just coming in, she's charged with 2 counts of second-degree red rum, 2 counts of operating while intoxicated, causing death, and 4 counts of operating while intoxicated, causing serious injury. It occurred on April 20th of 2024. 2 small children were unalived, and 15 others were injured.
Good morning. You may be seated. I know that you guys were all on time. We have not been on time. I apologize for that. Sometimes things are outside our control, but we're ready to go now. Your next witness, Mr. Close.
Thank you, Your Honor. May I go get my witness, please? Thank you very much.
He does take forever to get one thing out. The judge is getting, at least the judge is cutting him off and not letting him ramble, you know? Yeah, right now they're at lunch. When they come back, I don't know if they're going to be discussing jury instructions or not. I don't know if we haven't, see the way they've put this out to the public is they've cut it in pieces. They've left out a lot of the meetings that they've had outside of the jury. So we're kind of trying to catch up as they throw it on, the media puts it on their sites. Let me see, according to what Fox says, let me go up.
Sir, would you stand right here while you're sworn in?
Yeah, they're going to get to do the instructions.
The testimony you're about to give in this matter before the court shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do. Sir.
Let me finish what I was saying real quick before I play again. So it says on Fox's website that at 12:20 p.m. the court broke for lunch. The jurors are due back at 1:30 p.m. for instructions before deliberations begin. So they may have already gone through the attorneys and the judge putting up the jury instructions. So it's just going to be them being read to the jurors.
Would you state your name and spell your last name for us, please?
First name Okori, Okorie. Last name Okorocha, Okorocha.
Thank you.
This is off. Sir, how are you currently employed?
I'm a forensic toxicologist.
Okay. Can you give, by way of background to the jury, your education, formal education?
I have a bachelor's degree in biology. I have a law degree. I have a master's of science in pharmaceutical sciences with a specialization in forensic science. And I have a second master's degree in forensic toxicology.
And
you currently, what does your job encompass currently? What do you do?
The forensic toxicologist reviews the data produced by analytical instruments. In my case, it revolves around blood, breath, hair, saliva, urine testing.
And how long have you been doing that?
18 years.
And did you ever give expert testimony in a courtroom?
Yes.
Approximately how many times have you provided expert testimony?
Over 700 times in 55 of the 58 California counties, 25 times in 25 different US states, and in Germany and Japan.
And were you qualified as an expert in those locations?
Yes.
And did you ever give testimony and qualified as an expert concerning any U.S. military service personnel?
Yes, in Germany and Japan.
And in what setting would have that been?
Court martials.
And what were the allegations?
One of them was that the soldier was impaired while off duty, and his foot was taken off by a train. So in order to get his benefits, we needed to establish that he wasn't in fact impaired. The second one was the Navy one in Japan. That was a breath alcohol test.
And were you qualified as an expert in those cases?
Yes.
Have you been qualified in blood testing in labs and hospitals to give testimony?
Many times.
In breath testing?
Yes.
In the breath testing involving alcohol?
Correct.
In chemical analysis of blood, have you been declared an expert in that area?
Yes, correct.
Approximately how many times as a chemical analysis of blood have you been qualified in a court as an expert?
I would say over 400.
When it concerns the issue of driving impairment, have you been qualified in courts on that issue?
Yes, I have.
And approximately how many times?
Several hundred.
Have you been qualified in federal court ever?
Oh, yes.
And drug use and effects, have you been qualified in that area in courts?
Yes, prescription drugs, drugs of abuse, over-the-counter drugs, drug interactions.
With regard to field sobriety tests and chemicals that may affect sobriety tests or dexterity tests, have you been qualified in that area that you've given testimony?
Yes, and I have formal education in field sobriety tests.
How long ago would have that been?
2014 or so.
And do you do updates on that?
Yes, I teach the
You
course.
teach it?
Yes.
So you teach courses in forensic and related areas?
Yes, and in field sobriety tests, blood testing, breath testing.
In what setting do you teach?
For the State Bar of California, I also teach for various criminal defense organizations.
When you say the State Bar of California, would that be that people attend that are defense attorneys and prosecutors?
And judges.
And judges?
Yes.
And have you been declared an expert in forensic toxicology?
Yes.
And that's in different courts in the United States?
Correct.
And in Germany and Japan, correct?
Correct.
And general technology, toxicology, you've been declared an expert, found to be an expert by a U.S. court?
Yes. General toxicology is usually, it's 50 or so times. That's things that are contaminating the water or poisons and such.
Hair testing you've done?
Correct.
Right. Pharmacology, you've been declared and been declared an expert in those fields in U.S. courts?
Correct.
And the issue of impairment by drugs or alcohol, have you been declared a expert regarding toxicology of that?
Correct. Drugs, alcohol, or alcohol and drug interactions.
And you've given expert testimony in the case of Derek Rose.
Yes, MBA.
Who is that? Derek? I'm not a sports person. Who's Derek Rose?
He was the former NBA MVP.
And did you give ever any testimony as an expert in the George Floyd case?
No, I was a consultant on the case. The civil case, which I was working on, settled prior to the trial or testimony.
And as a consultant, were you asked for your expert testimony or expert advice?
Yes, and I relayed to the attorney what the attorney needed to know.
And then the last case is, it deals, it's captioned Hawaii versus Denise Dixie Villa, V-I-L-L-A. What was that case?
That was a baby manslaughter case involving Benadryl.
And were you qualified as an expert for the court there?
Yes.
I'm looking at your curriculum vitae, fancy word for resume, and it says you're testified in over 850 jury trials. Is that correct?
Correct.
In 55 different California counties,
Yes.
24 United States federal courts.
I think he said all that.
Okay. Did you say 24 U.S. courts?
I think he said 25. 25 other states.
Thank you, Judge. And you received a Master of Science in Pharmaceutical Science, specializing in forensic science from the University of Florida in 2012.
Correct.
I would like to have my witness as an expert.
Judge, can we go out here?
Yes, you may.
Thank you. Mr. Okorocha?
Yes, sir.
All right. Sorry if I get that wrong. You said you have a bachelor's in biology.
Correct.
Where did you obtain that degree?
California State, Northridge,
When would that have been?
99.
And so after you graduated in 1999, did you go right to graduate school
I went to law school, if that.
immediately? When did you start law school?
Yes, it was the fall following graduation.
So that would have been 1999.
Yes,
And when did you graduate law school?
2002.
When did you go to get your master's?
2010.
What did you do from 2002 to 2010?
I worked for the federal government, U.S. Department of Health and Human Services as a civil rights investigator, and then I worked as an attorney.
You worked as an attorney? You worked as a defense attorney?
Yes, for 3 of the 22 years I've been licensed.
Specializing in drunk driving cases, I assume?
For the 3 of the 22 years, I focused on that.
Where was that law school located?
It was in Costa Mesa, California, Orange County.
And where did you go to get your master's?
University of Florida.
So undergrad and law school in California, master's is in Florida.
Yes.
How long did you live in Florida?
I didn't live in Florida. You can do a lot of the work remotely. You take the exams and certain classes in person.
So you got your degree from an online university?
I wouldn't call it online because you're mostly doing research, but yes, it's remote.
Were you in class in person
Yes, for some of the classes.
for all of the classes?
No,
Okay. How did you do labs from California to Florida?
sorry.
How did you do your lab requirements? How did you meet lab requirements if you were living in California and your classes were in Florida?
The forensic toxicology, forensic toxicological analysis is not lab technician work. It's the analysis of the data. The laboratory technician work is simply filling up vials, putting them in a carousel and pressing a button.
Something tells me most chemists would object to that assessment, but I'll move on. The undergrad, how much lab work did you get?
General chemistry, organic chemistry, physics, microbiology, plant biology. There's more. I'm just not.
Do you work in a lab now?
I work for a lab. I'm not a technician, so I don't fill up the vials, but I analyze the data for a laboratory.
What lab do you work for?
AK&A Labs.
Is that, does that lab comply with the International Organization of Standards regulations?
I'm not in charge of compliance. A lot of what I do is also reviewing things from other labs for our lab, but I don't know.
Have you ever tested blood on a gas chromatograph?
I've tested over 10,000 samples.
When did you do this?
I've worked for various labs since 2000, from 2011 up until COVID.
Do you conduct testing still?
Only if I'm covering for somebody. I'm not a technician.
Are you a certified forensic alcohol analyst?
I'm not sure what that is.
Take that as a no. Your most recent professional experience then would be from prior to COVID?
Well, my lab technician work would be prior to COVID. My most recent professional experience would be this week.
Are you a licensed toxicologist?
There are no licenses for toxicologists, at least that I'm aware of.
Is your lab that you work with accredited by anyone?
I don't know the accreditation process. We have labs we send things out to that are accredited for other things. I'm not sure what the labs are accredited for.
What did you review in preparation for today?
It's really more cross than it is voir dire.
Okay, I'll move on.
Hang on a second.
Have you ever testified in the state of Michigan before?
No.
What protocols govern blood collection and testing in Michigan?
I did not review the blood protocols. I reviewed the analytical chemistry data.
So you don't know what rules or policies are used and implemented in this state. Do you know who implements these policies?
No, the policies aren't relevant to what I'm analyzing.
All right. And Judge, the people object. I don't think he's qualified to testify in the state of Michigan. He doesn't even know what governs collection or testing of blood.
All right, well, the court does determine that this witness has been qualified as an expert witness over 700 times in 25 different states, in Japan and in Germany. Has a significant education, also has a significant practical experience. Accordingly, the court does qualify this witness as an expert in forensic toxicology.
Thank you, Your Honor. May I proceed?
Yes.
Thank you. Your sir, could you, again, just say your name?
Okori Okorocha.
Okay, all right. And you reside where?
El Segundo, California. It's by Torrance, south of LA.
And you received certain records that were sent to you, is that correct, concerning this case?
Correct.
And they were more of toxicology type records and things like that, right?
Correct. Laboratory records.
All right. And you're not, a lab tech is somebody that stores, let's say, blood or accepts blood from the police department and then stores it. Is that correct?
Correct, stores it and then tests it, no.
Okay, all right, that's a lab tech. All right. It's sort of a simple procedure. It's more simple, correct?
Yes, we have lab techs that don't have any college education, for example.
All right. And you had opportunity, your job or being an expert when you've testified is to interpret the results after they've been obtained through testing devices. Would that be a fair statement?
Correct.
And that's where all of your expertise surrounds, not drawing blood or storing it, but analytical.
Correct. I am familiar with the procedures for mixing the blood once it's collected and what you're supposed to do with it once it's collected.
Okay. Well, whether it's a blood draw and placed in a vial in California or in Michigan, does it change fermentation or anything? Or it's the same blood, a true?
Objection, Your Honor, this is a leading question.
Well, I got to ask the question.
Well, the question is whether it's a leading question. Why don't you just try to?
Okay, all right. When you give testimony, prior to giving testimony, do you look at the toxicology reports?
Yes, and the laboratory data supporting whatever reports were generated.
Do you just look at the one page that says this is the result and that's it?
No, anyone with Microsoft Word could generate that. It's the data that supports it.
And can you inform the jury what data you looked at prior to coming to a conclusion concerning this case and this blood type?
There are various lab worksheets and then various graphs. The actual blood sample is depicted on what's called a chromatogram, which is a visual depiction of what was found in the blood.
And we did go through this with state of Michigan people that testified yesterday. But I want to ask you, just to see if we're sort of on the same page of what they said. And that is, when blood is extracted from an individual and it's put in a tube, let's say state police or government, or you want to, preserve it or save it for testing in the future, is there a preservative that's usually mixed with it?
Yes, and nationwide, everybody uses the same tubes, the BD or Becton Dickinson, and they are supposed to be gray top tubes with preservative and anticoagulant.
Okay, and that's a private company that does that, correct?
Correct.
And it's all the same? In other words, throughout the states?
Yes.
So they have the contract with all the states as far as you know?
Apparently so, or they're the only ones that make that kind of tube. I don't know.
Okay, and that would be Michigan and California both?
Yes, or any other state.
Okay, and I don't know toxicology inside out. I didn't study it. And the jury and the judge, can you please explain what would be in this tube and what purpose does it serve?
So the potassium oxalate would act as an anticoagulant because when the blood, if it clots, the alcohol follows the water portion of the blood and not the red blood cells. So if it clots, you get a higher concentration. So you want to fend that off. Secondly, it would have sodium fluoride, which is intended to inhibit microbes such as bacteria or fungi from converting blood sugars and other substrates into alcohol. But it's an imperfect process.
Okay. And when the tube is opened prior to putting the blood in,
Oh, it isn't opened, the needles.
if the needle goes in,
Mhm.
the needle is in the air, in the tube, then the needle goes into this tube with a protection on it, and then blood is put in the vial, correct?
Correct. And typically for forensic purposes, you would want to wipe the top of the blood tube you're putting it in.
So you're not putting something that can be contaminated right into the blood. What would be the reason of why what would be the reason why you wipe it?
Because it's easy to insert microbes such as bacteria and fungi into the sample, and it doesn't take a lot of bacteria or fungi to be able to alter the sample.
I presume from what you're describing, it's very, very sensitive, and you have to be very careful.
Yes, all biological samples change immediately coming out of the body. So it's just like when you buy milk at the store, you get the one with the furthest expiration date. It's stored properly, but you know it changes.
And how should, if the blood is put in like you described into this, is it 2 vials or 1?
Most jurisdictions collect 2 vials just in case there's a problem with one, because it's an imperfect process.
Okay. And once that happens, the person that draws the blood, what is supposed to be done with the tube? Just put right in the box or what?
No, the tube is supposed to be inverted approximately 8 to 11 times. So if this pen is the tube, you're going to turn it.
Record reflect that the witness is holding on to a pen that's about 8 inches long.
Yeah.
Thank you.
So you would take the tube, you would turn it completely upside down and then bring it back. And you're going to repeat that process 8 to 11 times.
Okay. I'm going to show you a pen, record reflect that I'm holding a pen maybe 8 inches long between my 2 fingers. And I'm going to just wiggle it back and forth and not actually turn it upside down 8 to 11 times. If I wiggled it once or twice, would that be enough to do a proper mixture of this chemical balance at the bottom of the tube?
No, not per the manufacturer guidelines. And the manufacturers have an interest in having the most robust tubes they can have. And even they say you need to go through that procedure.
And if a person does not mix it, for lack of a better word, mix it properly, this 10 or 11 or 8 or 10 times, what could happen?
The anticoagulant could not properly mix in the blood sample. And so you can have coagulation or the red blood cells clumping together, or if the preservative is not mixed all the way through, you can have fermentation, microbes converting sugar, blood glucose and other substrates into alcohol.
And what happens when fermentation? Do you want fermentation to happen in a sample?
No, you usually do everything to prevent it.
And what's the reason why?
Well, the fermentation, you're converting blood contents that are not alcohol, such as glucose, and you're converting them into alcohol. So not only are you losing blood volume, you're increasing alcohol, which can make the blood alcohol level go up significantly.
And if it's tested after that, would the test be reliable?
No.
Measurement of alcohol in blood?
No, fermented blood would not be reliable for blood alcohol concentration.
Is there an analogy with regard to preservative or milk or anything like that? We talked for a minute today.
The preservative is imperfect, and depending on what microbes are present, there can be significant changes, but there are always going to be changes. That's why you draw it, you put it in a refrigerator freezer, because that slows down whatever biological processes are going on, and you mix it to try to control it, and then you want to test it as soon as possible.
And what does the state testified that at times the refrigerator, there's a walk-in refrigerator that samples are put in. Why is there a refrigerator? Why is there refrigeration?
Because biological processes happen a lot slower when you're in a refrigerator freezer, as opposed to heat. Heat speeds up the chemical reactions.
Would that cause a fermentation at all to speed up?
Yes, it would cause any
And,
biological process to speed up.
and fermentation, what would that do to a sample, the accuracy of the blood alcohol level?
It would make it, it could make it go up significantly. In one study, they found that it would go up to a 0.10 in 1 day or 24 hours.
And if the fermentation is not shaken or inverted several times, would that also affect and cause to go up much higher?
It makes it far more likely.
So if the preservative, let's just say, is not mixed properly and it's not refrigerated or kept cold, you're really going to have an inaccurate result. Would you agree?
That potential is a lot higher.
And you don't want that normally, right?
Correct.
You want people to follow the test so you have an accurate result, correct?
Correct. Proper procedures.
And these procedures are not only for California or Michigan, am I correct?
Correct. There's nationwide standards, national standards from the U.S. Department of Health and Human Services, the Society of Forensic Toxicologists, and the American Academy of Forensic Sciences.
And are you aware of all of that? Are you aware of all that standards?
I know them pretty well. They're a couple, over probably 200 pages. So I don't know every single detail, and they go into very specific areas that I don't necessarily deal with.
There'll be no test today on that.
Okay.
Do you use that in your practice of analyzing data?
Yes.
And after having an opportunity to review the data that was supplied to you, supplied from the prosecutor, how many pages was it?
Over 300 pages total.
Okay. And did you, was there anything unusual when you looked at the data and you were analyzing these pages of results or raw data?
Yes.
What are you looking for to see? What would you look for in the data to make sure that the proper testing was done, or maybe it wasn't done?
Various things. In this particular case, I noted that there were other compounds in the blood sample that would not be there without fermentation.
And what would be the name of those compounds?
I'd have to look. The most significant one was acetone, which would be nail polish remover.
I know. Not that nail polish remover was put in there, but is that something that's put in nail polish remover?
Yes, that's what nail polish remover is. The blood sample would have tiny amounts of these volatile organic compounds, such as acetone, and the amount of alcohol produced when even you have a tiny amount of acetone can be 10,000 times as much.
And does somebody that wants an accurate result from blood testing toxicology, wants an accurate result, would they want acetone being found in their sample?
No, you would want to throw out the testing because acetone's not found in human blood.
Well, there was some testimony yesterday that you can have a little bit of acetone in the sample and it's okay.
I would strongly disagree.
Have you ever been told that it's okay to have some acetone in a blood sample and it's accurate 100%?
No, and there were other volatile organic compounds in there as well.
Where would those compounds originate that you saw? How would they originate? From what?
In a blood sample, the only way you would find them is fermentation, unless somebody put those, ran all those things in the instrument and there was a lot of contamination or something.
Unless somebody intentionally put them in, it happens through fermentation. Is that what I understand?
Yes,
And fermentation could occur non-refrigerating the sample prior to testing. The chemical compound inside the test tube is not shaken properly.
or it can happen even with refrigeration.
Okay. And if it's not refrigerated, would that be like an expiration date on milk, but you leave it outside and it tastes sour prior to?
Yes, correct. It would speed up the expiration of the milk.
So even though the expiration says, April 1st, if you left it outside in the sun prior to, expiration doesn't matter what it says, right?
Correct. All those biological processes happen a lot faster.
After analyzing the data that was supplied to you from the state toxicology department, do you think that the result that is allegedly obtained as 0.18 of that blood level, that's truly accurate?
No, because there were several volatile organic compounds present in the sample.
And all of that combines to not giving you an honest and accurate sample.
It gives you a result that is not the same as it was when the blood was drawn.
Do you know if the second sample of the vial of blood, there were two? There's
Yes.
two, right? And that's what was testified to yesterday. There's two.
It was run twice. I don't know which vial it came from, but it was run on two different, what are called columns.
Do you know if the second vial, if it was ran on that, does it show any testing on that? In the records you've looked at, the second vial?
I don't know about the vials.
Okay.
I just remember the columns, and it was
Okay.
run on both columns.
That's what I was gearing the question to, that if there's two, which there was testimony of, and tests are done on one, do you know if the second test tube or vial was tested at all from looking at the reports?
Yes, there were two tests.
So each one was tested,
Correct.
or at least it looks like that?
Correct.
Okay,
Or at least two columns.
okay. And there could be two columns in one test, correct?
There usually is two at a minimum.
And then it was described to us yesterday by a toxicologist from the state that the process is, what you said earlier, you push a button, you put the blood sample in, you push a button, and then it just operates on its own, correct?
Correct. It's completely automated. So most people would usually run it overnight so that you don't have lab personnel checking Facebook or sitting around.
And that's exactly the testimony was, that it's ran overnight and it's approximately 7 hours. Does that sound right?
Yes.
And the toxicologists, when they're running this test, they don't have any personal involvement, or they're not touching the blood or the sample or anything. It goes into a machine to keep it as clean and impartial as possible, right?
Yes, and it's all automated.
And if somebody's at a hospital, in your opinion, professional opinion, if somebody's at a hospital would it be more accurate testing to take their blood there and have the hospital test it than to get it, shake it, it might ferment, refrigerate, not refrigerate, wait 2-3 days, and then have it tested? Would it be better just to have the hospital more accuracy, take a blood sample right then and there?
Objection, Judge, this is a leading question.
No, it's leading, Your Honor, but I'm asking him his opinion.
I'll allow the question.
Thank you.
The hospitals have their own inaccuracies just because it's done very quickly. They can't wait 7 hours necessarily for, get test results back because the person could be.
So, but you wouldn't have the fermentation taking place, is that correct?
Correct. And you always want to test it as soon as possible, regardless of where you get it from.
So would it be more accurate to if the hospital do it than let something ferment?
All things being equal, yes.
Your resume, I've had marked as Exhibit 1, and I believe I'm going to move for it to be admitted, but I believe it's stipulated to already.
Defendant 1 is admitted.
The CV, thank you. Is that true and accurate as to your?
It's admitted.
Okay, thank you, Judge.
Could you give it to my clerk, please?
And after reviewing all,
Yeah, I'm gonna, for the record, any defense exhibits should be letters. This is defendant's A is admitted.
are you marking it, Judge? Would you like me to?
I'm changing.
All right, thank you, Judge.
Thanks.
And in your professional opinion of all your years, of all your testing that you've done, of all the cases of, I don't know, 1,000 cases altogether, and all the forensics you've done, in your opinion, toxicology-wise, your professional opinion, are these with the acetone that developed a true and accurate result of the blood test?
No, and there were also other volatile organic compounds. And if we put the chromatograms up, I can point out the issue.
Okay, do you have that at all in your laptop or anything like that?
I have them electronically in my iPad.
Your Honor, may he look at his records, please, to refresh his memory?
If that'll refresh your memory, sir.
Yes, Your Honor.
Thank you, Judge.
Oh, okay. This is like somebody that's never built a house telling you how to build the house. Does that make sense?
Okay.
He's like, no, but I've got it all here on paper, and I know exactly how it's done on paper, so I know exactly how to do it in person. Is that a good analogy? No, I'm not wrong.
Okay.
Thank you. Are you prepared now to go forward, sir?
Yes.
Okay, what are other different compounds that shows in their testing?
There is acetone and isopropanol.
Okay, that's the one I had problems pronouncing yesterday, the second one. Not that it's relevant, but tell the jury about those compounds. Are those normally in your blood?
No, you wouldn't have volatile organic compounds in human blood. Alcohol is a volatile organic compound, but the only reason you have it is if somebody consumes alcohol. But normal human blood wouldn't have acetone and isopropanol.
And if normally you would have, because somebody consumed alcohol, how does the fermentation affect that, or other compounds, or acetone?
Well, the fermentation greatly increases the alcohol level that you have present. It can make it drastically higher, or it can make alcohol where there's no alcohol So they take blood samples and they see if they ferment, and, you know, the blood alcohol levels can go from 0 to a 0.10 in one day.
And if there's all these other chemicals, could it go up higher?
Well, the other chemicals are just telltale signs that fermentation occurred, because fermentation is sort of involves the byproducts of fermentation. So you'll see those sort of things.
But you're absolutely positive before this jury that those results are not accurate according to your opinion, professional opinion, and according to the records you viewed from the state. The 0.18 would not be accurate.
Correct. It would not be accurate for the time of the time the blood was taken.
Okay. And and there's no way of knowing what would be an accurate amount if these samples were polluted or fermented.
There's no way to determine how much fermentation occurred. If you have some volatile organic compounds, you know it was far greater than the amount of volatile organic compounds, but you can't place a number on the increase, or if it went from 0 to whatever number you have, or it went from a lower number to a higher number.
And if somebody had a regular, I don't know, 6 ounce or whatever it is, glass of wine between 11 and 12 or 11 and 12:15, and a blood sample was taken, let's say 3 hours later, or 6 hours later, would it be accurate as what's being tested because acetone is in there, or fermentation may or may not be occurring?
If there's acetone present and other volatile organic compounds, that's evidence that fermentation occurred.
And it's just not good. You said, like, I don't know, drinking nail polish or heavy nail polish.
Correct. Nail polish remover.
Nail polish remover. And it's very, very strong. Am I correct? Alcohol base.
Sorry, what is?
It shows an alcohol base when you're testing, when you have this acetone.
Correct. There's a significant amount of 10,000 times as much alcohol created as the acetone.
Now, can you go back and prior to testing, take acetone out of the sample?
No.
Once it's in there, it's in there?
Correct. Taking it out wouldn't do anything to the alcohol produced.
Okay, so once the alcohol's there, it's there even if you could extract the acetone, its damage is done, so to speak.
Correct, because the acetone is part of the process in fermentation.
And, have you, I looked at your resume, or when I was speaking of it in front of the jury, qualifying you, is you've also been involved in breathalyzers, or, formerly data masters and things like that, that at the station, somebody blows into a tube and then it registers 1 or 2 amounts that may be of alcohol level. Am I correct?
Correct.
Okay. There was, that wasn't done in this case. Are you aware of that?
Yes.
Okay. Would it have been a good idea to have done that?
The more data points you have, the better understanding you have of your test results.
And if there was fermentation or any pollution of these samples, sounds like common sense that you'd have the breathalyzer at the station, those results, right? If everything was working good.
Right. Those would not be prone to the fermentation errors.
Not at all, correct?
Correct.
Okay. I don't have any other questions, Your Honor.
Cross. Thank you, Judge. Mr. Okarocha, does acetone ever occur naturally in the human body?
If it does. I'm unaware of it, and the body has to get rid of it very quickly because it's toxic.
At what level is it toxic?
I don't know offhand. It would vary for each person.
You said you reviewed the lab reports and the data points from the GC.
Yes.
What else did you review in preparation for today?
There were various laboratory documents such as worksheets and chromatograms indicating the acetone. There were controls, calibrators, calibration curves, reference samples.
Did you review the police reports?
I received them, I think. I don't think I reviewed them. I was only working on the toxicology part.
Did you review the body camera footage of the blood draw?
No.
You cited a study where the blood alcohol level went up 0.10 in 24 hours. What study is that?
It was by Bloom, Blume, and Lakatua, Lakatua.
Did you bring that with you today?
I have it electronically.
You have it electronically. Can you provide a copy to us?
Electronically.
Okay. What other publications have you relied on in preparing for your testimony today?
I guess the Becton Dickinson manufacturer guidelines. But the things I'm talking about are they're sort of common knowledge. There wouldn't be an authority on them.
This practice is accepted not only in the state of Michigan, the way the blood is drawn, the way it is transported, but throughout the country. You testified, correct?
There are national standards.
So, but the gray tops are standard throughout the country. Everybody uses them.
Correct.
Okay. And the testing is standardized throughout the country. It's done the same way here as it is in California.
No, not always. Here we are using a dual column instrument. The modern, more reliable instrument would be a GCMS, as in mass spectrometry.
What states employ GCMS?
Several counties in California. GCMS for alcohol is not as common as it is for drugs. I'm not sure offhand.
Are you familiar with the Michigan police guidelines for how many times the blood is supposed to be inverted in the tubes?
No.
No. What is, you stated that estrogen does not occur naturally in the blood. What do you base that opinion on?
Well, the laboratory runs known samples of various compounds, including acetone, because they're running known byproducts of fermentation, because you need to run them to see if they're present. So if you're running them to see if they're present, you're doing that so that you can figure out if there's fermentation or not.
How often does fermentation occur?
It would depend drastically on conditions and, the temperature, the delay between testing between the draw and testing.
When does fermentation stop?
Usually when the microbes run out of substrates that they can convert to alcohol.
So you tested the blood here to confirm that it was higher than 0.18 that it kept fermented, correct?
No.
You stated that you don't believe at the time of the draw her blood alcohol was 0.18. What do you believe it was?
We can't determine the amount of error associated with fermentation based on the byproducts.
Was her blood alcohol higher than a 0.18?
Not with fermentation, no. It would have to be lower at the time of the draw.
Do you want me to take a break, Judge?
No,
Okay.
go ahead.
Is it, so it's your opinion that her blood alcohol level was lower at the time of the draw?
You know, I'm gonna object, he said he doesn't know this fermentation takes place, it's speculative. You know, what was her blood alcohol level? First of all, it's presumed something that, you know, it makes no sense, you can't speculate that there's fermentation. He said it can occur with no alcohol in your system, it's heartburn.
Judge, he's testified that he believes fermentation occurred. I'm trying to establish whether or not he believes the result is accurate. Was it 0.18 at the time of the draw, or was it lower at the point of the draw?
I think it's a fair question, I'll allow the question, the objection.
It would be significantly higher at the time the blood was collected. I'm sorry, at the time of the testing than when the blood was collected.
So her blood alcohol increased from the time of the draw to the time of the testing.
That's what fermentation does.
And what causes this rising alcohol to occur again?
The microbes, bacteria, and fungi. Often it is a microbe called Candida albicans, which the preservative does not slow down. And the thing that's called a preservative can actually speed up fermentation with Candida albicans.
Does the Michigan State Police procedure require refrigeration of collected samples?
I saw something about refrigeration. I don't recall it well enough to give an answer.
Do you know how much defendant had to drink on that day?
I read something.
Your Honor, I didn't hear the question. Repeat the question, please.
Do you know how much the defendant had to drink on the day in question?
No, I wasn't there. I read something in the report. It might have been 1 or 2 glasses of wine.
But you weren't present?
No.
No. So you don't have any idea if she had 1 glass of wine or 40 glasses of wine, correct?
Well, with the testing, I wouldn't say 40, but I don't know how much.
So with the testing, how much do you think she had then?
Objection, Your Honor, he said the testing fermentation took place, you can't guess and be speculative. What do you think she had? What do you think I had?
Judge, he said with the testing, I wouldn't assume 40, so maybe he's got an answer to this.
He's also an expert witness who can give his opinion. If he can't base his opinion on what's been presented, then he'll say something.
Okay. 40 drinks would be, even with hard alcohol, I doubt somebody's belly could hold that much.
I understand. How much do you believe she had to drink based on the testing results that you've looked at?
I cannot tell because of the unreliability of the testing.
The state of Michigan test blood like this every day, multiple samples a day. It's your opinion that some percentage of those ferment every day?
I don't know what percentage. I can say in this case it fermented.
And that's because acetone doesn't occur naturally in the human body.
Neither does isopropanol.
1 second, please.
I've pulled up his website. We're going to look at it in a minute.
The whole purpose of the testing in toxicology, in the blood testing, is for accuracy, correct?
Correct. Forensic testing, you want to get it as accurate as possible.
And from all your studies and all the cases you've worked on and all the cases you've testified in, are samples of blood supposed to be refrigerated?
They're supposed to immediately be put in a refrigerator freezer per the national standards and tested as soon as possible.
And the national standards go with the uniform testing kit, right? That applies. The uniform testing kit that company has a monopoly on.
Yes, the tubes.
And because somebody violates that or a county violates that, that doesn't make it right. Is that correct? There's national standards.
Correct.
And how many times, and does that also then apply to how many times a tube should be inverted? You had said how many times?
8 to 11.
That's to make sure that all that powder that's stuck on the bottom is dissolved.
Is mixed in with the sample.
And is it the national standards to do it this 8 or more times?
I don't know if the national standard states the amount of times or to follow the manufacturer guidelines. I don't remember that specifically.
And what's the manufacturer guidelines?
The 8 to 11 times.
And do it less than that, you may not have accurate results.
Yes, per the manufacturer.
And that's because fermentation could take place.
Yes, and it can take place without, without the preservative, with the preservative.
Thank you. I don't have any further questions.
Recross.
May I approach the witness?
Yes.
I'm going to show you what is the FSD 093. This is the Michigan State Police instruction form for drawing blood. Your Honor, may I take a look at what you're showing on the
Sure.
Thank you.
Excuse me. Your Honor, I'll object because this has never been, I've never even seen something like this where I found it, and nobody's testified to it. I don't know if it's old, new, what this piece of paper is.
It came in with your witness.
Judge reviews it in the trial already.
Yes, and there's been testimony regarding it already. I was going to ask you if it's an exhibit because.
We have not admitted it as exhibit, but perhaps we will.
Yeah, all right. The objection's overruled. It's clearly been testified.
Excuse me. Can you take a look at that, please? Tell me if you recognize that document.
You want me to read the back of it?
I just want you to take a look at it and tell me if you recognize it. Have you seen it before?
No.
And Your Honor, also objection, because he's already had his opportunity to ask him questions and cross, now he's going into another tangent.
You were asking about the standards. I think it's a legitimate question. The objection's overruled.
Your Honor, help, stop. Don't let him do this, Your Honor. Good Lord. Yeah, I object because this ruins my case. No, Plan B was the seizure. I mean, Plan A was the seizure, Cassandra. Plan B is this toxicology guy. Yeah.
Okay.
You have not seen that document before, correct?
Correct.
Okay. In the state of Michigan, we talked about actually, hold on to that for 1 second.
Okay.
If you would. The Michigan State Police has policies and procedures associated with blood draws in the state of Michigan, but you're not familiar with those policies and procedures, correct?
This is the Michigan State
That is
Police.
not it. This is a question aside from that document.
Oh, okay.
Are you familiar with the Michigan State policies and procedures that govern drawing and testing of blood?
Not in particular, but they're pretty standardized.
The state of Michigan, through the Michigan State Police, creates blood draw kits. We've used it in court already. This is the kit. And every kit is that form. Can you tell me what number 3 on the back of that form says, please?
Slowly invert blood collection tubes enough times to distribute the sodium fluoride, potassium oxalate preservative.
Enough times? Is that what it says, or does it say 8 to 11 times?
Says enough times.
Okay. It's your opinion that the Michigan State Police policy and procedure is wrong.
No, I'm saying the manufacturer tells you what enough times is.
Judge, the people are going to move for admission of People's Proposed Exhibit 39. That is the FSD 093 form that has been referenced a number of times throughout the case. Response.
Sure, I'll stipulate to that. I don't agree that that's proper, but I'll stipulate to that exhibit, but it doesn't meet the national standards, according to my time.
People's 39 is admitted.
And how much were you paid to testify today?
I was paid a retainer of $5,000 and then I had expenses.
And what were those?
Get the calculator out.
Approximately 1,200 total.
So all told, about $6,200?
No, I didn't get anything other than the $5,000 retainer.
Oh, he didn't
No
get
further
paid. He ain't got paid yet.
Redirect.
Thank you, Judge.
Did you get a receipt?
That piece of paper that shows you, is that from the national, or excuse me, is that from the manufacturer of, is that from the manufacturer of the biological arrowhead forensics kit?
You know, those kits are made using the Becton Dickinson vial, and the Becton Dickinson vial manufacturer guidelines tell you how much is enough to mix it.
Okay, do they just say, mix it enough, and use your own, judgment, or do they say 8 to 11?
The manufacturer says 8 to 11 is required to be enough.
Of inverting each test tube?
Correct.
Okay, and you're sworn to tell testimony today, you're sworn to tell the truth. Is that the absolute truth?
Yes, absolutely.
I don't have any other questions.
Any follow-up on this?
No, Your Honor.
May this witness be excused.
Yes, Your Honor.
Yes, Judge.
All right, thank you. You may step down.
Okay, thank you.
Okay, I just got to pause it. Oh, for just a second here. Give me just one moment. What I'd like to do now is show you all his website. And then we'll move forward. Okay. So his website to me looks like one of those things like if you act now, you'll get a set of steak knives. Because if you go down to the bottom, it's like, ooh, look at all this. Look at all this. What bothers me and troubles me about what this, this is just what he does bothers me. He's sitting here and he lists all this stuff, and I guess this is part of what he does. But like in one of the cases, he got an overturned, I would say it was like a sexual assault thing overturned with serious toxicology issues. Got some guy off of a meth DUI acquitted. Oh, maybe these aren't people. These are the attorneys that he worked with. They're all in California. DUI, not guilty. DUI, not guilty. The charges were dropped for homicide to a misdemeanor in one of the cases that he testified in. Congratulations, sir. I'm sure the victim's family appreciate you. Defender earned an acquittal in a marijuana DUI because of him. Drug DUI. Deputy public defender, a fentanyl DUI, hung jury in case dismissed. Another meth DUI, not guilty, acquittal. Do I need to go on? I'm just looking for the ones that have the red rum involved again. Just going through that. He's caused a lot of hung juries, it looks like. But then to go over here, it's like, our customers. Our customers? Okay, so these are all the law firms that call him. Apparently, he's available 24/7 at the very last minute. This is his website. He does a lot of blogs too, you guys. He's an author of all these blogs. Him as an expert witness. And what I liked here on this is what won't an expert witness do? Act as a legal counsel, act as an expert witness, will not give you advice, except any case in which there is a conflict of interest. What makes a good expert witness, though? Well, education, experience, and training. I, he's got the education down, but has he had the experience and training? It's all been in the courtroom. Academic publications and keynote speeches, awards or grants, communication skills. That all of this, he's a paid to play attorney. I mean, he's a paid to play expert witness. It's disgusting. It's disgusting. All right, I'm going to go back over here now. Anything y'all would like to add to that before I move on? His education is iffy. It's not showing it. It wasn't showing you guys what I was just looking through. Well, football. I'm sorry, I just read it to you. Okay, let's get back to it. Can you see the trial up now? I've got the trial up now showing. Okay. Let's go forward now. We got another out. We'll see 1 hour, and then I think around the 2 hour mark is when we picked up from this morning. So we'll just keep going on until we need to move forward with something else. Because I have a feeling that after this, we're going to be waiting around anyway. Because if they send them out to deliberate, we'll just be sitting here. So let's just take our time and watch this.
Appreciate it. Thank you. Your Honor, if I may, there's the exhibit that we stipulated to, that I would ask exhibit B, the defense, and that's the receipt.
All right, if you give it to my clerk, please.
Thank you, Your Honor.
Defendant B is admitted.
That's a receipt from Verna.
Yeah,
Well, the jury. Thank you.
Do you solemnly swear or affirm that the testimony you're about to give in this matter before the court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
if you would state your name and spell your last name again, please.
Yes, I am Tabitha Faust, Faust.
Thank you, Judge. Ms. Faust, thank you for being here again. You were, because of court rules allowing the same, you were able to be in the courtroom to hear defense's expert testimony. Is that right?
That is correct.
Okay. When you received the blood sample in this case, Ms. Faust, what was its condition?
The condition I would consider to be normal. As part of our checking process, we look at the samples before we test them to make sure that there isn't a large clotting issue, that everything is mixed in, all the information on it matches our system. It is part of our normal check when we test.
So was there any clotting of the blood in this case?
There was not an excessive amount of clotting that I had noted, or I would have put a note in the case record.
Okay. And what is that indicative of?
So to me, that's indicative that the sample was properly preserved because there is an anticoagulant that is in those tubes. If it had not been mixed properly, then I would have expected the blood to have clotted.
In your role as a forensic toxicologist, do you have any involvement or any opinion regarding inversion of the tubes to distribute the preservative?
I don't know if I have a lot of opinion on it. I know that as part of our practice, we do actually rock the samples before we test them as well to make sure we get a well-mixed sample for testing.
Does the lab have a policy on accepting blood samples that haven't been refrigerated?
Our policy is that we accept any samples that have been delivered to us. Our official ASB standards states that it is acceptable to send samples unrefrigerated as long as they are received within a reasonable amount of time.
And do you have a qualification for what's a reasonable amount of time?
I do not.
Okay. How long between collection and testing was the blood in this case?
In this case, I pipetted this sample less than 48 hours after it was collected.
Okay. In your opinion, would that be a reasonable time?
That is extremely fast for blood alcohol sampling.
Defense's experts spent a good time speaking about acetone and isopropanol.
Yes.
As to did you locate any isopropanol in this sample?
No, I did not. The instrument picked up, there was a peak shape in the window, but it didn't even integrate it because it was so low. It couldn't really differentiate it from background noise.
If you could explain peak shape in the window that the instrument didn't really integrate.
So whenever you run a sample on a GC, there will be it's not a completely flat baseline. There are peaks, so like mountain shaped, and in the isopropanol window, so that time frame, there was a small blip that kind of looked peak shaped, but it was so small that it was considered insignificant by the instrument and myself as the reviewer of the data.
And I think you described the acetone that occurred in the sample as insignificant as well. Is that right?
Yes, it was slightly larger in that the peak actually met some of the quality criteria for what we call a peak, but it was still extremely small, which is why it was not reportable. And it was only integrated on 3 of the 4 results.
And the isopropanol was even smaller than that.
Yes, it was completely insignificant.
Thank
Do
you
you
so
have
much,
any-
Joanne.
Knowledge, or have you read any literature in regards to acetone naturally occurring in the body?
Yes, I have.
And what is that?
So acetone can naturally occur in the body for many reasons. One, like I mentioned yesterday, is in diabetics. If you, especially uncontrolled diabetes, you will have ketones in your system, which is one of them is acetone, and you can go into diabetic ketoacidosis, which is a high level of acetone. The fad diet, the keto diet, tries to get you into that ketosis state. And that is also will increase the amount of acetone in your system naturally. High levels of stress, pregnancy, and even a binge drinking episode can cause low levels of acetone in your blood naturally.
This level of acetone, would that be in line with the studies you've reviewed?
Yes, it would.
You heard defense's expert testify to a study that he was familiar with where a blood sample that started out with no alcohol was allowed to ferment and reached 0.10 within 24 hours. Did you hear that testimony?
Yes, I did.
Did you hear him cite the name of that study?
It sounded like it was by the author of Bloom, but I'm not familiar with that study.
Okay. You've never heard of that in your trainings or in your profession?
Not that particular study. I have other studies on fermentation I've read, but not that particular one.
How many studies on fermentation have you read?
A great number of them. One in particular that we refer to a lot, they were attempting to create fermentation in a tube, and the highest amount of ethanol they were able to produce was as 0.071, but that was after 5 days of not being refrigerated.
What could cause fermentation in a tube?
So fermentation is caused by different kinds of microbes can cause it. But that is why the manufacturer of our tubes puts in that preservative to destroy any microbes to prevent fermentation.
Okay. If you received a tube that had experienced fermentation, would it be different from a typical tube?
So most fermentation processes produce a gas. And so when I go to open, to pipette the sample, I have to take the stopper off the tube. And that buildup of gases, I would be able to hear it and sometimes even see it, because the blood could, in rare cases, actually shoot out of the tube because it's under pressure from the fermentation process. And none of that occurred in this case.
So in your training and experience, is there anything to suggest that this blood had suffered from the fermentation process?
No.
Is there anything in your training and experience to suggest that this blood was not properly preserved?
No.
Is there anything in your training and experience to suggest that this blood was not properly stored and transported before it arrived at the lab?
No.
Just one second. No further questions.
Ross?
Thank you, Your Honor.
Oh, Lord. Here we go.
Showing the prosecutor a perspective of exhibit.
Thank you so much, Joanne, for your gifted memberships. That's so sweet of you. Congratulations, whoever got one.
Ma'am, you said that you did not see any large clotting in the tube or tubes?
Correct. I have seen improperly stored tubes before where the entire sample has congealed, isn't it? It was like a gel-like substance almost, and that was because it was improperly stored.
When you say improperly stored, like how?
I don't remember the particulars of that case, but I believe it was left for a very long period of time in a very hot squat car.
Could that also occur if you don't shake it enough?
I would assume so, because the anticoagulant would not have been distributed within the sample.
And it's very important that the anticoagulant gets distributed very well. Am I correct, to preserve it?
Both that and the preservative, yes.
And you stated earlier, and it sort of stuck out in me, you stated not any excess amount of clotting. So you said I interpret that as there's clotting, but it's not in excess. That's what you said, not any excess amount of clotting. So was there some clotting at all in it?
I didn't know any clotting in this sample.
What did you mean by not any excess amount of clotting?
If the anticoagulant hadn't been mixed in, then I would expect a large amount of clotting in the sample as evidence of that. And I did not see that. I did not know any major clotting or even minimal clotting that I noticed in this sample.
So earlier when you testified with the prosecutor, you didn't say there was no clotting. You said not any excess amount of clotting. So it wasn't any serious clotting in your opinion, correct?
Correct.
Okay. And did you look at it all under a microscope or any of that type of regarding clotting and things like that?
No.
And you work for the state of Michigan, correct?
Correct.
Okay. In the toxicology department, correct?
The toxicology unit of the Michigan State Police.
And you're supposed to do your job as best as you can, correct?
Correct.
And acetone, you said it's okay if you have some acetone in your blood?
Yes, a small amount of acetone is perfectly acceptable and normal.
So acetone is used as a solvent, correct?
Pure acetone is, yes.
And it's okay to have a little bit of that in your system, you're saying?
Yes.
And you've got studies with you today that says you can have some acetone in your blood.
I have a study with me today that says acetone is naturally occurring in the body, yes.
It naturally occurs. And it says what level? that you can just have it and you're healthy.
It does not, I don't believe it quotes a certain level, but the level that I found in this sample was extremely low.
Okay, and that can occur also if somebody's pregnant, right?
As I stated before, pregnant, high levels of stress, diabetic episodes, any of that thing can raise the amount of acetone in your blood.
Did you know my client was not pregnant on April 20th, 2024?
No, you're kidding me. She wasn't pregnant?
I do not know your client.
Would you agree that fermentation is not good in a blood sample, no matter how much, to get a true and accurate reading? Would you agree with that?
Yes.
Would you agree that the blood testing sample, if taken right from somebody in the hospital and tested in the hospital, would be much more accurate than trying to do these shakes and have several days later be tested?
I can't testify to that because I've never worked at a hospital, so I don't know their testing policies and procedures.
Okay, that's fair. Would you agree that not having any refrigeration whatsoever on a blood testing sample and then giving it to you days later could cause some fermentation?
Fermentation is a complicated process that needs more than just not being refrigerated. You have to have the exact right microbes, you have to have enough glucose in the system, and you have to have a low enough blood alcohol level that the microbes won't be killed off by the ethanol by itself.
Were you able to test for that before you tested to make sure all those things didn't exist?
I don't understand your question.
You said, you just repeated or you just stated all these different things that have to be met regarding fermentation, correct?
Correct.
Okay. Are you able to test for that to see, is this a fermented sample or not before I test it?
No.
Or you just test it and you hope it's not fermented?
As I said before, the tubes have a preservative. There's evidence of fermentation.
I'd like for you to stick.
Hang on a second.
Well, I want her to stick with the
Do
answer.
not interrupt her.
Evidence, physical evidence of fermentation, like the gas buildup, like I spoke of earlier, would exist. That is something we are trained to look for to prevent fermentation. But did I test for microbes? No, I did not.
Okay, that's what my question was, and I apologize, Judge, that I interrupted. And did you, when you opened the tube, did you have any type of instrument that would measure any gases that are emitted as soon as you open it?
No, I do not.
And let me hand you something. Ma'am, and I just talked to the prosecutor, and I believe he doesn't object to this communication log report, which would be Defendant's Exhibit C. And I'm going to show you it and see if you recognize it. I believe it may have been printed from your workings. Please take your time. And I understand it's not the full report of all the testing that was done, but I'd look for you to look at this proposed exhibit that shows the different graphs that we talked about or you talked about. Does that look accurate?
Yes, these look like the chromatograms.
Thank you. And ma'am, do you have a copy of that with you? Or is it easier for you to just look at mine?
I think today it would be easier to look at yours.
All right, thank you for
Oh,
being.
no, I found them. Never mind.
Great, thank you. And do you see, it says upper right-hand corner, GC 19-1. It's really the second page after this page.
Yes.
All right, thank you. And it shows the acetone figure under the FID1. What's FID1 mean?
So that is our flame ion detector number 1.
Okay. And then FID 2, I presume is your second one you have.
Yes, that is the
All
second
right,
one.
I'm learning. All right, thanks. And then you have a graph on the third page, second page, that shows acetone number 2 in the FID 2. Is that correct?
Yes,
All right, thank you. And that shows that peak going up, correct?
yes, the integrated acetone peak.
Thank you. And then you have GC 19-2, that page. I'm going to ask you to flip over that. And then we have on the upper right-hand corner, it says Elgin Technologies. And it says page 2 of 2 at the bottom. Do you see that one?
Yes,
All right, thank you. And you see acetone and a graph going up. Is that correct?
yes, under FID 1.
Okay. And then under number 2, you show a graph going up. Is that correct?
Correct, an integrated peak.
Okay, thank you. And that's all acetone, right?
Yes,
Okay. Then formally, I would ask to admit defendant's Exhibit C.
People don't object as long as we publish to the jury. That's only a partial part of the report. For the purpose of
Defendant C is
what the people don't object.
Mark?
It's marked, Your Honor, and I also put that on the record. You just need the staple. All right. Thanks. I don't have any other questions of this witness. Thank you, ma'am.
Any redirect?
Just one last question. This is just a refresher from yesterday. What was the acetone level in this sample again?
so the acetone level in 3 of the 4 detectors was 0.002.
What per,
It'd be grams per deciliter.
okay. And in your training and experience, is that indicative of anything as it pertains to the alcohol test? The ethanol test, I should say.
No, for us, that is so small that we don't even report it.
Nothing further, Judge.
Your Honor, just one question. May I?
Yeah.
Thank you. And you decide that it's so small that you don't report it, correct?
So we have a calibration curve, and that is how we accurately,
If I may, it's a yes or no answer.
I don't think it's a yes or no answer, so let her answer the question.
so we have a calibration curve for any compound that we can quantify and report. And our acetone calibration curve starts at a 0.01, so that is the level at which we start reporting it.
And are you aware of hospitals that they start at different levels? Are you aware? Yes or no?
Hospitals test for different reasons, so I assume their levels would be different than forensic testing.
Thank you. No other questions?
Anything else?
No, thank you.
May this witness be excused.
She may.
Thank you very much. Any other rebuttal witnesses?
Yes, Judge.
People call Anthony Fowler.
I think this is the last witness, and then they go to closings. The defense has lost the jury. I know he has.
Do you solemnly swear or affirm that the testimony you're about to give in this matter before the court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Sir.
Would state your name and spell your last name, please?
My name's Anthony Kathawa, Kathawa.
Thank you, Judge. Good morning, Mr. Gonzalez.
Good morning.
Are you employed?
Yes, I am.
How so?
I work at Fermi 3 Party Store, and we're in Newport, Michigan.
In Newport, Michigan?
Yes, sir.
And you said party store, you sell alcoholic beverages?
Yes, we do.
So, okay. Were you employed in that role on April 20th of 2024?
Yes, I was.
And were you working that day?
Yes, I was.
What time did you go into work?
I'd like to have a sidebar, please. It's very important.
Oh, he's going to tell us how many bottles of wine she purchased that day, I guess. I know the pregnancy question was like, I'm so glad he clarified that for us, that his 68-year-old or however old she is, Granny defendant wasn't pregnant. He's like, oh, he's like, I didn't know about this witness. Judge, I didn't know about this witness. Damn it, Margaret. I know. How much did she buy? That's what I want to know. I'm getting Sarah Boone vibes here.
May I continue, Judge?
Yes, you may.
All right. I kind of lost my place there, so I'm just going to start over. You work at Fermi 3.
Yes, I do.
You were working there on April 20th?
Yes, I was.
Okay. What time did you get to work on that day?
Just before 9 o'clock, before we open.
What
We
time do
at
you
9.
open?
We open at 9 o'clock.
Okay. And did you make a sale on the day that brings you here today?
Yes, I did.
Do you remember what that was?
Yes, I do.
Do you remember who you sold it to?
Yes, I do.
Okay. And do you keep records of the sales at your store?
We have a POS system. Our receipts are saved in the POS system.
Okay. POS, for those of us that aren't in the industry, is that point of sale?
Yes, it is.
All right. That's your cash register,
It
right?
is our cash register.
Okay. And so are you able to sort of replicate receipts from any transaction?
By replicate, do you mean reprint?
Sure.
Yes, we could
Okay.
reprint a receipt that has gone through already.
Do you have access to that system?
We do have access to it, yes.
Okay. And you can go in and find a sale from April 20th of 2024 and reprint the receipt?
We should be able to.
Okay. Do you know if you did that on that with regard to that sale?
Yes, I did.
Okay. I'm going to show you what is marked as People's Proposed Exhibit 36.
I don't object, Your Honor, if he's going to be ahead of it.
All right, People's 36 is admitted.
Thank you, Judge. Can you put that on the screen, please? Mr. Gonzalez, do you recognize that document?
Yes, I do.
Okay. And can you tell me what that is?
It is a receipt of the transaction made that day.
Can you read the date, please?
Yep. Yeah. 04/20/2024, April 4th, 2024.
And what time was this transaction made?
9:01.
So 1 minute after you opened?
Yes, sir.
All right. And what is on that receipt?
It is a 4-pack of Sutter Home Pinot Grigio wine and Silver Rain Cabernet, a bottle of wine.
When you say a 4-pack of Pinot Grigio, just a few questions about that. What is Pinot Grigio? I mean, I know it's a wine. Is it a red wine, a white wine?
It is I would say a white wine. It's clear in color.
Clear in color. Okay.
Yes, sir.
A 4-pack is what size approximately would those bottles be?
Honestly, so it's 187 ml. It's a really small bottle of wine. It's like
Sort of like what you would get on an airplane.
Yeah, you could say that.
Okay. It's equivalent to about 1 glass of wine each.
I am actually not sure about that.
That's fair. And then the bottle of Cabernet, that was a more traditional size bottle?
Yes, it was a regular standard bottle. I think it's 750 ml.
And is Cabernet a red wine or a white wine?
It is a red wine.
Thank you. I don't have any further questions for this witness, Judge.
Cross?
Yes, Your Honor. Oh, correct. Sir. Right.
So a 4-pack of they're not that little, but the 4-pack of the handheld bottles, and then a big bottle of
When you open at
Chardonnay.
9 o'clock, do you have people every day come in and buy things?
Yes.
It's not unusual.
It's not.
And are you like, I've driven by your place. Is it like a neighborhood type place?
It is.
You get to know everybody?
Depends. Some
Or
people are in and
you
out.
get to know, you get out of towners sometimes.
Yes, we do.
And that's a truthful receipt, right? Because that's
Yes,
what
it
took
is.
place.
It is a truthful
We
receipt.
don't doubt it. Okay. And do you know those bottles, are they like little 4-pack with bottles about that big?
Yeah, about that size.
Okay, they're like around that round.
Yes, they are.
All right. And people buy those sometimes. That's why
Yes.
you carry them.
Of course.
Okay. And do you remember my client coming in that day?
Yes, I do.
Okay, did she seem like she was intoxicated at 9 in the morning?
No, she showed no signs of that intoxication.
Thank you very much. And if she did, you wouldn't be selling alcohol,
Exactly.
right?
We
Okay.
refuse, we have the right to refuse to sell to anybody that's
And
intoxicated.
you might even call the police too. if
We
they
could
look
call
like
the
they could
police.
Harm themselves, okay. And then there was a bottle of, did you say,
It was a bottle of wine, Silver Rain Cabernet.
okay, all right. And people bought things from, it was the lawful time to be able to buy anything for your house, right?
Yes, sir.
Okay. And she didn't sit there and open the bottle and start drinking in your
She
place,
did not.
right?
And we do not condone that, allow that.
Right. I don't blame you. And she didn't sit there and go outside and start drinking a bottle of wine, did she?
I didn't go outside, so
Okay, do you
I
have
can't
video?
tell you.
Do you have video outside?
We don't have we didn't have cameras at the time.
Okay, all right. And so, do you know where she went from there at all? No?
I don't.
Okay. And do you know whenever in the future that may have been consumed, whether it's that day, the next day?
I was not with
any
her.
day?
Nope, no clue at all.
That would, you would be speculating, right? You
Yes.
don't know. Okay.
All I know is that she purchased it from me, and what she did with it, I have
And
no clue.
she presented herself very presentable and things like that.
She was,
Okay, I don't have any other questions. John.
Any redirect?
No, Your
All right, thank you. May this witness speak, excuse.
Honor. Yes, Judge.
thank you, brother.
Okay, so just to touch on that again. So she bought the little bottles that were basically, if you pour it in a glass of wine, it equals a regular glass of wine. And then she bought another larger bottle. I think I wrote Chardonnay, but I think she said Cab Sauvignon. Okay. So when the detective gets up here, he's going to say, okay, and all those bottles were empty when we went to the house. So she drank those 4 glasses and then that whole bottle by herself before 3 o'clock. And she was at the, whatchamacallit. She was at the liquor store waiting for them to open, you guys. Like, I've only done that, like, if I needed coffee or something, you know? Oh.
Appreciate it. Thank you, Judge.
Any other rebuttal witnesses?
Yes, Judge.
Okay.
I'll Deputy Howard Cradmore.
Yeah, the red bottle was a regular big bottle. It was a mega pint. So you guys notice how all of a sudden the seizures have just gone away. They're not talking about them.
Testimony you are about to give in this matter before the court shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
He's going to probably have her have a seizure right there in court, fake a
Deputy,
seizure.
would you state your name and spell your last name for us?
It's Alec Predmore, Preadmore.
Thank you.
Afternoon, Deputy. Morning.
Morning.
It's been a long week. What do you do for a living, Deputy?
I'm a deputy sheriff with the Monroe County Sheriff's Office.
How long have you held that position?
Approximately 8 years on road patrol.
And what's your current assignment?
I'm assigned to traffic services.
And what does traffic services do?
So traffic services is a division within the sheriff's office. I handle crashes on the road, fatals, VIN inspections, just any traffic complaints if somebody were to call into dispatch and was having a traffic issue.
In your role with traffic services, did you play a role in this investigation?
Yes, I did.
What was your role?
So I responded to the scene the day that it happened on April 20th. From there, my supervisor advised to respond to Verna's and take part of that investigation.
And you did so?
Yes.
Did you do anything in regards to the defendant's 2017 Ford Edge?
Yes, I did.
What did you do in regards to that?
So on April 22nd, around 12:30, Deputy Burkhart and I responded to Jim's Towing to conduct a vehicle inspection of the 2017 Ford Edge. While there, Deputy Burkhart needed the EDR, the black box, out of the vehicle. Jim's Towing employee, Forrest Peck, was removing the EDR from the vehicle, and he made a discovery from the inside the vehicle.
And what did he
I'm gonna show you what you brought for us in just a brown paper bag, but there's something in an evidence envelope inside.
Yes.
Your Honor, this, any of this case in chief should have been brought in case in chief. I have no idea that it would be rebuttal, that all of a sudden it's an afterthought to find something. It should be in case in chief.
Same response to the sidebar, Judge, if you want me to make a record of it. Defense's case is that defendant only had one glass of wine that day, and through some sort of chemical process, that turned into a 0.18 alcohol level by the time of the crash or the draw. This is all to specifically rebut that proposition.
All right. Certainly the other testimony was, I don't know what this is yet. So I guess we'll see.
So Deputy, you were present when Forrest Peck, the tow truck driver, was removing the EDR.
Yes. While he was doing so, he located a 187 milliliter bottle of Sutter Home Chardonnay.
Oh,
which was turned over to me, photographed, and was placed into evidence.
Here.
so it was
And that
4 of
was
those she
located in
had.
Defendant's vehicle.
Yes, in the center console.
Okay.
Remember,
People would move to admit the bottle is People's Exhibit 40.
I was wondering if they found any in her car.
People's 40 is admitted.
No further questions.
Cross.
That, I don't know if Lenny, if you're, yeah, there's Lenny. Lenny, that was the firecracker ending right there. In my opinion, that and watching her in her video.
If you're done.
I'm done with it. Thank you.
Sorry, I thought you wanted to inspect.
No, I did want to look at it. Thank you.
Officer, do you know when that was drank?
I do not.
Okay. Do you know of people that do returnables and they have a bag of returnables and things like that? And returnables, but also recycling too. Do you know, have you ever heard of people doing that?
Yes, of people recycling plastic, yes.
All right. Do you know if my client ever was like always recycling everything?
I do
Sort of
not.
an earth person?
I do not know.
And do you know where that plastic, is it a plastic bottle?
I
Whatever
don't
it is
recall. I
it is.
believe so. Yes, so I know it's a bottle.
Do you know where that came from?
From the center console of the vehicle.
Okay. And have you ever seen any videos or photos of my client ever sitting in a car drinking?
I have not, no.
All right.
No, sir. But what we could do is we could possibly go back to the surveillance video of when she was getting in her car and all the time while we were waiting for her to back out. Maybe that's what she was doing. Maybe we could zero in on her car and try to figure that out if we have the proper equipment to do so.
Do you ever take any recycling items to be recycled, such as bottles or cans or plastics?
Me personally, I
What the deputy
How is it relevant?
I'll withdraw it, Judge.
All right.
Have you ever pulled anybody, have you been a patrol officer?
yes, for 8 years.
Okay. And have you ever pulled anybody over and investigated and see they have returnables inside their vehicle?
I mean, I'm sure.
Objection relevance.
Well, I'm laying foundation if it's an unusual thing to see returnables.
I'll take the answer.
Thank you. Have you seen that before ever?
I mean, yes, I have recyclable. I have bottles in my patrol car right now. Yes.
Okay, all right. And that doesn't mean that they drink that wine right then and there or prior to, correct?
I don't have that answer.
Right, all right, okay. It would be all speculation, right? You'd be guessing.
Yes, I would be. Yes.
All right, thank you. I don't have any other questions.
Redirect.
No, thank you.
May this witness be excused.
Yes, you may.
Thank you.
Thank you, Judge.
The prosecution, I mean, the defense has to realize how
It's time to people call Detective Kenneth
ridiculous
Doss.
he sounds. Please tell me he realizes it. He just has to do what he has to do, I guess. But again, they've dropped up talking about her seizures because they could not get a medical expert in to back that up. So that's why he's pushing so hard on this.
The testimony you're about to give in this matter Nothing but the truth, so help you God.
I did.
We're going to watch the videos again right here, y'all.
Thank you.
Detective, if you would state your name and spell your last name, please.
Yep, Detective Kenneth Dodds, Dodds.
Good morning, Detective Dodds. Are you currently employed?
I am
Where are you employed?
with the Monroe County Sheriff's Office.
And what is your role there?
I am currently a detective with the Monroe County Sheriff's Office.
And what training or experience do you have to have prior to being delineated as a detective with the Monroe County Sheriff's Department?
So I attended the Oakland Police Academy and graduated there in 2017. Over the course of the past 7 years, I've attended multiple investigative schools, some being basic detective school and evidence technician school.
And so I think you just answered my question, but approximately how long have you been a detective?
A detective approximately 2 years,
And how long have you been employed by the Monroe County Sheriff's Department?
7 years.
And prior to that, did you have any experience in law enforcement?
No, I did not.
So the entirety of your experience is with the Monroe County Sheriff's Department.
Yes.
Was there something as a result of your employment, were you involved in an investigation of involving the Swan Boat Club in April of 2024?
I was, yes.
What was your involvement with that case?
A couple days after the incident happened, I helped execute a search warrant on the defendant's house.
Do you recall the exact date by any chance?
I believe it was 4/22 of 2024.
So that would be April 22nd?
Correct.
Okay, thank you. Detective, as a result of that investigation, or rather, what, if anything, was the Detective Bureau hoping to find or anticipating that they might find as a result of the search warrant being executed?
So through the course of our investigation, we learned that the defendant purchased alcohol prior to the crash happening. So part of the search warrant was to locate any evidence related to that.
And Detective, do you happen to recall what she purchased, if you can recall at all?
I don't recall exactly.
Okay. As a result of the execution of the search warrant, did you find anything relevant to that inquiry?
We did. We located multiple small wine bottles in the kitchen trash can. They were all empty. I believe they were Sutter Home brand. And we also located a couple Fireball brand empty bottles as well.
Detective, you indicated that you kind of used your fingers to implicate. Do you recall, were they large bottles of wine? Were they small bottles of wine?
They were small bottles of wine.
Do you know how much is found within the small bottle of wine of Sutter Home that you just mentioned?
They were empty at the time we located them.
Okay, sorry, that was not a very clear question. When you say small bottles of wine, do you recall exactly how much that particular bottle holds?
I don't recall exactly how much.
Okay, Judge, can I see Exhibit 40, please? May I approach? Thank you. Detective, I'm going to show you what has been marked as People's Exhibit 40. May I approach the witness, Your Honor?
Yes.
Thank you. Detective, can you take a look at this bottle and I suppose familiarize yourself with it and then look up at me when you are done? Okay. Based off of your recollection from executing the warrant at the scene, is this similar to the bottles that you found?
Yes, this is very similar.
Okay. And can you just look on the bottle and articulate for the record how much is found within that bottle?
Looks like 187 milliliters.
Thank you. May I approach, Judge?
Yes.
Thank you. I'll take that back from you, Detective.
Thank you.
Detective, do you recall what type of wine was found, I suppose, and when I say type of wine, Chardonnay or any other type of wine was found in those bottles, or I suppose was at one point in those bottles?
I don't recall exactly what kind of wine it was. No.
Okay. Are you familiar with types of wine?
Vaguely.
Okay. Do you? That's okay. Do you withdraw your objection? Okay, thank you very much. Yep. And Detective, you indicated there were several empty bottles of Fireball whiskey as well?
Yes.
Okay. Detective, did you find any full bottles of Sutter Home of the 187 milliliters that you just indicated?
No, we found no full bottles.
Did you find any full bottles of wine within the home during the execution of your search warrant that you can recall?
Not that I can recall, no.
Thank you, Detective. That's all I have for you.
Thank you.
Thank you, Judge. Now,
This tragic accident happened on April 20th of 24, correct?
Yes, sir.
And you executed a search warrant at the residence of my client and her husband on what day?
The 22nd.
So 2 days later, correct?
Yes.
Okay. And my client was not at her residence during those 2 days. Do you agree with that?
She was not there at the time of the search warrant.
And was she there a day before, or was she somewhere else?
I do not know that, sir.
You don't know if she was arrested and in jail?
Oh, I believe she was in jail at that time.
Okay, so that means she wasn't at her residence, right? She couldn't be at her residence and in jail at the same time.
Correct.
Okay. And do you know when those bottles, those 4 little bottles, when those were drank?
No, we do not know when they were drank.
And do you know who was residing at my client's residence when you showed up with a search warrant?
Her husband was there at the time.
Do you have any reason to believe that her husband was not residing there every day for a long time prior?
No.
All right. And do you know what he drank when he was at the house those 2 days?
No, I do not know what he drank.
All right. So you're not in front of this jury in court. You're not alleging that my client absolutely drank these 4 bottles that were purchased 2 days before, are you?
I can't say who drank those bottles, sir.
All right. I appreciate your honesty. Thank you. Now, the bottle that was found in the car, did you hear about that? And that was some exhibit that was just showing you. There's like a plastic bottle.
I'm
It was showing you.
aware. Yeah, I'm aware
All
of the
right.
exhibit.
Did you ever go look at the lot number on that and measure it with the lot number from the party store?
No, we did not.
I don't really know what he's referring to regarding the lot number and also.
Lot, L-O-T.
Yes, I still don't know what he's referring to in regarding the lot number.
Oh.
And I don't believe that there's going to be testimony from Detective Dodds regarding the lot numbers.
All right, I'll withdraw that. That's fair.
Okay.
Now, because there was no cold bottles of these wines, does that mean, when you executed search warrant, does that mean that my client's husband could have never drank those for 2 days?
Judge, I'm going to object to speculation. I don't really know, first of all, what the relevance of this is, but secondarily, I think he stated that most of the bottles that he found were empty, if not all bottles.
I totally agree as to the relevancy of this. I'll withdraw it.
Any redirect?
No, Judge,
May
thank
this
you.
witness be excused.
He may, Judge, thank you.
Thank you.
Thank you, Judge.
Next rebuttal witness.
Judge McCall, Detective Sergeant Jeffrey Hoover.
Yeah, I don't understand the whole fireball thing, but okay.
Do you solemnly swear or affirm
I'm exhausted for that attorney.
in this matter before the court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
That's true, Northwest. The 4-packs, you can get them in the refrigerator and drink them in the car easily.
Jeff Hooper, Hooper.
Thank you, Judge. Sergeant, you testified previously that you executed a search warrant on defendant's home. Is that correct?
Yes,
And when was that done?
that would have been Monday, I believe it was the 22nd
And
of April.
Sorry, you testified that you found some cameras and a DVR recording system.
Yes,
Did you find any cameras inside the home?
yes,
And how many cameras were there?
one.
Where was it located?
In the kitchen area.
In the kitchen area. Were there any recording? Were you able to locate any recordings from April 20th of 2024
Yes,
in the kitchen area camera?
yes,
And did you have a chance to review those videos?
yes.
And did you find the timestamp to be accurate on those or similar problem as the other ones?
Similar with the other one. Again, if it was an hour behind. So if it said 3 o'clock on the timestamp, it would be 2 o'clock.
Did you make a copy of these videos?
Yes,
And you viewed them, correct?
yes,
Okay. You reviewed what's purported with people's proposed exhibit 38A through 38F.
yes,
And are these all home
No,
Just pertinent to the case in chief.
correct.
Judge, I'm going to move to admit people 38A through 38F.
Response. I'd like to see what they look like before, Your Honor.
Are you gonna play him?
I'll move to proffer next, Judge.
All right,
All
let's do
right,
that.
can we play 38A, please? 1 second, don't play it just yet. Detective, can you, for me, tell me what the date and time is on this?
So the original date and time is 4/20 of 2024 at 8:24 and 47 seconds in the morning.
And so that would actually be what time?
9:24 and 47 seconds.
AM.
AM.
Okay, please play the video.
She's got one of the small bottles in her hand. Now that we know what the bottles look like, this makes better sense to us. And this is how the jury saw it. They saw the bottle first. And what did he say? This is 9:24 a.m. that she's drinking this? Instead of coffee, she has wine. Susan.
Please play 38B, or actually bring it up. Detective, what is the timestamp on that?
9:24 and 38 seconds AM.
What would be the accurate time then?
10:24 and 38 seconds AM.
Please play the exhibit.
So an hour later, she's got the bottle in her hand. She's going to throw it away. And she's getting another bottle out of the fridge. Too bad we can't see the refrigerator. Yeah, whose idea was it for her to put cameras in her house? I can't see her left hand there, though. Wonder why they've got that camera in there. Laura says she thinks it's because so the husband can see if she was drinking.
Detective, what's the timestamp and date on this one?
9:45 and 12 seconds AM.
Also from April 20th?
Yes.
So what is the accurate time then?
10:45 and 12 seconds AM on the 20th.
Okay, now she's got another bottle in her hand, and she's going to throw that one away. So that would have been bottle number 2. I think she's going to the bathroom when she goes around that corner and then comes back out and gets another
Detective, what is
bottle.
the date timestamp on this one?
April 20th, 2024, 11:35 and 1 second AM.
And what is the actual time, accurate time?
12:35 and 1 second, and that would be PM.
Please play the video.
Your Honor, for the record, this is 38B.
That's correct.
So this was, she had just returned from having lunch right here. She's got a bottle in her hand. So that's the 3 bottles. There's 3 small bottles, and then the 4th one would be in her car. You think she's hiding them in her pocket so the husband, if he's watching the camera, can't see? TV straight ahead.
Please pull up 38. Detective, what is the date timestamp on this one?
April 20th, 2024, 1:10 and 38 seconds PM.
It says 13:10, but that is, the translation is 1:10 PM.
I'm sorry, yes, that's military time.
Sure.
So one,
What is the accurate time?
that would be 14:10 and 38 seconds or 2:10 and 38 seconds PM.
Thank you. He is in here. Thank you.
And don't forget, she had, yeah, thank you, Ann, for the reminder. She had one at lunch as well. Okay, there's the big bottle getting opened. On the news, her husband said that there was no alcohol in the house, so she had to go out and buy it.
Just pull up 38F. Detective, what is the date and timestamp on this?
April 20th, 2024, 13:31 and 50 seconds or 1:31 and 50 seconds PM.
And what is the more accurate time based on timestamp and accuracy?
It would be 14:31 and 50 seconds or 2:31 and 50 seconds PM.
Approximately 30 minutes before the crash.
Correct.
Please play the video.
She may not have even known that camera was there, you guys. Her husband may have put it up to see if she's been drinking, watching her. Because there's no way he didn't know she had an issue. Getting another glass. Yeah, how can you stop somebody that's determined to do that? There's no way to. I am confused, though, why they, with everything that the defense threw out, why didn't they try to get the husband to testify unless they thought it would just work against them? Yep, Cyrus then added in the meds, too, that she was on. I bet this was her daily routine.
Judge, the people again move to admit exhibits 38A through 38F as in Frank.
Response.
Your Honor, we have no objection, just for the record, prior motion that was filed prior concerning this, but no objection.
People's 38A through F, they are admitted.
I thought I heard that the husband was working,
I
that
have
he
no
still
further
works.
questions for this witness, Judge.
Cross.
Officer, did you, were you ever inside my client's home prior to the date you executed the warrant?
No.
And when you obtained this videotape, you obtained the contents of the videotape, correct? Or the video machine or recording machine?
Yes.
Okay, with this search warrant, right?
Yes.
Okay. Did my client participate in you going through, well, you had a chance to go through and look at hours of videotape, correct?
Correct.
And he didn't stop you at all from taking the videotape. You asked for it, and he showed you where it was, and he gave it to you, correct? My client's husband.
Correct.
Okay. And you didn't have him come to your office and go through the videotape from start to finish to confirm that that's the videotape, no editing, no nothing, that it's the full videotape. Did you ever have him come do that?
He did not come to my office, no.
But you never went through the entire videotape with him prior to you starting to edit and show certain fragments today, correct? He didn't participate in editing this, correct?
It's not edited. It's just the videos were taken off of the DVR.
Okay. If the DVR has 6 hours of recording and you take 2 or 3 spots, segments, that would be editing, right? Because it's like taking a police report and putting black certain parts.
I can't say one way or another. I don't believe
Is that the
so.
full videotape?
Is that the full
Full
contents of?
videotape of
Okay,
4
hang
hours?
on a second, you asked him a question, you
Okay.
talk over.
You're right, Judge.
That is not the full contents of all the video for that day. No.
And who decided to participate in, for lack of a better word, editing or picking which versions and how they were obtained? Who did that? Did you do that? Did an IT person do it?
No, I looked through all the video footage.
And you picked those to bring to court today, right?
I notified the prosecutor's office of my findings.
Okay. And your job is to participate in people that are arrested and participate in coming to court and participate in getting convictions. Do you agree with that? You're not here.
Your question is argumentative.
That's not argumentative. How's that argumentative, Judge?
Your job is in getting convictions.
Well, what's he doing here today? Is he working for me and saying
I
she's
think what he's
innocent?
doing is telling the truth.
Okay.
That's his job, so in that regard, the objection is sustained.
Okay. Do you come to court to testify in criminal cases in your history of being a police officer to prove the innocence of the accused?
The same objection, Judge.
It applies.
All right, thank you. I'll withdraw, Judge.
No further comment.
Any more redirect?
Briefly, Judge. Detective, you said there are other videos for this, correct?
Yes,
Do they present as one long 6-hour video or however long?
they do not.
How do they appear on the system?
So on the system, they are motion activated. So each time it triggers, it creates a new video. So for that complete day, on that DVR of all 4 cameras, I believe roughly approximately 460 video clips.
They're all short video
They're all,
clips?
absolutely all short, maybe a minute long.
You didn't edit down a longer video into short clips.
No,
This is how they came to you.
yes,
Did you make any alterations to the videos?
no.
Nothing further, Judge.
Detective, you're not showing any videos from 6 in the morning, am I correct?
Correct.
And there were activated videos, motion activated from, let's say, 6 in the morning, do you think? Or is this the only time that she walked around?
No, there were other videos of her walking around.
No other questions?
All right, may this witness speak to you.
Yes, Judge.
Thank you.
Thank you.
Next witness.
Judge, we want no further witnesses, we rest our rebuttal.
All right. Here's what we're going to do, ladies and gentlemen. We're going to take a short break, like about a 10-minute break.
People of the state of Michigan versus Marshella Chidester.
I was muted. We're going to go ahead and watch the closing for the state again because it's only like 15 minutes. Because once they have the closings, we're just going to wait around for the verdict anyway.
Ready to make your closing statement? Yes, sir. Thank you.
Good morning again, ladies and gentlemen. I know it's been a long 4 days. We appreciate your patience and your attentiveness. You've now seen all the evidence and heard all the testimony that you're going to hear in this case. I told you at opening that I'd come back here at closing and go over the evidence with you. There are some photos that the people did not show during the case in chief. Those will go back with you into the jury room. If you feel like those will be helpful in rendering your verdict, you're free to look through them and review them. The same with the defendant's interview. The people did not play that in their case in chief. The defense didn't elect to play it. I think the parties all felt it didn't move the needle too much one way or the other, but you're also going to be free to view that back in the jury room. So what has the evidence in this case shown? It showed that Diane Medina, Leah Stith, Ed Smothers, Zayn Phillips, and Mariah Dodds were all injured as a result of the defendant's operation of the motor vehicle. We could bring up the jury instruction on OWI causing serious impairment. And you'll have this written back in the jury room. But the injuries being the result of the operation of a motor vehicle is one of the elements you need to find. That is not in dispute. The defendant was the factual and proximate cause of those victims' injuries. Further, those injuries rose to the level necessary under the law for you to find that element in counts 5 through 9. This is actually stipulated to by the parties. In other words, we agree the degree of injury is not in dispute. Further, you could bring up OWI causing death. The evidence shows that Zayn and Alanah Phillips died as a result of the defendant driving that day. Their death was a factual and proximate result of her operation of the motor vehicle. They do not dispute this. You did not hear from a medical examiner because the parties agree that that was the cause and manner of death. It is not in dispute. The defendant's willful operation of the motor vehicle is not in dispute. The parties agree. We all saw the video of her leave her house and get in her car.
Judge, I agree that there's willful use of an automobile. But you just said we agree on willful.
No, fair enough. I
agree
guess.
There was I agree there was an automobile accident. It's proximate cause of a horrible thing of injuries and deaths.
All right, your objection is sustained.
All right, thank you.
People offer to you that the proofs show that the defendant willfully operated the motor vehicle on the date in question. You all saw the vehicle, the video of her get into her vehicle and drive it away from her home. We think that element is met. As the driver of the vehicle is not in dispute. People would offer that there are two key elements in this case that are in dispute. The defendant's blood alcohol concentration and her intent when she crashed into the Swan Boat Club. As to the BAC, the blood alcohol concentration, you've heard from several credible, experienced, and dedicated professionals about the level of care and the quality that was taken with defendant's blood draw and the subsequent testing. You heard from Deputy Schmidt, who was able to walk you through the blood draw process and confirm that everything was done according to proper and long practice procedure. You heard from Rome Monday, the phlebotomist, who testified she had conducted thousands of blood draws in her career, and she also told you she followed the correct, proper, and accepted procedures. Former Deputy Krieger, Lab Technician Hopner testified. They both told you that not only were the policies and procedures followed, but they went above and beyond. That typically a blood sample would be dropped in the mail. This one was hand delivered by deputy to the Michigan State Police Crime Lab. Finally, our two experts in forensic toxicology, Tabitha Faust and Samantha Beecham, testified the procedure for testing the blood and their results. Their results, that the defendant's blood was a 0.18, more than twice the legal limit for regular OWI and exceeding the limit for high BAC OWI. Further, there was the presence of gabapentin in her blood. But this is disputed. So what can you folks do? What other evidence can you look at to support the expert's evidence of the blood draw? First, you can look at the testimony from the first day of Ms. Sigler and Mr. Wickland. Ms. Sigler testified that she smelled alcohol on the defendant immediately after the crash. Mr. Wickland flat out called her drunk when he helped pull her out from behind the wheel of the car. He further testified he smelled alcohol on her as well. Deputy Karina said she smelled of alcohol, and Deputy Schmidt went through the field sobriety testing with you. In his opinion, she failed field sobriety testing. But how else do we know the blood alcohol result was accurate? We know because she told us. We could bring up the first clip from Deputy Karina.
To 10, 0 being like you're so cold sober you can drive perfectly, 10 being you're passed out drunk. Where do you think you're at right now?
7.
A 7? Okay.
What else supports it? When they tested her blood, they found gabapentin in her blood. What did she tell us about her gabapentin?
Run through the medications that you told me about again.
Gabapentin.
When did you take your medications today?
8 o'clock.
8 a.m.?
Yeah.
Okay.
And how do we know she had more than the one drink at Vernus? It's well established in the evidence, and I don't think either side disputes. She left Vernus at the latest at 12:15. Crash was at 3:01. But remember what she told Sergeant Bomia.
A little bit, yeah.
When's the last time you had something to drink?
Probably half an hour ago.
Half an hour ago? What did you drink?
Wine.
Wine? Okay.
And just today, you heard from the clerk at Fermi 3, and you saw the video from inside the defendant's house. It's true that she had one glass of wine at Vernus. That doesn't speak to the rest of the day. All of those other pieces of evidence that I've just talked about, just showed you, work together to show beyond a reasonable doubt that the drink at Vernus wasn't her first or her last drink of the day. It's similar to the mystery story I mentioned to you in voir dire, that all of the evidence lines up to show one result, except one thing. And that one thing is defense's expert. But everything else works to show that the BAC result is accurate and in line with what she did that day. The second element that people believe are in dispute is the defendant's intent. We bring up the second-degree murder instruction. For the OWI causing death and the OWI causing serious impairment, you only have to find willful operation of the vehicle and that her blood alcohol exceeded the legal limit, or that she was intoxicated, or that she was impaired by alcohol and gabapentin. For the people's first two counts, the 2 counts of murder in the second degree, you have to find a separate intent. You can find one of 3 kinds of intent to find the defendant guilty of second-degree murder. You can find that she intended to kill. You can find that she intended to do great bodily harm. Or you can find she knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of her actions. As we talked about in opening statements, you can look at what she said, you can look at what she did, and all the evidence and circumstances surrounding this case that you've heard over the last 3.5 days to decide what her intent was. You can think about her driving toward the boat club, straight as an arrow, right between those 2 telephone poles. You can think about what she said to Kristen Sigler right after the crash. Where's Don? She wanted to know where her husband was. You can think about her crashing into the neighbor's truck. And then continuing on her way. At the moment she crashed into that truck, she had to know things were not right, but she continued on. She continued on at full speed and drove her car into a 3-year-old's birthday party, into a building, a route that she knew very, very well. Ladies and gentlemen, this is not a typical drunk driving crash. Not at all. She didn't cross a center line and strike oncoming traffic. She didn't misjudge a red light and rear end someone. At almost 45 miles an hour, she drove through the wall of a building that she had been to countless times. That's what makes this worse than OWI causing death alone. She drove her car into an occupied building knowing she was unfit to operate a vehicle. And if she didn't know she was unfit to drive when she got behind the wheel, she knew it after she hit her neighbor's truck. 5, 4, 3, 2, 1. 44.3 miles an hour on a dusty, pitted dirt road. Look at all those things to determine her intent. As most criminal trials are, the focus of this trial has mostly been on the defendant. How she drove, the contents of her blood, and her state of mind. But let's not forget, a trial is about a fair trial for the defendant and for the victims. The ones you heard testify and the ones you couldn't hear testify. It's about an 8-year-old big sister and her little brother. 2 little kids that had just sat down to eat their hot dog and a cake pop at a birthday party. Sat down to have some lunch without a care in the world. They didn't have a chance. It's about justice for these 2 kids. Thank you.
Thank you. Mr. Wells.
Thank you.
Yeah, if only she'd have hit that post, Mark. She did miss it by inches.
This is, the law in Michigan says that the plaintiff, the prosecution has the burden of proof. That's why they get to go first. That's why the defense goes second, because they don't have to prove anything. These people have to prove everything, every element beyond a reasonable doubt. And then because they have such a high burden to prove their case, they get to go first for a closing argument, that's what this is called. And then I do my closing argument as a defense. And then because they have such a high burden of beyond a reasonable doubt, they get to go again. They get to go last. So, and it's sort of common sense. We can't keep going on and on for many days. So they stop it there at the law. So they get to go first, then we go, and then they get to have closing argument the last. And sometimes what happens is that they'll do their closing argument and then they'll say something that I can't rebut or I can't stand up and talk like I am right now. I'm going to be doing with what they mentioned. So I ask all of you, when you go into the jury room to deliberate, think about what Bill Clovis would have said. Think of how I would have countered anything if they're holding anything for their last time to talk to you and I have to just sit there. This case, I don't have to tell you, it's very, very, it's very sad. It's very, very sad. And the facts of two children passing away, as the prosecutor said, in a setting like this is just beyond grief. And that's why I took a moment out, maybe took my attorney jacket off, so to speak, and really gave sympathy to mom. I gave sympathy to all of them. I don't want to get anybody hurt. I don't have vindictiveness. My client doesn't. And I gave my sympathy. And it's normally out of line to do that. And I'm glad the judge and prosecutor allowed me for a minute to do that because I just had to get that off my chest or myself because I can't talk to the witnesses here when we're in court. And they don't have to talk to me at all. It's very, very sad. And, you know, I'm taking a little bit longer in a closing argument today than I normally do when I have a trial or I'm involved in a trial. Because there are several counts. Well, first, all due respect to everybody injured and the poor little kids. I want to show them respect. And that's why I want to just talk to you. I'm not making things up. You know, so many times, you know, attorneys, people raise their eyes or look up when you say attorney or attorney jokes and that. There ain't no joke in here. And I'm a real deal. When I talk to you, I'm not making anything up. Certainly, it's up to you. You're collectively the judge of the facts, all of you. And I respect that, and my client respects that. That's our American jurisprudence, our American law, is that we have, if you're charged with a felony, especially a capital felony, 12 jurors decide the case. So the judge certainly has been very nice and will release one person, or the clerk will. And then the 12 of you, whomever you may be, will deliberate and rule on the case as a judge of facts. Of course, the most serious part of this case is second-degree murder. Murder charge don't get no more serious than that, at least in Michigan. A murder charge. And to me, in the law, is that for somebody can get charged every day for whatever. Somebody to be convicted of murder, whether it be second-degree murder, there's an intent. There has to be an intent or intentional, like recklessness. To me, that's intent. Okay? If I'm driving down the street on the freeway and Bill Clovis never had a heart attack and I have a heart attack and somebody's changing their tire and my car hits them and they die, there's not much intent there. I had a heart attack. What do you want me to do? I apologize. Everything that happened, but please don't charge me with murder. And that's our first part of the poor two children that died. And my client, actions speak louder than words. My client, the officer says, in effect, had no record, no nothing.
Objection, Judge. I think he's arguing with facts, not evidence.
Well, I thought I asked the officer with regard to record. If I didn't, the jury heard me not ask him
All right, we'll allow it, but it's
Thank you.
a close call.
Thank you. This person doesn't drive around committing crimes. Here's this person that went to lunch. Let me back up. I want to address everything he brought up. But it's interesting that some of the things they brought up was not what they call a case in chief. In other words, when you present a case, as prosecutor, you put everything up there. Then the defense puts, if there's any evidence they want or whatever to counter it or bolster their defense, then they go up there. That's how it's done. Then they waited and did some rebuttal and pulled things out of wherever. Why did they bring that in case in chief? If it's so true and so positive. Something to think about. Is it lawful? Yes, they can do that in rebuttal, but think about common sense. That's another thing. You don't, a lot of times judges will tell juries, you don't leave your common sense outside. You leave your bias and prejudice outside, but not your common sense. It just, you can have your common sense when you're in the room. That's what we all have, our life histories that we bring. That's why I like to have a little bit older jurors, because they've experienced life histories. And they can judge things because they've lived some life. And you can use that. You just can't have prejudice or bias. You can't have that. Somebody sitting at defense table, they're guilty. Prosecution prosecuted my brother. I don't like prosecutors and police. No, can't do that. You got to start with a clean slate. Just as if somebody, anybody, family member, whatever, is being charged with something. You want them to have just a fair, clean slate you start with. That's why I asked in the very beginning. There's nothing been said. How would you find a person? Sometimes people say, well, they're charged guilty. No, not in America. They haven't put any proofs on it. They got to prove their case beyond a reasonable doubt, every element. With regard to going, and they held for a rebuttal, this Fermi 3 or whatever party store, corner store, and there's this, she bought some stuff for the house, some wine and these 4 little bottles of whatever, Sutter or whatever. There's nothing illegal about that. When she went in there, I asked, is she sober? Is she okay? Yes. Would you sell to somebody under influence? No, thank God. I'd like to hear that. And okay, so we've got that they brought. And then we've got her going at 11 o'clock to Furnace Tavern. Okay. Did she drive there okay? Yes. Did she have an accident? She turned the corner, go down the road, country road, veer to the right, everything go okay? Looks like it did, or else the officers would be telling us. They're telling us anything. They went and looked at something she bought at 9 o'clock or 9:05 in the morning. So, okay. So if it doesn't exist, that's a positive for my client. Remember that. They're going to bring up every negative there could be with a microscope. That's why there's 2 attorneys in there. We're going to bring up positive or talk about their negative, credibility wise. So, okay, so then she drove at about 11 o'clock to Vernus to meet 2 friends for lunch. She says a sandwich. They say no. Sandwich, you'll see the receipt as an exhibit. Take a look at it. Looks like my client had a better memory on the food part. And so she had the chicken chili or whatever. And she also had 1 glass of wine. And Verna, the person, Kelly Thornton, that came here, and I'm told that she's like really a peppy person, but she was very sick that day. And, she was, and it showed. She did not feel good. And I'm glad she showed under subpoena. And she testified that she was sober. When she came in, she was sober. So if the prosecution is trying to say that she guzzled all these drinks and then went in there, you're wrong. Actions speak louder than words. You can talk all day long. Prosecution wasn't there. The police weren't there. All they're doing is surmising. And they're trying to surmise beyond a reasonable doubt. And they're trying to throw out facts like these two children passed away at a party. Absolutely. I feel horrible. That doesn't make somebody automatically guilty. You have to prove it. We don't go by emotions. So she comes in. The testimony of Kelly Thornton is she's sober when she comes in. It's just normal. She met friends, had lunch, had one glass of wine. Any other wine? No. Anything else to drink? Water. Okay. And the bill, she got the bill. They each got individual bills, whatever was paid by a credit card. Thank God. There's a record of it. Exactly what my client said. And when I first met my client, she said, I had one glass of wine, Bill, at Verna's when we were at Verna's, because I said, what did you have at Verna's? She said, one glass of wine. And, you know, as a defense attorney, you sort of, you listen to clients, but until it's backed up with something, either paper or something, you don't automatically, I hear it. I keep it in my head. I hear it. And then when I see the search warrant that they immediately used, closed it off, nobody allowed in immediately, because she told them, I went to Verna's. Where were you before? Verna's. They went there, they use a search warrant immediately, and they get the receipt. And you'll see that's one of my exhibits. I only have like 3 exhibits, A, B, and C. I keep it simple. And that's one of the exhibits. If you take a look at the defense exhibits, got a little delta or a D in law school. That's what we use. And so that lines up perfect. She's trained, she said, for 20 years. She has regarding alcohol and observing and the effects of alcohol and seeing if somebody might be under the influence, not to serve them. And she didn't. And she felt she was totally fine. When she left, was she fine? Okay. What did she buy? What did she drink extra? Nothing. Okay. So we know that's solid. We know that before 11, it's solid sober. Then we know at 12:15 when she left, solid sober. In America, in Michigan, you're allowed to have a glass of wine. You're allowed to have a glass of wine. And she ate. Okay. And she just miraculously was able to drive home and go through the country road and branch off and turn and take the angle and do all that, not get stopped, not have a collision, not fall off the road and go into, areas that are not the paved road. And she was able to park her car. These are all things of sobriety. That's what we look at. Wasn't parked on an angle. She didn't hit people coming home, hit people, the neighbor. So then she gets home. She's home for a couple hours, let's say 12:15. She goes up to the birthday party at 3:02 or thereabouts. She was leaving 3:01 in the afternoon. So 12:30, 1:30, 2:30, about 2.5 hours. Then they say there are proofs, well, and they wait that video. They wait until rebuttal, not their case in chief. So I don't know what was in their mind. That's up to you. I don't know if they thought that maybe it's not as strong or doesn't make sense, but they waited till rebuttal. That's up to you. That's your area. That's your bailiwick. Okay? It's all about credibility. And so that's when they bring up and say, well, look at what we found. Look at what, we got a video here. Let's call, the officer back up here and talk about a video that shows that she's walking around. Okay. She's got that, whatever. And, maybe she's drinking. Okay. All right. And then she's not falling down. She's not tripping. She's not dropping things. But, maybe she's under the influence. Well, maybes don't convict. Maybes not beyond a reasonable doubt. We don't do that here in America, maybes. We don't send somebody away. Murder too. Maybe. Okay, so then this collision happens. And you say, you know what? That was just crazy. Okay, you're right. It was crazy and completely out of character. Somebody's never had anything. And that makes me think that something neurological, that there's been talk, and that she went back while driving out of the driveway and went in reverse. She hit, and then hitting the arm came back and went full speed ahead. And they're saying, the prosecution, for a murder too, that she intentionally did this, that she had this intent, this reckless intent to kill somebody. Okay. Former Commodore. Reckless intent to kill someone. I swear, and I swear, there's no intent to kill anybody, much less two little kids. There's no intent to hurt anybody. Why would you put it to the floor? Why would that person testify that it's brake and gas for a second there? Both. Where'd that come from? So, you know, when I'm working on this, I put a lot of days and hours in. When I'm working on this at my office, you know, I'm looking at just don't make sense. Out of nowhere, somebody's going to put it to the floor. Somebody's going to put it to the floor and go right into a building that's 450 feet from her house. She's a former Commodore. She lives on the street, lived on the street forever, married, you know, whatever, long time. So they're
That band equipment that Judge Nichols says. Good?
Judge, and people don't understand, the court reporter has more power than the judge, because when that goes out, the judge has to stop too.
That's true.
I know. That's why I always treat them with great respect. This sort of lost there for a second. You know, put it to the floor, and she's going to, they would say, is that she intentionally caused this recklessness. She intentionally wanted to go into the building. I don't know where that comes from. I have no idea. Yes, I understand what the video shows, but an intent to do that, that's insane. That's crazy, with all due respect. So then, while I'm working at my office and I'm going through things, we start getting voluminous records. And, you know, you were told it was, I don't know, I thought it was 200 pages, but he says more like 300 pages, you know, of going through all the records of the state of Michigan and their history and their certification.
Okay, the verdict is in. We do not have that much time left of him and his closing, so I'm going to fast forward him a little bit here, and then we'll go straight into the courtroom for the verdict.
Machine and this and that, and also all the records of acetone and all the other things that show up. And it's interesting that, and this is real pivotal part of the case, is you want that blood to be as pure as humanly possible for testing. Why? You got murder too, 2 charges. You have other charges that are extremely serious, under the influence causing serious injury. These are all very serious charges, very serious felonies. So you want everything right on the money, absolutely as perfect as human can be. So why would I not? It doesn't cost a penny, and you do it every day with drunk drivers. As a road patrol officer, why wouldn't you take him to the station? Get a breathalyzer blown. It's also closer in time. Have that done. Doesn't cost anything. Then you got the data master, whatever they were using back then, the breathalyzer. Okay, you got those results. They print out right then and there. not an hour, right then and there, immediately near blowing. 2, to confirm the first. If they're too far off, a third. Why would you not want to do that? Number one, you've got fatality. Okay. Number 2 is why wouldn't you do, and he talked about a urine test. I'm not saying you got to do one of those, but at least a breath test, but you could do a urine too. That's what the law says. That's what that DI 177 that he talked about, that he read, which means the right to refuse it, that you can take all these things. My client says, yes, sign. You don't even need a warrant. They got one anyway. I'll sign. You can take whatever blood you want for testing. Does somebody guilty do that? Does somebody feel guilty do that? Somebody's scared and they're under the influence. Do you do that? And I'm talking about to be a 1A. Does somebody sign and say no? Or yeah, go ahead and take my blood or my urine or whatever? No, I don't think so. Again, we can use our common sense on this. So they do that and they wait, a couple days and take it to Lansing. And then I'm very thankful they have a video of the person drawing the blood. And you know what? That speaks for itself. All of you saw that. And that's why there's 12 ultimately, because sometimes you catch something somebody else didn't catch or whatever and talk about it. And what's really great is you can ask for those videos from the bailiff to the judge for any of those videos. And they'll be, the judge put together a very nice exhibit list of the videos. So you don't have to look at all videos. You can pick out what you want to see, which is good. And so you'll be able to see, did she shake it? Did she invert it 10 times? Because it doesn't cost anything to invert it more than once or twice. But I sort of, with all due respect, I sort of got the gist from her that she was okay with the prosecution. But if I started asking her anything, it started went downhill the attitude-wise. I don't know why, but I have no idea. I thought I treated her very nice. But it just seemed like she was not happy to be here anymore. And all I did was ask simple questions. But that's up to you to judge that, because you can judge credibility, attitude, truthfulness. You can do all that. That's what you are. And so when I started asking her, well, whatever, and she said a few times, whatever, and then I said, well, the video showed 1 or 2, it was done. It wasn't even done like that. She said, yeah. Okay, so, sort of truth serum comes out when you tell somebody, well, there's a video and it says this. What do you think now? Well, again, it was 1 or 2 times. Okay. So that's done. And the preservative is extremely important. Why I'm hitting this so much? Because that's their case. Again, that's why I said, why not take a breathalyzer? And that. Nobody says not to do that. If you're going to do blood, do it correctly. It's very important. So it sounds like she does, like she said, hundreds of thousands or whatever it was, and she just, it's another day here, whatever. Well, there's 2 murder, 2 charges, by the way. So that's done. It's packaged and it's driven up a couple days later, whatever it is, and it's tested. And testing it, and they agreed. The toxicologist or whatever said, your test results are only as good as what you're testing. If it's polluted or it's not good, then your results are not good. Yes, they can come in all day long and give sworn testimony and say, it was a point at 1A. I don't doubt that. I don't doubt that that was the result. But how did you get the result? Was there a problem with the fermentation? And something that really sticks out, other than, well, you didn't shake it, so there was fermentation, and here's Bill Clovis, he's coming up with something off the wall, that it's too many maybes there, and it won't overcome beyond a reasonable doubt. No. We've got proof positive, very thankful, that they have proof positive of a graft. I want you to take a look at, I believe it's Defendant's Exhibit C. I believe it's C. I only have 3. So take a look at that, and it'll show that it's more than a little bump. Take a look at it and see if it goes up like this. Acetone. That gas came out. And then they'd have you believe that the state of Michigan says it's okay to have acetone. It's all right, that commercial cleaner. A little bit of that doesn't hurt you. Insane. Can we come up with something better than that? But it's okay. Nobody gets hurt by that. Oh, okay. Have you done ever testing on live human beings with acetone? I don't expect to have, at least this generation. So acetone, and then my person, who to me came across very professional, very, in my opinion, you're the judging on the credibility of people, was sharp. He was credible. He wasn't sarcastic. No matter if the prosecution or myself asked questions, he was honest. And acetone, he said, nail polish remover. That's what acetone it's made up of, industrial solvent. And what happens is nobody says anybody put that in a blood sample, but it occurs through fermentation. It occurs that way, or something was polluted. The needle before it went in there had something, a microbe or whatever. We don't know. But I don't care how it got there. It shouldn't be there. It shouldn't be there at all. And if it's there, it just spoiled the results. These results are supposed to be positive and clean and accurate. Accurate, in my opinion, here's a fact. Accurate, in my opinion, accurate is out of 100%. If you can get it up to like 95, that's accurate. If you start going below that, there's a problem there about accuracy. It's not 51%. To me, that's not accurate. Okay. again, we draw it back to murder two charges of murder two, and operating under the influence causing death, and operating under the influence of causing serious injuries. Counts there. Alcohol has to be right on the money. And I know I repeat a couple things just because of the seriousness of this case. Please excuse me. Where's the breathalyzer? Wouldn't it cost anything? Wouldn't have it been amazing if the breathalyzer said 0.01 or 0.02 and they're claiming 0.18? Boy, they'd have a lot of questions to answer. But you know what? The less testing you do, the less tests you have, the less defense attorneys have questions to. Right? Right. So we don't want to have too much. Plus, remember, they're the ones in charge. You can't say, you know what? I want to go here. I want to go to a doctor. I want to have this or that. You can't say that. Why didn't they have the hospital do it? They had insurance. Why didn't they have the hospital draw some blood? Just for the heck of it. They didn't have to worry about transportation, fermentation, nothing. Boom, it's done. Oh, by the way, I forgot about refrigeration. And it's supposed to be refrigerated. Might have an expiration date, but milk does too. And if you put it outside, not refrigerate, guess what? Who cares about the expiration date? It's spoiled. Spoiled milk is the fermented. And that's literally, it causes curds and stuff. I left some too long in my office and it stunk up the office and the refrigerator. Baking soda had to be put in. So, you know, fermentation is a very strong animal. It's very strong and it's aggressive. And you don't want that because you got all these serious charges, including murder too. I want to know, if I was on a jury, that everything is properly done and there's no question whatsoever. And beyond a reasonable doubt, it's pretty close to that. That where we're at is that there's no question that it's there. All the elements are there. Everything was done properly. If things were not done, that the seriousness of what occurred, I can't say not guilty. That's not fair. That's not what the law says. The law says for you to do your job, do your duty as a citizen, as a sworn in juror. And that is, if you feel that somebody's not guilty of all the elements and the people have not proven it beyond a reasonable doubt, all the elements crystal clear, then your duty is to say not guilty. And you say, oh my God, these people are going to be mad, or they're going to say this. No, you don't do that. In America, you rule, just like the judge has been ruling. He rules. You rule too when you deliberate. Please. Your decision is going to affect my client's life. And I know by looking at all of you, and I've had a few trials over the years, that you've taken this very, very serious. Very serious. I truly mean that, or else I wouldn't say it. I've had a few juries, and actually, honest to God, some people will start nodding up. They'll start going to sleep. And it's like, I got to speak real loud to wake them back up from over here. And that's sad. That's really sad. And this was supposed to be a long trial initially. You know, picking a jury, you don't know if it's going to be 3 hours or 3 days. And we moved along very well. And everybody came across very honest. I think that's how we were able to do it. Plus, the judge is really good, if you haven't noticed, about keeping us reined in and moving the case along. I love that he starts at 8 o'clock, because I've been in other places at 8:30 and they show up at 11, the judge. So this one I can count on. That door's going to open at 8. And that's good, because it's taken a lot of time out of all of our lives, but more importantly, we do this for a living, out of your life. And I truly want to say thank you. And I truly say thank you for being here, for uprooting your whole lives. I don't care if people are retired at home, you're still uprooting your life. And lastly is that we've put such a heavy burden on you. We have a very heavy burden on you when you make your decision. However you make your decision, I will respect it. But you've got a heavy burden and everybody has to go on living. But I want to thank you again for taking the time out to be here. There's areas I didn't cover just because you listened to everything. You saw everything, the testimony, videos, exhibits. So I'm not going to go through every single piece. I've gone through enough, but it's my one time. I don't get a second time. If he does go up, Mr. Lorraine or whomever, please try to think what Bill Clovis or the defense would say encounter it. Okay. Thank you very much again. I appreciate your time today.
Thank you, Pastor. Brief rebuttal. Absolutely. Folks, I don't have a long pre-planned rebuttal or anything like that. I'm sure you're happy to hear that. Just like to hit on some things Mr. Clovis spoke about in his closing. Why didn't we play those videos and bring the Fermi clerk on before rebuttal? Because that's not how the prosecutor's office proves drunk driving. We prove drunk driving through the blood result. Once Mr. Clovis wanted to challenge that, I have what I believe to be other evidence of alcohol consumption. I'm going to play that for you. I'm going to show that to you. If he hadn't presented a case, I wouldn't have presented that evidence because I had a blood result. I agree with him that actions do speak louder than words. Her actions at Vernus. But that's the testimony of a waitress who saw her for a minute at 11 o'clock
I think she testified about 3 times that she did not see her leave. Countered with the testimony of a bartender who saw her immediately after the crash, and 2 police officers who dealt with her. Police officers specifically trained in spotting alcohol consumption. I also agree with Mr. Globus that maybes don't convict. They do not. But you know what does? Lab results, videos, injured people, and deceased victims. The intent in this case was sealed the second she put that car back in drive and continued down the road. He characterized it as intentional recklessness, but it's exactly what is written in the jury instruction. And look at that. It is creating a situation. Once she starts to back out of her driveway with that blood alcohol content, that's the beginning of it. If she had run someone over right then and there, that's OWI causing death. What she did, that's second-degree murder. She knew from that second she was dangerous. She was in a situation where she was creating a high risk of death, and she continued on anyway. Mr. Clovis talked a little bit about beyond a reasonable doubt. The judge will explain to you what beyond a reasonable doubt is. What the jury instruction says is it's a doubt that grows out of reason and common sense. It's a doubt that grows out of the evidence or the lack thereof. So again, as I did in my opening statement, on behalf of the victims, on behalf of the people of the state of Michigan, when you go back in to deliberate, I ask you to look at everything, speak amongst yourselves, deliberate as you see fit, and when you're finished, find this defendant guilty of 2 counts of second-degree murder, 2 counts of OWI causing death, and 5 counts of OWI causing serious impairment. Thank you, folks.
Okay, let me pull up the verdict. I was thinking the judge might have said something. We might have gotten something new from him. Oh, well, here's something that's strange. Fox doesn't have it yet. That is weird. They haven't released it yet. Okay, hang on. That's not our only option, though. That's just the one that we've been relying on because it's been the best. I mean, I kind of like seeing them talk to the jury about going into deliberation and all that stuff, you know? It's just me. I don't know. I like things the way they were. All right, here it is right here. This is only a 6-minute video. Why do people always text me when I'm in the middle of something? A little something, something. All right. Stop screen share, present screen. I think a while ago I had to reshare, and that's why it wasn't coming through. This should be good. Can everybody see and hear it?
All right, ladies and gentlemen, welcome back. I'm told that you've had a verdict. Is that correct? All right. All right. You're the foreperson? Yep. Please sit for me and read me the verdict form. You're going to say, "We, the jury, find," and then you'll go through each count, please.
We, the jury, find as follows. Count 1, guilty of murder in the second degree of Alanah Phillips. Count 2, guilty of murder in the second degree of Zayn Phillips. Count 3, guilty of operating while intoxicated or operating while visibly impaired, causing the death of Alanah Phillips. Count 4, guilty of operating while intoxicated or operating while visibly impaired, causing the death of Zayn Phillips. Count 5, guilty of operating while intoxicated or operating while visibly impaired, causing serious impairment of her body function to Mariah Lynn Dodds. Count 6, guilty of operating while intoxicated or operating while visibly impaired, causing serious operating while intoxicated or operating while visibly impaired, causing
I
serious impairment of
apologize.
body
I
function
apologize.
to Diane Virginia Medina.
I knew life wasn't that easy that I could just have it done and it wouldn't be a problem. This always happens to me on every verdict. If you've ever followed me, I always have issues.
All right, ladies and gentlemen, welcome back. I'm told that you've had a verdict. Is that correct? All right. All right. You're the foreperson?
Yep.
Please stand for me and read me the verdict form. You're going to say, "We, the jury, find," and then you'll go through each count, please.
We, the jury, find as follows. Count 1, guilty of murder in the second degree of Alanah Grace Phillips. Count 2, guilty of murder in the second degree of Zayn Phillips. Count 3, guilty of operating while intoxicated or operating while visibly impaired, causing the death of Alanah Grace Phillips. Count 4, guilty of operating while intoxicated or operating while visibly impaired, causing the death of Zayn Phillips. Count 5, guilty of operating while intoxicated or operating while visibly impaired, causing serious impairment of a body function to Mariah Lynn Dodds. Count 6, guilty of operating while intoxicated or operating while visibly impaired, causing serious impairment of the body function to Edward Thomas Smothers. Count 7, guilty of operating while intoxicated or operating while visibly impaired, causing serious impairment of the body function to Jaden Bryce Phillips. Count 8, guilty of operating while intoxicated or operating while visibly impaired, causing serious impairment of the body function to Leah Marie Stiff. Count 9, guilty of operating while intoxicated or operating while visibly impaired, causing serious impairment of a body function to Diane Virginia Medina.
All right, thank you. If you would put that back in the envelope and then just give it to my bailiff. Is this everyone's verdict? Yes. So say you one, so say you all? Yes. Do you wish me to poll? All right, I'm going to point at you. I'm not being rude.
Are you serious right now? Oh, you guys, I'm so sorry.
I just don't want to publish anybody's names. Okay, so I'm going to start in the back row and say, is this your verdict? Is this your verdict?
Yes.
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 Is this your verdict? Is this your verdict?
Yes.
I'm going to come all the way here. Is this your verdict?
Yes.
Is this your verdict?
Yes.
Is this your verdict, sir?
Yes.
Is this your verdict?
Yes.
And is this your verdict?
Yes.
All right, thank you. Ladies and gentlemen, I want to thank you for your hard work. I know that you worked hard all week. It's a long, exhaustive process. Takes it out of you physically, it takes you out emotionally. We really respect and appreciate your hard work. I'm going to ask for one more little favor, and if that is, you would go to the jury room and wait for me for a second so that I can come in and talk to you for just a second. Ms. Keene, would you come around here and join them as they go back into the jury room? All right, thank you. I'll talk to you in a second. You can come, yeah, go ahead.
Do we finally get tears? Do we finally get some kind of emotion out of her? I think she is crying, y'all. I didn't hear when sentencing was. Did you guys?
All right, Ms. Chidester, you've been found guilty by a jury of your peers, 2 counts of second-degree murder, 2 counts of operating under the influence and causing death, and 5 counts of operating under the influence causing serious bodily injury. You are to be sentenced in these matters on May 15th at 3 p.m. That will be in this courtroom with Judge Nichols' permission. You are remanded to the Monroe County Jail pending sentencing. We are adjourned.
You know what's odd? Odd is her husband's not even there to see her off. She had, oh, good point, Barry. She had her coat on like she was expecting to leave. Well, they might have been outside. She probably went to her car to drink. Seriously. Now we see. Now it's coming out. Oh my God, she's having to walk past all of them. Oh, wow. Oh, that was kind of a dangerous thing, but I'm glad that they made her do that. Oh, what do you guys think about that? About her walking through past the family? Old courthouse design. Yeah, I guess so. Yeah, perp walk. She could have. She could have. But you know what? Mm, I just don't even know, you guys. Well, I kind of like the way it all worked out today, that we had pretty good timing and it wasn't exact, but it was pretty good. If we had started later, I would have been panicking that the verdict came out when it as quick as it did. But I think we kind of knew. Didn't we all kind of know it was going to be guilty? I mean, did you guys really have any doubt in your mind that it wouldn't be guilty? Why do you want me to rewind it? Oh, you're telling somebody else to rewind it? Go back. She said so sorry. She said that? All right, girl, hang on. Let's go back to the perp walk. She did, didn't she? She looked at her. She didn't say I'm sorry. She didn't say I'm sorry. Where'd you see that, Cheryl? I thought I heard somebody say sorry. I heard somebody say it. I thought I did hear it, but I don't think it came out of her mouth. Because I was watching her complete. Let me do it again. Hang on. Let's rewind it again. I was watching her mouth to see if she said anything. But then again, I don't think she said anything. Do I need to play it again? Let me see what's in the chat here. Someone said it. I thought someone said something like that, or maybe is she going to say she's sorry or something like that? No video again. Are you flipping kidding me? You guys, I don't. Hang on. I'm so frustrated with my computer. It's not me, it's the computer. And I will tell you, you guys know, I'll tell you if it's me. Can you see it now? You can see that, can't you?
All right, ladies and
I know,
gentlemen,
it just
welcome
frustrates
back.
me.
I'm told that you've had a verdict. Is that correct? All right. All right. You're the foreperson?
Yep.
Please see for me and read me the.
You can see it now, right? No? Jesus. Manesis. All right. On my side, it says you, on my side, I see it. So it's like, I apologize that I didn't know you couldn't. Shut up, Mark. See, her face doesn't look like she can she doesn't even look at her. But I kept watching her mouth. And when I heard it sounded like somebody said, I'm so sorry. She mouthed, I'm sorry. I did not see that. I must be crazy. Yeah, all of a sudden she can walk, right? All right, one last time. That was it right there. Ooh, that sounds awful, doesn't it? I'm sorry, but I don't think she said it. Lady in green. Yeah, the lady in green said something. It's like really soft. Someone else said it. Okay. Yeah. I didn't think she did. I told Mark to shut up because he knows he gets so tickled when I get flustered. She just thinks it's so funny. He's over there giggling his little ass off right now. I apologize. That got mixed up, y'all. That got messed up. I didn't hear him talk about bail. She didn't say anything. Yeah. So anyway, I guess that's it. I was reading y'all's chat, trying to catch up with what y'all are saying in here because I was messing with the video. I think I'm just going to break down and buy a new computer, buy another laptop. I've got two and a desktop, but I think I'm going to buy another one because each of them have issues. What'd you say about the lady in green? Let me go back real quick. Oh, the lady in green says something. I see who you're talking about. Well, you know what? I have to say something. That mother has so much class. She has absolute class. And she held it together because I don't know if I would have been able to, especially if they walked that woman right in front of me like that. So they'll put her in there until sentencing. I was wondering about whether or not they would. I'm sure. What you guys want to bet money? Her attorney's going to try to get her out on bail until sentencing. I bet we hear from him on that. Oh, it's okay, Cheryl. I was just I thought I heard it. I thought I heard something too. So I was thinking we needed to go back and look at it anyway. Yeah. Well, when you got on headphones, it's easier to hear it. Cass said, I'm the one that said it. Yes, she did. But bless her heart, that's all she did. Come on, if you'd have been in the mom's position, would you have been able to just stand there and watch her walk right in front of you like that? This will be her first 60 days dry. Yeah, she's not going to do that great in prison. She's old. I don't know. Do they have you think when somebody that her age comes into prison, don't you think they kind of keep them in a space that would be safer for an elderly person that's never been in prison before? They kind of work them into the system a little bit. You'd think. I don't know. Barry said that mom has dignity. Yep, she does. She did so well on the stand too. I just have so much respect for her because I just don't think I could have done it. They have an elderly section in Florida. They have a 55 plus community in the prison too at Florida. In Florida, that does not surprise me. Senior citizen sales. They might, Mark. I don't know. They might. Donna declined because she's youthful. Y'all, I'm gonna tell you, I've got so many things going on right now. Oh, by the way, we need to jump over while y'all are still here. Let's jump over to this Morgan Geiger thing or Geyser, whatever her last name is, and watch this case because I've been wanting to watch it. But I'm gonna shut down my computer on one side before I do it. So anyway, I was gonna go and try to watch. What's her name? Donna Adelson. I just can't. I just can't get into it. Oh, you guys, the WTOL had longer coverage. Let's just see something really quick. They had like 14 minutes, whereas Fox 6 only had 11 minutes. Just really quickly. And then we'll switch over to the Morgan Geyser thing. I know it's not up yet. I haven't put it up yet. Now it should be up. Oh, there we go. Can you see it now? Now my StreamYard's acting up. Okay, thank you so much. I just wanted to see what happened here. See, I bet you money she was outside in the car drinking while they were waiting. If I was going to be sentenced, I'd be outside smoking a cigarette and drinking a Diet Coke. I'd have to have a Diet Coke. I'll turn on the fast speed until she comes in. I just wanted to see if we miss anything. Seemed like Fox was cutting a lot of stuff out. I'm so glad the family didn't have to wait around for the verdict. Don't they say usually when it comes back that fast that it's usually going to be a guilty verdict? Laura said in Illinois, when they go to verdict watch, they are not allowed to leave the courthouse until the jury is dismissed. Ugh, that would suck. They better have a cafeteria. I'd be at the casino. I would too, Mark. Okay, we have a presser. Okay. Thank you, Denny. I'll get to that too. Thank you so much. Oh, yeah, I was actually right about something for once, Northwest. Thank you. Thank you for giving me that credit. I appreciate that. I needed that little pat on the back. There she is. What's in that water? Marshella. This is WTOLL feed, so we'll go straight into the. Looks like we didn't miss anything. I want to see what he says to her, though. You guys think she knew that lawyer and that's why she hired him?
All rise. Always back in session. Maybe seat.
People of the state of Michigan versus Marshella Chidester.
All right, ladies and gentlemen, we have a verdict. I know this has been an emotional case, one of the most emotional cases that I've been involved in, but we're still in a court of law. You guys have been great all week. The media has been very unobtrusive all week, and I appreciate their efforts. But remember, once the verdict is read, we're in a court of law, and we would act accordingly. All right, Bill, if you can bring in the jurors.
I think she will at her hearing, her sentencing. Oh yeah, I think she'll apologize. She did it on TV. If she, she does it for show or whatever. Hey, Marilyn, by the way, welcome in. Oh, Curtis. Yeah, I remember that one. We're going to go to the press conference. I just, here, let me find it. I was just wanting to see if we, I shouldn't have done that. I shouldn't have done it. I meant to do this. Boom. Boom. Live. Prosecutors hold press conference. All right. Before I make sure I got the feed, you guys can see it now? Still can see it? You're good? She's going to detox now. Yes, you're going to have to.
Oh, yeah. I figured they were.
How long did they take, Cass? It wasn't. Well, they went out at 2:00 their time, so 2 hours, enough for them to fill out the paperwork. Okay, now that I know you guys can see it, I'll fast forward to when we get there. There it is. Sure, I got it turned up. Got it turned up.
Let's try.
They did a great job.
Good afternoon, everybody. My name is Jeff Yorkie. I'm the Monroe County Prosecutor. I want to thank everybody for coming in today. I have a few points that I want to make, a couple of brief statement, and then I'll open it up to questions for the attorneys and any of the law enforcement officials that are here today. First of all, I want to start out by saying that we are obviously satisfied with today's verdict. We're very pleased with today's verdict. Well, we appreciate everything that the jury did here today. We think that they did a phenomenal job in evaluating all of the evidence, and we're obviously happy with the way it's turned out. That said, there's never any winners in a case like this. There's nothing that we're going to be able to do to bring back Zayn and Alanah, or to be able to heal the physical and mental damage done to the people that were present at that birthday party last year in April. That said, I also want to thank all the first responders, though, because their quick action prevented this tragedy from being worse than it already was.
And I also want to thank the amazing work that Sheriff Goodenough's team has done in this case. I want to thank them for their professionalism, the excellent work that they did in providing us with the evidence that we needed to effectively prosecute this case. Specifically, I want to thank Detective Modelinsky and Sergeant Hooper, who were instrumental. Sergeant Hooper, unfortunately, isn't here today. But Joe Hammond is here. He's our undersheriff. He's helped to coordinate all of this, all of the work that the Sheriff's Department has done, and we just would not have been able to do it without them. I also really want to send a shout out to the State Police Crime Lab for their professionalism and assistance, and specifically Tabitha Faust. She testified today and yesterday and did an absolutely phenomenal job, and I thought it was very important to point that out. Finally, my team, led by Senior Trial Attorney Ken Lorraine, my hat's off to the hard work that was put in by Mr. Lorraine, along with Assistant Prosecutor Chris Marriott and Alexis Hatch. Their job is to distill all the evidence and then break it down and present it in a clear and concise and a cogent manner for the jury to be able to understand the theory of the case. And they just did an unbelievable job of doing that. I could not be more proud of the job that they've done, but they could not do it alone. I have a couple other special shout outs to some of the people that work in our office. Missy Nichols was instrumental in putting a lot of the media together that we showed at the trial. Brooke Bazinski did an amazing job of coordinating the over 30 witnesses that were called in this case and making sure that they were ready to go at the appropriate time in order to keep this case moving along. And that's really important for the jury. And finally, also want to thank our victims' rights coordinator, Allie Horkey. She and her staff do an amazing job in a case like this that is as difficult emotionally to have to deal with on behalf of these victims. She does an amazing job with them, and we couldn't have done any of this without the hard work that they put into this, along with the rest of the staff in our office. They've been on the ball for months while we've been working on this case, and we couldn't have done it without any of them. So that's all I have. I want to thank you guys for coming in, and I'll open it up to questions.
Sounds pretty solid that there's going to be an appeal. Are you ready for that?
We're always ready for an appeal. We've been talking about it from the very beginning. When we prepare for a case like this, we're thinking about appeals. We're thinking about appellate issues, and so we consider that stuff as we develop a case and get ready to present it. We didn't. I know that Judge White did. And we'll probably, I would love to talk to the jurors about this, but we have not spoken to them. No. Anybody else? That's a loaded question. Am I surprised? No. We put so much work into this case, and honestly, these three attorneys behind me did such an amazing job of putting it together and making it so that this jury could understand exactly what our theory of the case was and how all of the facts that were presented fit into that theory, that I'm not really surprised that they were only out for a short period of time.
Can you talk about the strategy of holding the in-home video as well as the receipt from the store getting the bottles of wine? Why holding that to rebuttal instead of bringing it out?
Well, we talked a lot about that. In fact, I'm going to defer here to our lead attorney on that, because he was the guy that really saved the day on that one. He was the one that made the case, and I said, okay, go for it. So Ken, if you want to touch on that.
It's no different than what I told the jury in closing. It wasn't strategic at all. I've done many drunk driving trials over the course of my career. I've never proven a single one of them by trying to track down every drink that the defendant had before they drove. I've always proved it with a blood result, That was what I wanted to do here. Mr. Yorkie agreed with me. Mr. Marriott and Ms. Hatch agreed. So that's what we did. But when he opened the door to trying to say it was just one glass of wine in a chemical process that caused her to have a 0.18 BAC, then I felt it was appropriate to give to the jury the other evidence that she had given us, essentially, mostly from her surveillance camera, that she had consumed more than just one glass of wine.
Clovis said as part of his appeal, part of the basis is going to be that there was evidence presented to the jury that he thinks should not have been presented. Can you respond to that?
Well, we believe that the judge made all of the appropriate evidentiary rulings, and we're satisfied that the Court of Appeals will feel the same way.
Mr. Yorkie,
Yes.
you have an incredible team, and you've all been working on this for a very long time. Do you want to share with us some of the hard work that you've mentioned people have done, but individuals have done, but as a team, you seem very cohesive?
Well, what we do as a team is we have a group that is primarily responsible. In this case, it was these three attorneys behind me were primarily responsible for getting this case together. That said, we know when we get a case like this that there is going to be a lot of evidence that we're going to have to wade through, and because of that, we know that other attorneys and other staff members in the office are going to have to carry some of the weight, some of the load that these guys ordinarily would carry themselves. And I think that we've fostered an attitude in our office where everybody really wants to work as a team. We all take great pride. If you watched in the gallery during the course of this trial, many of my staff members, when they had a moment, they were in there watching this case because they know that they had a hand in it. And I couldn't be more proud of all of them.
Going back to those videos for a minute, it struck me as unusual. Normally when you see security camera videos, they're taken in from the perspective of the person who owns the camera is the victim of the crime. In this case, the person who owns the camera is the perpetrator of the crime. Have you ever seen that before, where someone's own security camera video turned out to be incriminating against them?
Well, to be honest with you, just thinking about it right now, this is the first time I've ever thought of that. And honestly, I can't think of an instance where something like that has occurred. But, and a lot of that credit goes to law enforcement. These guys did an amazing job. They didn't just, they were able to get that surveillance camera, but then they got the neighbor's surveillance camera, and that requires some police work. You got to go around and ask about who's got what, and these guys did an excellent job of that. They provide us with the evidence, and we couldn't do it without them. Sheriff Goodenough and his team, they did a fantastic job, and I couldn't be more proud of what they've accomplished and the information, the evidence that they gave us. All right. If that's all you guys have, I want to thank you again for coming in. Thanks. Thank you very much.
You sure you guys don't want to listen to her attorney talk? I could go find one. I'm sure he took an interview. Forget that. We're going over to Morgan Geyser's thing. I just got to put it in real quick. Bear with me. Please hold. They've got it up on Court TVs. Oh, Law and Crime's got it too. Do y'all want Court TV or do you want Law and Crime? Court TV has better audio. I don't know if they're on a break right now, but they've been in there. I can see it's already been going on. Now I can share it. Here we go. We want to go about right here.
They include Aaron Graff here.
All rise.
Okay, give me a thumbs up. Let me know
Thank
if y'all
you.
can't
Please
see or
be
hear it.
seated.
Court will call the matter of State of Wisconsin versus Morgan E. Geyser, case number 14 CF 596. Appearances.
Thank you,
Good
Nana.
afternoon, Judge Abby Nicolai appears on behalf of the state.
Good afternoon, Judge. Morgan Geyser with Attorney Anthony Cotton. She's here in person.
All right, thank you, and good afternoon, all. We're here on the review of the court's petition, the order to proceed with conditional release, and then the petition filed to revoke that order. So how is the state calling a witness? Or how should we proceed?
Judge, given today's scheduling was primarily based around the 3 doctors' schedules, I would suggest that we perhaps start with their testimony because I know that they were all available today and I believe they're all on Zoom. And I know that the court had questions for the doctors. So that would be my proposal.
Well, should we introduce the petition though, of why we're here?
Sure.
We have the petition for that seeks to revoke the conditional release.
Right.
Is there a witness here to testify about that?
I have several witnesses on the state's burden, none of which I anticipated including any of the doctors.
All right. Well, I think we should put the petition into the record officially so we can have individuals comment on it. So who is calling to authenticate it?
Well, I have this afternoon, I plan to elicit testimony from Nicole Whitaker from WCS, who helped author some of the information, as well as Kathleen Martinez from the Department of Health Services. And then there's also a witness on Zoom who is part of the defendant's treatment team from Winnebago, Lisa Portman. I was going to have testimony from all of those individuals in regard to the information that was filed in document 655, the petition to revoke conditional release.
Well, it was signed by the amended petition that they filed most recently was signed by Nicole Whitaker. Is she available?
Yes, she's here, Judge.
Well, we should have her then be the one that introduces it so we have it in the record.
Okay. She did sign that memorandum. The actual petition to revoke the conditional release is signed by Erin Graff from the Department of Health Services, who's also here. The WCS memo was included underneath that petition as a factual basis. Ms. Graff is also here, as is her supervisor, Ms. Martinez. So however the court would like me to begin, I can do that.
Well, I'll allow you to decide how to begin. I just wanted to get it in to the into the process. I'm just looking for it. I have the statement of probable cause for detention and petition for revocation of conditional release. That was filed in court here on February 27th. And that letter is signed by Nicole Whitaker as well. The reason we're here is they filed a petition.
Right. I did not mark the petition as an exhibit. Because it's already in the court record, I apologize. Perhaps I should have done that.
Well, we'll use it as Court Exhibit 1.
Okay.
And who, I guess, should Ms. Whitaker be the witness that comes in?
She will be one of my witnesses, yes.
Well, let's call her and she can identify it so we have something to proceed with.
Sure. I'd call Nicole Whitaker.
Ma'am, if you'd come forward, have a seat behind the court reporter. We have an exhibit tag for that. And then, ma'am, if you'd stand, remain standing, raise your right hand. Do you swear that everything you're going to testify to today is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, thank you. You may be seated. And then state your full name and spell your last name.
Nicole Whitaker. My last name is Whiteaker.
No, we're missing, excuse me a moment. We're missing sheets. What I've done is I've copied the petition and marked it as Court Exhibit 1.
Thank you, Judge.
All right, thank you. I'm just going to give you now what's marked as Court Exhibit 1.
Thank you.
And then I'll turn over to Attorney Nicole.
Thank you, Judge. Ms. Whitaker, where do you work?
I work for Wisconsin Community Services.
And what do you do there?
I am the Conditional Release Program Supervisor.
What does that mean? What are your duties?
I oversee a team of people who are overseeing participants who are released into the community under conditional release.
Did you become involved in preparing a plan for Morgan Geyser in this case?
I did.
And did you begin to prepare that plan in this case?
I did.
Ultimately, did you write a memorandum with some information in it that was filed with the court?
I did.
And you've been handed Court's Exhibit number 1, is that true?
Yes.
Is that a multi-page document?
Yes.
What's the date of filing on that document, please?
February 27th, 2025.
Okay. And do you recognize that
I
document?
do.
What is it?
This is the 5177 petition for revocation.
Is there information in that petition that you generated?
There is.
What information is that?
I generated a portion of this that are numbered, and that comes out of case notes that were done after meetings with Ms. Geyser.
Could you refer the court to a page number where your content begins?
Mine is not numbered, but I'm on the 4th page.
Okay. Is there a WCS logo at the top left corner of that page?
There is.
Okay. On the final page of that exhibit, is your electronic signature there?
Yes.
Okay. Why did you compile the information in this memo?
We, as a treatment team,
I'm going to object to her testifying as a treatment team when she's asked what she was tasked with. doing.
Sustained. Yeah. Sustain the objection. Can we go ahead?
Sure. When, I want to back up a little bit. Did you meet Morgan Geyser when you were assigned to this case?
I met her previously to being assigned to this case.
Okay, and specifically to planning the conditional release plan, did you meet with a team that was tasked with creating that plan?
I did.
Who was a part of that team?
There are several members of the team that include myself, a case manager, our partners at DHS, and members of the Winnebago Mental Health Institute treatment team.
And when you say DHS, are you talking about the Department of Health Services?
I am.
And would that include Erin Graff?
It would.
For the record, is that GRAF?
Yes.
And is her signature actually also on Exhibit 1 that you were given by the court?
It is.
And what part did she play in this filing, if you know?
She filed the 5177.
And she's an employee with the Department of Health Services, is that true?
She is.
Okay. But was she also a part of the team that was helping to prepare this conditional release plan?
Yes.
Okay. And how many meetings do you think that this group had in regard to the conditional release plan in this case?
Initially, the treatment team meets as a whole in the beginning, when a participant's granted conditional release. And then a smaller group meets with the participant on a weekly basis going forward until she's released.
When the group became smaller, what participants were left in it?
Myself, my case manager, the participant, and sometimes her social worker at Winnebago.
Was the social worker always in those meetings in this case?
Not always.
Why not?
There were times that Morgan had asked her to leave.
Was that social worker someone that was recently brought into Morgan's team?
Yes.
Okay. At some point in time during these planning meetings, did reading material become a topic?
It did.
And why would it be important for you in preparing a conditional release plan to know about a participant's reading material?
In the beginning of preparing a conditional release plan, it's really important for us as a team to build rapport and get to know the participant, coping skills, things of that nature. And the purpose of the conditional release plan is to mitigate risk to the community. When we started looking into things that Ms. Geiser liked to do, reading became a topic. To then we inquired about what types of books and things like that.
Okay. At a point in time, did you become concerned about information you learned about reading material that Ms. Geiser was using?
I did.
Why?
Because it is related to the index offense, I suppose.
In what way?
It's violent.
Specifically, is one of the books that you're referencing called Rent Boy?
Objection leading.
Overruled. It is leading, but we all are familiar with these various documents. This will move the hearing along, so overruled.
Yes. And did you have concerns about the fact that Ms. Geiser had read that book?
I did.
Why?
Because it was a dark novel that revolved around murder and the selling of body parts on the black market, along with sexual sadism.
Is that information contained in the material that you put together in Exhibit 1?
It is.
Okay. How did Ms. Geiser react when she was informed the treatment team and conditional release team would be monitoring her reading material?
She was upset.
Did she say why?
She didn't feel it was necessary for the team to oversee things that she used as coping skills and a creative outlet.
Do you consider it an important part of a treatment plan, a conditional release plan, to monitor things like reading material and media usage?
Yes, that's a standard thing that we do as a conditional release team, and it's very individualized to each participant as well as their index offense.
Was that fact relayed to Ms. Geiser?
Yes.
And was she receptive to that?
No, she still thought that it was unnecessary.
Did you talk about monitoring Ms. Geiser's reading material during more than one meeting with her?
We did.
Did her response to that monitoring ever change?
No.
Would it be fair to say she pushed back on that monitoring?
Yes.
Did she ever come around and acknowledge that that would be an appropriate thing for the team to do?
No.
Was that concerning to the conditional release team?
It was.
Why?
Because it shows risk, and the conditional release plan cannot, or the conditional release team, I'm sorry, cannot write a conditional release plan when we aren't aware of the risk to the community.
Was there a point in time when you approached Aaron Graff and Kathleen Martinez with the Department of Health Services about preparing this plan?
Yes.
Why did you do that?
Because things were coming to light that the treatment team wasn't aware of, and I needed to pass that on to other people as she's being released into the community. I can't be the only one harboring that information. The team needs to be aware.
How did you know that the treatment team wasn't aware of these things?
Well, initially I brought it to Aaron and Katie, and they then looked deeper into things with Winnebago.
So that was that discussion and comparing information with Winnebago was not a role that you took on personally?
Correct.
Okay. Are you aware of an individual named Jeffrey Pagels?
I am aware of him, yes.
When you are creating a conditional release plan, is it important for you to know people who a participant is having contact with outside of an institution?
It is.
Why?
There are a number of reasons, risk being the number one. We have to take in the participants' treatment needs, as they're in the community. And so I asked Ms. Geiser, who are the people that she's communicating with on the outside, and that his name came up.
How recently had she had communication with him?
I'm not sure the answer to that. I know that she stated he did send him, he did send her a letter after she was granted conditional release, and she stated that she ripped it up and threw it away.
So at the point in time when you discussed this individual with Ms. Geiser, did it seem like she wanted contact with him?
No.
Okay. Is there information nonetheless about this person in the memo in Exhibit 1 that you wrote?
Yes.
Why? What is included in here and why?
After the team became aware of him, it was during that meeting that Ms. Geiser asked for a no contact. We further looked into things to find out if there was such a need for a no contact and what was the reason. And we found a number of things on his Facebook that pertained to Ms. Geiser that we were concerned about.
And before I forget, I apologize for jumping topics here, Ms. Whitaker. I want to ask you one more question about the book Rent Boy that we talked about.
Okay.
Were you able to ascertain how Ms. Geiser got the book to read in Winnebago?
I was under the understanding that she had got it from the library, but then it later came out that it was sent to her.
How?
Via mail from somebody, I'm not sure.
Okay. Now, going back to, you indicated that there were things, did you do research on this individual on the internet, or how did you know these concerning things about this individual JP?
I did not personally do the research. My lead case manager did, as well as the social worker at Winnebago Mental Health.
And what was anything that was found significant to your assessment of Ms. Geiser's risk to the community or herself?
I'm going to object to that. She didn't do any research on Jeffrey Pagel.
Overruled. Witness can answer.
Can you repeat the question, please?
Sure. Was there any information about this individual JP that was relevant to your assessment of Ms. Geiser's risk to herself or the community?
Yes, but it was also concerning for Miss Geiser. And when we talk about risk to the community, she is included in that assessment, and he had things directly relating to her on his Facebook page. So yes, that was concerning.
What types of things relating to Ms. Geiser was on his social media accounts?
I'm going to object on relevance grounds. And I'm happy to make further argument.
In overruling objection, I think it's relative and probative to the issues that have been raised by the petition to revoke the conditional release from the standpoint that information the person, Mr. Pagels, may have on his Facebook account could be from any place, but it may also involve information that purportedly may have come from Ms. Kaiser. I don't know that, but I wanted to be able to hear that, and that should be part of the record. So I'll overrule the objection.
We found that there were letters and drawings that she had sent him, a postcard, and he was selling them. He was selling the items.
Were you able to see the drawings that he was purporting were from Ms. Geiser?
Yes.
Were they concerning to you?
Yes.
Why?
They were very dark in nature. I would describe it as a horror type picture.
Excuse me?
Horror.
All right.
I want to show you what's been marked as State's Exhibit 1.
Yep, thank you.
Thank you.
Do you recognize that?
I do.
What is it?
It is a drawing that Morgan has done
Where did you get it?
off of Jeffrey Pagel's Facebook page.
Was that one of the items for sale?
Yes.
How was it being was Ms. Geiser's name linked to that piece of art in the sale information?
It was.
Does that look like a fair and accurate copy of the item that you found for sale in this case?
It does.
I'd move Exhibit 1 into evidence.
Any objections? So received.
And Judge, I can either display it digitally or just have the witness hand you the paper copy of it.
You can display it digitally.
Ms. Whitaker, is the Exhibit 1 on the screen in front of you the same as the paper copy that I handed you?
It is.
Okay. And remind the court again what this is?
That's a drawing that came off of Jeffrey Pagel's Facebook page. He compiled a number of items that he was selling as, he called it the Slenderman package.
Okay, thank you, Madam Clerk. Were you able to ascertain how long Ms. Geiser had been a willful participant in communicating with that individual, JP?
I do not have knowledge on how long the relationship lasted or how long they communicated.
Okay. At a point in time, did you learn any information about JP that was concerning as it related to sexual behavior?
Yes.
And what was that?
In speaking, we were very open about this topic with Ms. Geiser during the meetings. You know, as it's a great risk as she comes into the community, and she was aware, and she recalled that he would get sexual gratification from her index offense. And I believe that there were letters written back and forth.
Is that information something that Ms. Geiser told you during a meeting?
She did tell us that,
Okay.
yes.
Is that, as far as you're aware, is that information something that she had worked on in therapy or with her treatment team to that point?
I was not sure.
Okay. Was that concerning that you didn't know the answer to that?
Yes,
Why?
because it tells me that there's an unknown risk.
When you first, strike that. The exhibit 1, you testified that the bulk of the information you included is bulleted with numbers, is that true?
Yes.
Okay. So would it be correct that in terms of creating the conditional release plan in this case, one of your first meetings with Ms. Geiser would have been on or about January 17th of this year?
That's correct.
Okay. During that initial meeting, did you learn what Ms. Geiser's preferred pronouns were
I
at
did.
that time?
I did.
How did you learn that information?
At the beginning of the meeting, my greeting or opening statement was, "Hi, Ethan, how are you?" And she had responded, "JK, I'm going by Morgan, she, her pronouns."
What was Ms. Geiser's demeanor like when she said JK to you?
Very light, aloof, just very casual.
Why did you greet Ms. Geiser as Ethan?
Because I had previous knowledge that she was now identifying as Ethan using him, her pronouns. He, him pronouns, I'm sorry.
In terms of exhibit 1, the conclusion section and recommendation section, is that something that you authored?
I did not.
Okay, who authored those pieces, if you know?
Katie Martinez from DHS.
Okay. And in terms of the decision to actually file this material as a petition to revoke conditional release, was that a decision that you made on your own?
It was not.
Was it even your decision at all?
No.
Okay. Those are all the questions I have.
All right, thank you. Cross-examination.
Do we have a hard copy of Exhibit 1?
She has it.
That's the February report. You have Exhibit 1 in front of you, ma'am?
I do.
Yeah. Yes, she does.
Okay, can I go?
Sure.
Can I see that, please?
Sure.
Good afternoon.
Good afternoon.
This report that you just testified to is dated, what date?
February 27th, 2025.
Can I mark Exhibit 2 here on this date?
Now, are you marking the one that came in on March 4th?
Yes.
I have it already marked as Exhibit 2.
Perfect, can I use that?
Sure.
So what you just testified to is an exhibit from February 27th. I'm showing you Exhibit 2. What's the date on that report?
March 4th, 2025.
The reason there was a second report is because the first report that you authored contained inaccuracies, correct?
Correct.
In other words, you made mistakes.
Not me. It was Winnebago had not given accurate information to DHS.
So inaccurate information was provided to DHS from Winnebago.
Yes.
Then DHS provided that inaccurate information to the court.
Through the filing, yes, that's why we amended.
Okay, well, we're going to make sure we have accurate information today, okay?
Perfect.
So the March 4th report, Exhibit 2, in front of you has certain things that are crossed out, right?
It does.
And just so I'm clear, ma'am, I only want to ask you questions about things you have personal knowledge of that you did. I don't want to get into what other people did, okay?
I just want to note for the record that exhibits 1 and 2 are actually court exhibit 1, court exhibit 2. You may continue.
Yes. So just so we're clear, when things are crossed out in exhibit 2, it's because that was inaccurate information and you're trying to correct it for the record, right?
Yes, but I did not make those corrections.
Okay, so points 1, 2, 3, 4, 5, 6, 7, 8, are those, did you type those line items?
I did.
But in terms of making the corrections, some other person did that.
Right.
Okay, so as I understand it, your job is, well, I don't know that we got into this. What is your educational background?
I have a bachelor's degree in criminal justice.
Okay. What else?
As far as my education, I have ongoing mental health education through, employment. I've been working in the mental health field over 17 years.
Okay, so you have a bachelor's degree.
I do.
You are not a doctor.
I am not.
Not a psychologist.
Nope.
Not a psychiatrist.
No.
You're not holding yourself out that way at all, I'm assuming, right?
Absolutely not.
Okay. You would agree that, strike that. You are in charge of the condition, you are a WCS conditional release supervisor, right?
Yes.
And so would I be on solid footing if I said that part of your job is to manage the team that will oversee the conditional release?
Yes.
For Morgan specifically, as part of this process, did you yourself ever speak to any of the 3 doctors who did the reports in this case?
I had not.
Okay. You've never called Dr. Lundbaum.
No.
You've never called Dr. Collins.
No.
And you've never called Dr. Robbins.
No.
Have you, as you sit here today, have you even read their reports?
Yes.
Okay. Which ones?
I don't have the dates memorized. There were a number of reports. I can't give you specifics.
Okay, well, there are 3, you are aware that there are 3 doctors who have authored reports that have gone to the court in support of Ms. Geiser's release.
Yes.
And it's your testimony that you have read. You're not sure if you've read all of them or you have read all of them.
No, I had at one time. I have not read them recently.
Okay, well, I wasn't asking about dates, but you're sure you read all 3 reports, right?
Yes.
Okay. And did you read those reports before you authored or before you put together the petition to revoke Ms. Geiser's release?
I didn't put together the petition to revoke.
Or before you typed the WCS letter?
Can you rephrase the question, or can you restate the question? I'm sorry.
Did you read those 3 doctor reports before you put together the letter that you authored?
Yes.
Okay. So as I understand it, you've met with Ms. Geiser on a few occasions. How many times?
I'm not sure the number of times off the top of my head.
Okay, is it more than 5 or less than 5?
More than 5.
So you drive up to Winnebago and do meetings there at Winnebago?
We do Zoom meetings.
Have you ever met her in person?
I have.
How many times?
About 5, maybe.
So you've done Zoom meetings and you've also driven up to Winnebago to meet her in person, right?
I have, but that was different conditions, yes.
What does that mean, different conditions?
We do what's called community success groups that we go up to Winnebago and do education. So that's when, I've met Ms. Geiser.
Okay, so you're talking before before conditional release was granted. So since conditional release was granted, were those meetings those were Zoom meetings? Then?
Yes.
Okay, but the other occasions in the past, you've met her face to face?
Yes.
And to be clear, I think the last question Ms. Nicolai asked you was about the petition to revoke. That's not your doing, the petition to revoke.
Correct.
What you've authored is a WCS letter that's attached to that to provide information for the court, as I understand it.
A portion of the letter.
Not even the whole thing.
Right.
Now, you said that it's important to build rapport with a person who's going to be released, right?
Absolutely.
And because you're going to be involved in Ms. Geiser's life going forward on a practical level. If she's released, you're going to be involved in her life, right?
Yes, her case manager would be more so, but yes.
But just so it's clear, WCS as an agency provides support in the community for people who are on conditional release, right?
It does.
So rapport is sort of a two-way street. It's important for you to have a positive rapport towards her and her to have a positive rapport towards you.
Yes.
And you're aware, you've been to Winnebago before, so you're aware of what the facility is like, right?
Mm-hmm.
Is that a yes or a no?
Yes.
Thank you.
it is a secure facility, if you will, is it not?
Yes,
And I know we call it a mental hospital, a mental health institute, but there's security and guards and rules at an institution like that, aren't there?
yes,
And in order for somebody to get a visit at Winnebago, whoever's in Winnebago, they're just sort of there, and another person in the community can request to come visit that person. Is that how it works?
I do not know.
What you do know is that Morgan had some visits with a person named Jeffrey Pagel, because you testified about his name today, right?
Yes,
And if I go to Exhibit 2, if you have Exhibit 2, I want to draw your attention to paragraph 7, which is your note from February 19th. Did you author that?
I did.
And again, this is information that you had supplied to the court because it's being given to you by Winnebago, right?
I'm sorry. Can I correct something?
Sure.
That number 7 was authored by my lead case manager.
So some of the numbers in here are things that you wrote and some aren't?
Right, they come from case notes. That is a collaborative effort.
So in other words, you put your name on a document that you've not entirely authored because it's a team approach.
Yes,
Okay. And on item 7, it's indicated that Jeffrey Pagel had visits with, well, I guess they used the initials JP. That's who we're talking about, right? Pagel?
yes,
Had visits with MG, that's Morgan Geyser, right?
yes,
At Winnebago 3 times.
yes,
Initially, it was reported that it was 4 visits, but in fact, it's only 3.
correct.
And every one of those visits that took place with Mr. Pagel was at Winnebago.
Yes,
There is no suggestion that Ms. Geyser ever met him in the community.
I'm not aware.
You're not aware of any of her outings that she secretly had contact with Jeff Pagel, right?
Correct.
There's no suggestion at all of that.
Not that I'm aware of.
Okay. And the 3 times that Ms. Geyser saw Pagel was inside, as you understand it, was inside Winnebago's secure facility.
To my knowledge.
So Pagel went through whatever process he would have gone through to get permission to go into the facility to see Ms. Geyser.
I suppose.
And those visits spanned 3 visits over the course of 10 days. That's the extent, isn't it?
From the records they provided us, yes.
June 3rd, June 8th, June 13th
Yes,
of 2023.
yes,
So Winnebago supplied you with those records, right?
they did.
So Jeffrey Pagel's name was known to Winnebago in June of 2023.
It was.
In fact, they were aware of the visits because that's the institution that provided you with the records, right?
Correct.
And initially it was reported that Pagel visited her on June 30th, but then that's crossed out because that actually never happened, right?
That's what I'm told.
And in fact, it was Miss Geyser that there was a visit scheduled on June 30th with this Pagel person, and it was Miss Geyser that canceled the visit, right?
I don't have firsthand knowledge of that, but that's what I'm told.
Your report that you supplied to the court says Miss Geyser rescinded permission. That's the language you supplied to the court.
Yes,
So your understanding is that it was Miss Geyser who rescinded the ability of Pagel to visit her further.
yes,
And there's been no further visits that you're aware of from Jeffrey Pagel.
correct.
And there's been no contact with him in the community that you're aware of.
Not aware of any. No.
And as part of the release planning process, when you talk to Miss Geyser about people she's had contact with, she brought up Pagel as a person. It was her that brought that name to your attention, right?
Correct.
It wasn't like she was hiding something and you found some notes or something in her room. She told you about Pagel.
She did.
And she asked, didn't she, to have a no contact with Pagel?
She did.
Because she still, as of the time you were meeting with her in January, was expressing a desire not to have contact with him.
Correct.
I want to ask you something totally unrelated to Morgan because I think it's important. You've been doing this for 17 years in the mental health field, right?
Yes,
And we don't need to get into the details of other people's cases, but you are aware that Ms. Geyser's case, if you will, is of a high profile nature, right?
yes,
We all sort of know about it because whether you've been involved in it or not, people have heard of the Slender Man case and people are just generally aware of that.
correct.
And the reason why that's important is because as part of Morgan's release planning, that's an additional variable that exists in her case that doesn't exist in everybody else's cases.
Correct.
And so thinking about that variable and talking with her about how to sort of constructively handle that is important.
Yes,
Pagel is sort of, feel free to disagree with me if you want, but Pagel is sort of a classic example of somebody who appears to be fixated, if you will, on the Slender Man case, or Morgan specifically, right?
it appears he's fixated on true crime as a whole.
When you looked at his Facebook page.
Yes,
Because you didn't talk to him, I'm sure, right?
absolutely not.
So do you know that he's a former, has law enforcement background?
I do not.
Did you know that he used to be in the work in the correctional system?
I do not.
You know nothing about Pagel,
Nothing.
other than what you see on Facebook.
That's correct.
And he appears to be somebody who's fixated on, what'd you say, true crime and things like that?
Yes,
And he's the one who's selling things on the internet that he purports are from Miss Geyser.
yes,
And you don't know there's two things that are unclear from when you look at Pagel's Facebook page. One is whether the things he says Miss Geiser sent him were even sent by Miss Geiser, right?
I'm sorry, can you say that again?
When Pagel puts something on Facebook and says, here's the Slender Man letter,
Sure.
do we know as a treatment team that Miss Geiser even wrote that letter?
No, that was why we were looking into things.
Right, because any person on the internet could claim that I got this from Morgan or I got this from whoever, right? So you don't really know that the things he's saying he got from Morgan even came from Morgan, right?
She had told me that she had sent him things and she was aware that he was selling them. So we did know.
Okay. So Morgan was willing, was just discussing with you the fact that she had a letter of communications and had sent him some drawings, right?
Yes, we asked her about it and she was aware.
Okay. Is there any suggestion that Morgan was trying to profit from her crime in any way?
That's unknown.
Okay. In other words, no, there's no evidence that Morgan was
Correct.
doing that, right?
Correct. Yep.
Okay. And because there's lots of things that are unknown, I just want to focus on what we do know. What we
Okay.
do know is that Pagel is posting things for sale on the internet.
Yes.
And Pagel is apparently fixated on true crime type things.
Yes.
But Morgan herself hasn't had any physical contact with Pagel in over 18 months
Not that I'm aware.
and has never seen him in the community as far as we know. Right?
Correct.
And has herself asked for a no contact order.
Yes.
And as part of a treatment release, when you're planning someone's release, a person gets rules, right? It's sort of like being on probation. They have a list of rules that they have to abide by.
Correct.
And certainly on those rules, oftentimes there will be no contacts with certain individuals. I mean, one obvious no contact would be the victim of the crime and the family members, right?
Yep.
And then, so it seems like Miss Geiser is aware of that. So when she uses the phrase no contact, it's in the context of, I'd like there to be a rule that makes it clear not to have contact, right?
Correct.
And in terms of making sure that somebody knows how to, well, let's go back to sort of the nature of the crime. There will be people who probably try to reach out to Morgan if they know where she is or they know how to get a hold of her because they might be obsessed with Slender Man case, right?
That's been the history.
But actually what's going to happen, as I understand it, is judge had ordered conditional release. And so you, as part of the planning group, you were going to put together a plan for her to go to a group home was the idea.
Correct.
And as I understand it, there were two group homes that were identified, but one was too expensive and one was affordable, right?
Yes. Well, yes.
Two group homes that would take her, right?
Yes.
And so the one that you had identified would be a location that would be confidential in a way, wouldn't it?
We were going to try to make it confidential.
Okay, I just want to explore that. I mean, the idea was even Morgan shouldn't reveal her own location to start with, right?
Yes.
So don't, and it may not be, we're not saying forever, but to begin, don't even let your mother or anybody know the exact location, right?
Correct.
Because what I think we're trying to do is make sure when she's released that these Pagel type people don't flock to a group home or start writing letters to her as she's transitioning into the community, right?
Correct.
And so in a way, as she sits here right now, anybody can write a letter to Winnebago where she is, and either Winnebago gives it to her or they don't, right?
That a yes or no?
Yes, I'm sorry.
But when she goes to the group home, the idea, your guys' idea, or the team's idea was keep the location confidential as much as possible so we can help transition Morgan into the community safely.
Correct.
And that can be hard for her to process in a way because it's almost more restrictive in a sense than Winnebago is, isn't it?
Yes.
I know she's worked hard. You would agree she's worked hard to earn her release from Winnebago, right?
Yes.
And so she has release privileges where she can go into the community in a supervised fashion and have visits from family members and friends, right?
She does.
But that's going to change when she goes to a group home. She's actually going to be more restricted to start with.
Initially, yes.
And Morgan specifically and people in general, that can be a hard thing to have to work through, the fact that they're going from having some privileges to now having almost more restriction, even though they're not in an institution.
Yes.
So things like crying and let's talk about the books. Did you ask Morgan to put together a list for you of all the books she's read? Let's pick the last year. Did you say, Morgan, give me a list of all the books you've read in the last year?
No.
You do know that she read Rent Boy, obviously, because you mentioned it, right? But the reason we know that is because Morgan brought it up as part of the release planning.
Yes.
And that's important because it's not like you found it hidden somewhere in her. It's not like Winnebago found it hidden somewhere, right?
We asked her to provide us with a list of books that she would like to read, and she had brought up that she was reading Rent Boy. She stated that she didn't want to tell the conditional release team the kind of book she was reading because she was afraid that we wouldn't allow them because they were kind of dark, I think was the way she described it.
Did you ask? So you were asking sort of prospectively, can we have a list of books that you were planning to read as you are released?
Yeah, what are you interested in reading?
Okay, but you never asked her for a a list of books she's actually read, right?
No,
And in something like Rent Boy, there's no evidence that she sought it out. It appears that somebody mailed it to her at the institution, as you understand it, right?
I don't know if she sought it out or not.
Well, but you said before, you believe someone mailed it to her.
That's what I'm told,
Okay,
yes.
so all we know is that someone mailed her this book and she read it, right?
I suppose that's what I'm told.
Yeah, we're told that someone mailed her the book.
Yes.
She read the book, and then she disclosed to you or the team that she had read the book.
Yes.
Okay. And so isn't honesty an important part of one's release plan?
It is.
Morgan should be commended. Morgan should be commended for not concealing the fact that she was reading a book that has some dark themes to it. Agree?
I'm not sure. I'm not a doctor, so I don't, from the clinical standpoint, that's not my role.
Okay, so you defer that question to the doctors who can testify about whether that's a problem.
Yes.
But it gets presented to the court and disrupts her release plan potentially because it's being represented as a problem, but you've never talked once to the doctors about it.
Correct.
Okay, and you could have, before you filed this letter from WCS that now seeks to revoke her release, you could have called any of these doctors before you filed this letter and asked them, hey, we learned that she read Rent Boy. What's your opinion? Is that a problem?
Objection, she didn't file the letter.
Okay, before you authored the letter. You could have called any of these doctors and asked them, is this a problem?
DHS contacted the treatment team at Winnebago to look further into it. So that's what they were doing.
Okay, and so the answer is you didn't do that, right?
Did I contact the doctors? No.
Now, since you read Dr. Lundbaum's, I want to ask you about Dr. Lundbaum's report. You know you've read the 3 doctor reports, right?
Yes.
And therefore, you are aware of the fact that even back when Dr. Lundbaum authored her report in December, that it was known to the doctor, it was known to Dr. Lundbaum at least, that there are drawings, letters, and other items being sold on the internet purported to be drawn by Ms. Geiser. You were aware of that, right?
Yes.
So it's not anything new. Dr. Lundbaum knew that when she wrote the report.
Yes.
And in fact, when Ms. Geiser was questioned about it, she acknowledged that she had done that, right?
Yes.
Okay. And this Jeffrey Pagel person, are you also aware of the fact that Jeffrey Pagel was a known person to Dr. Lundbaum as well?
I recall that she had knowledge of him, yes.
In that Ms. Geiser had talked about how the fact that she learned on her own that this Pagel person that her letters or drawings that she had sent to him, that he was involved in trying to sell these things. She brought it to the doctor's attention back in June of 2024.
I don't recall what's stated in the report.
Now, the reason these reports are important is because when a person is released on conditional release, these reports become part of the treatment process, don't they?
They do.
And you've read the reports, but I just want to be clear, you never reached out to these doctors to discuss any of your concerns about the book or Jeffrey Pagel, right?
Objection asked and answered.
Sustained.
So with respect to the art that Ms. Geiser does, were you aware of the fact that Ms. Geiser has discussed her trauma therapy and the therapeutic benefit from her artwork and the fact that a lot of it is disturbing, but helps me cope with the trauma I've been through? Are you aware of that?
That's not my role.
Okay, but we're using her artwork here, this picture that you testified to. What's the point of providing this to the court? What is the intention behind giving this to the state?
What is the intention behind giving it to the state?
Yes.
Because it raises a concern for risk.
But you never took this picture that you've now given to the state and asked Dr. Lundbaum, does this change her risk?
That's not my role.
Okay, whose role is that?
That would be the doctors that are treating her.
That would be the Winnebago doctor's role.
Winnebago, yes.
So you become aware of a drawing and you then mention it in a revocation letter that is supplied to the court. But you were also aware of the fact that Ms. Geiser has been drawing disturbing things for a long time. And Dr. Lundbaum was aware of that when she suggested that Morgan was appropriate to be released, aren't you?
That's the report.
This is not new. Her doing a disturbing drawing is not a new fact at all. Agreed?
Agreed.
Okay. So we'll put that to the side. And nor is Jeffrey Pagel a new thing at all. He was known 2 years ago in June of 2023 when he was going to the institution.
To Dr. Lundbaum, yes.
Well, actually,
And it was in her report.
Right, and to the whole institution, because the records at Winnebago reflect the fact that he was a known visitor to their facility.
Yes.
And the records never showed anything inappropriate between Ms. Geiser and Mr. Pagel during any of those visits?
I'm
I'm gonna
unaware.
object on foundation of this witness to testify about all of Winnebago's records.
Overruled. Witness can answer if she can. If she doesn't know, she doesn't know.
I do not know.
So in addition to this one book, Rent Boy, did you ask Ms. Geiser about the other types of literature that she's interested in?
Yes,
You know that she's interested in biographies, right?
yes.
And you know that she likes historical books, if you will. I might have said Westerns previously. She doesn't like Westerns, but historical books, right?
I am not aware.
But she's talked about her like of Vincent van Gogh, for example, and reading biographies about him, right?
Okay, yes.
And at Winnebago, she doesn't have internet access at Winnebago, right?
I'm not sure what she has access to at Winnebago.
But when you've met with her and talked to her about her hobbies, a central hobby for her is reading, right?
Yes.
It's really been, for the 11 years that she's been in custody, it's really been a crutch for her and something that she's relied on, isn't it?
I know that it's something she's interested in.
And so what Morgan has, and Morgan has an interest in a wide array of reading material. You're aware of that, right?
I'm not aware of a wide array. I know of the horror books that she's described. She mentioned fantasy and the biographies.
Okay. Those are all my questions.
All right, thank you. Redirect.
Ms. Whitaker, why did you think it was important to share this information with the Department of Health Services?
It raised risk, and we needed to be aware that the treatment team was aware of these risks and that they were being addressed in treatment with Ms. Geiser.
When you say treatment team, what are you talking about?
I'm referring to the doctors and therapists at Winnebago.
Why, if Ms. Geiser is getting out into the community anyway, why does it matter what is being addressed with the treatment team at Winnebago?
We take that as a foundation as we go into the community and know how to treat her into the community to mitigate risks. It's a much different, what is allowed in a confined setting is much different than what can be allowed in the community.
Those are all the questions I have. Thank you.
Any further cross based upon the redirect?
No, Your Honor.
All right, thank you. You can put the exhibits just up on the counter here.
Thank
That would
you.
be fine. Thank you. You can step down. Thanks for being here.
Thank you.
Judge, at this time, I would like to call Kathleen Martinez to offer testimony on Courts Exhibits 1 and 2 as well.
All right, very good. Ms. Martinez, if you'd come forward.
Do you swear that the testimony you're about to give in this matter before the court should be the truth, the whole truth, and nothing but the truth, so help you God?
All right, thank you. Be seated. Pull up to the microphone. It's the bar with the red light. State your full name and spell your last name.
Kathleen Martinez, Martinez.
Is Kathleen with a C or a K?
K.
K. All right.
Ms. Martinez, where do you work?
Wisconsin Department of Health Services,
What's your role there?
Forensic Mental Health Section Manager.
Where's your office?
My office is 1 West Wilson in Madison, Wisconsin.
Okay. Do you work with someone named Aaron Graff, Graf?
I do. I supervise Aaron.
Okay. Were you involved in the filing that's been discussed at today's hearing regarding the petition to revoke conditional release for Morgan Geiser?
Yes.
Okay. I believe in front of you are Courts Exhibits 1 and 2. Is that true?
Yes.
Okay. Do you recognize both of those items?
Yes.
Looking at Courts Exhibit 2, and just to clarify for the record, were you just in a courtroom during the testimony that was offered by Ms. Whitaker?
Yes.
Okay. Do you know Ms. Whitaker?
Yes.
Okay. Are there portions of Exhibit 2 that you authored as well?
Yes.
Could you please clarify for the court which portions you authored?
The conclusion portion of the letter, page 5, partial part of page 6, DHS reviewing these documents is standard practice for conditional releases, and we often make edits or final approval before filing these documents.
Okay, so how does WCS relate to DHS when we're talking about someone that's been granted conditional release?
DHS contracts with WCS to provide conditional release case management to any conditional release person in certain counties in Wisconsin,
Okay.
including the southeastern part of the state.
Okay. Does that mean that the person would only work with a WCS case manager and no one from DHS?
Upon release,
Right. Or would they have both?
DHS also contracts with Department of Corrections to provide supervision. So the individuals that are conditional release work with their WCS or the contracted case manager, the contracted DOC agent, and any other treatment providers or service providers that are indicated in the plan.
Okay. In terms of preparing a conditional release plan, is DHS involved in that?
We review it when it's complete.
Okay. Were you involved in any of the meetings that occurred in regard to the plan for Ms. Geiser?
No.
Okay. At some point in time, did you become involved in the planning for Ms. Geiser?
Yes.
Why?
I received pictures of Facebook posts that were concerning. I received them from Erin Graff that she received from WCS.
Okay. And are those some of the things that have been discussed during Ms. Whitaker's testimony and are detailed in Exhibit 2?
Yes.
Okay. Ultimately, were you able to review the information compiled by Ms. Whitaker in Exhibit 2?
Yes.
When you learned that information, what did you do?
I alerted the department administration because it is a practice to complete high-profile notifications if we believe that there may be attention or media drawn to a specific case, and that's what I did.
Okay. Did you have contact with Winnebago Mental Health Institute about some of these issues that were raised, or risk issues that were raised?
Yes, I did.
Why?
To ask them about their perspective from their, from their end.
When you approve a conditional release plan, is it important for DHS to have an understanding of what is in place with the current treatment team at the facility the person is in?
It is.
Why?
Because if somebody is making progress in treatment, we would like to continue it in the community. And when we write conditional release treatment plans, those plans should be informed by the assessed needs and risks that are done by various people in the current treatment team.
Now, would doctors who are court appointed to make evaluations about appropriateness for conditional release be the same as doctors that are in someone's treatment team in a facility?
No.
What's the difference?
The court-appointed doctors are independent examiners, not affiliated with DHS, and meet with conditional released clients or prospective conditional release clients for purposes of offering an opinion about whether the conditional release poses a threat to the individual or community or property. People at the institution treatment team would be people that interact with an individual at whatever frequency they determine is needed to address treatment concerns.
Did you try to ascertain whether information was known to the Winnebago treatment team regarding Ms. Geiser in this case?
Yes.
What specific information were you trying to learn whether they were aware of?
Had they seen the posts that I had received from around Jeffrey Pagel, including the contents of the postcard and the specific drawing, and if they knew the extent of the content of the current book, Rent Boy?
Why did you want to know that?
Because I would be interested in incorporating their opinion about what interventions would be needed to address any risk associated with those items, or perhaps they might say that they were aware and that they had no concern with it. And, so since they're treating her, I was interested in understanding more about that.
Ultimately, was a decision made to file a request of this court to revoke the conditional release as opposed to finalizing and offering a plan?
Yes,
What entity's decision was that?
Department of Health Services.
Okay. And why? Why is that the position of the Department of Health Services?
Because when we asked if the treatment team were aware of the extent of these issues and the content, they said the Winnebago social worker.
On hearsay grounds.
I'll overrule it. I'm satisfied. To some extent, it's offered for the truth of the matter asserted, but it's also offered to it's offered to show what, after receiving the information, what the witness in the department did. So I'll overrule the objection. Witness can answer.
I can answer.
Yes.
The social worker indicated that she had not told the treatment team that the specific details of the posts and the specific details of the drawing and the specific content of the current book read. That was in a meeting with Aaron Graff, Nicole Whitaker, and the WCS case manager were that. So to answer your question, so because the treatment team had no knowledge of these, they could not indicate whether they thought it posed a risk or they thought it was great or whatever. They couldn't answer that question because they didn't know about it.
Were there aspects of these concerns that had direct relation to the index offense that caused the department concern?
Yes.
Like what?
The material being horror related is similar to the content of the Slenderman content, and that was similar enough. The material being related to killing people and violence was similar enough to ask a question about risk.
Did the department have concerns about Ms. Geiser's self-reporting tendency to disassociate when stressed?
Yes.
What was that concern?
That in a report by Dr. Lumbaum, there was indication that Ms. Geiser was aware that she sometimes disassociates, and that was what was happening during the index offense when her environment is stressful. And releasing to the community often includes elevated stress for the individual. And so we were interested in knowing what her treatment team thought about that in relation to her current reading material.
Was the decision to request revocation made before you checked in with her Winnebago treatment team?
No. But we would have liked more time to get more information. That's part of the problem, is that we didn't have the information we needed. And our job is to write a plan that mitigates risk to the community. It's hard to do that if the risk is unknown.
Is the information contained in Exhibit 2 that you authored still true and accurate as you sit here today, as far as you're aware?
As far as I'm aware, yes.
Okay. And is the position of the department continue to be that the court revoke conditional release at this time?
At this time, yes.
And what you're aware that one way the department can seek revocation is when rules are violated, right?
That's correct.
Does that apply here?
No.
Why not?
Ms. Geiser did not violate any rules of conditional release.
Right. So then why
I'm aware of.
why is the department seeking revocation at this point then?
It's based on concerns about safety to the community and to Ms. Geiser.
You were in court when State's Exhibit 1 was offered, the drawing, is that true?
Yes.
Is that something that you had seen before?
Yes.
Is that something that you inquired with the Winnebago treatment team prior to filing the request to revoke?
We asked had they received or aware of any of the posts that were done on Facebook? And they said that the Winnebago social worker indicated that the treatment team was not aware.
What about in terms of, was the treatment team aware or worked with Ms. Geiser on, you know, her tendencies to enjoy violent artwork or something like that? Was that something that was known and aware?
I believe that it was, but I don't know that for sure, but I think so, based on the reports submitted by the independent examiners. And so, yeah, yes, I think so.
So what aspect about the posting was concerning to the department and unaware to the treatment team?
They indicated they weren't aware of any visits. They weren't aware of the fact that he'd indicated sexual arousal based on the index offense. They were aware of the general themes, but not the details of the specific posts or drawings or the particular book.
From what you were able to review, did it appear that there was well, strike that. How do you know that this person, JP, was sexually aroused by the index offense?
I don't know that he was, but Morgan, the Wisconsin, the WCS conditional release team reported that Ms. Geiser told them that he was, and that was why she part of why she asked for the no contact.
And at that point in time, she hadn't had contact with him since June of 2024, right?
It says 2023 in the records. Exhibit 2, paragraph 7.
That was the June of 2023 is the last reported visit. I have no idea when the last contact they had was.
Okay. But from what you were able to gather, her treatment team, she never told her treatment team, hey, I'm writing letters to this person who's sexually aroused that I committed this crime 14 years ago.
Not that level of detail, but I believe they knew about him. You know, they knew his name. I asked if this was, that specifically, the sexual piece has been addressed at all in treatment, and I was told that they weren't aware of it, so.
Are there any other risk concerns that the department has that you think that the court needs to know about?
I'm going to object on notice. I'm going to object on notice grounds. If they file a petition to revoke, they can identify the grounds, which they've done, so that we have notice and can investigate and respond.
Overrule, if the witness has additional information for the benefit of the public and the court, the witness can disclose that.
I would just say that generally the conditional release program places people in the safest environment possible. However, and we have the ability to write rules for people to follow, but obviously those rules are broken, and group homes are not locked. People can leave group homes. People can cut off GPS bracelets. So we try to make the best placement possible, the safest placement possible. And we understand that we have rules, and those aren't necessarily safeguards, but I wouldn't, I guess that's just more general information about conditional release generally, not Ms. Geiser specifically.
That's all I have. Thank you.
Cross-examination.
Good afternoon.
Good afternoon.
You and I have talked one time before, haven't we?
Yes.
I think you were on a Zoom conference that we had about a week
Yes.
or so ago, right? Right?
Yes, correct.
So I just want to ask you some questions about what you testified to.
Sure.
It doesn't sound like there was any additional concerns that you had beyond what was expressed in your filing. Do I have that correct?
Yes, I think so. Yep.
Okay. And we all know rules can be broken. You mentioned people, I think you just said people could choose to, a person could cut off their GPS bracelet. right?
Correct.
Person could theoretically leave a group home if they wanted to get out somehow, right?
Yes.
And there's a mechanisms in place that when people break rules, there's mechanisms in place to address that, right?
Like, for example, pursuing revocation, or do you mean something?
That person could be arrested, right?
Yes, if they were, if we could find them, they could be arrested, or we could put them in, we could petition the court to, or ask the DOC to place essentially a hold on them if they were willing to come in and go to jail or something like that.
Yep. So
We could also adjust treatment if we needed to.
Sure. And so as we sit here today, Morgan has broken 0 rules, right?
As far as I know, yes.
Okay. Well, I only want to know what you know. So
Yep,
she's broken no rules.
Yes.
All right. So she's not facing revocation because she broke any rules.
Correct.
She's not, in fact, you've never even given the judge the conditional release plan for her to go to the group home, right? You pursued
Correct.
revocation first.
Correct.
Okay. And you said, I think I have your words correctly, the sexual piece wasn't addressed in treatment. Are those your words?
Yes.
Morgan has never expressed any sexual interest in her crime.
When I said sexual piece, I'm referring to the current reading material of being sexual sadism, plus her interactions with him around being interested, sexually gratified or aroused by her crime, exploring that in therapy to see whether or not that presents a risk to the community. That's what I meant.
Okay. What I heard you say before was that Morgan broke off contact with Pagel when she found out that he was sexually interested in her crime. That's what I heard you say 5 minutes ago. Right?
Are you asking me?
Yes.
Yes.
Okay. So Morgan,
she rescinded his ability to visit her in person.
Right. Which is what you would want a person to do in her shoes.
Absolutely.
She finds out that the guy is creepy. He has sexual interest in her crime. She cuts off contact.
Revocation is not about punishment or saying.
I'm not asking about.
I mean,
first, ma'am.
Sure.
I just want to ask you very specific questions.
Okay. Sorry.
What you want someone in Morgan's shoes to do is if someone reaches out to her and starts expressing sexual interest in her crime, you want her to cut off contact with that person.
Yes.
That is what she did. Correct?
Correct.
In June of 2023, right?
June of 2024.
No, June of 2023.
She rescinded the release on June of 2024.
Right, but the last time she had contact with him at the institution was June of 2023. Right.
For that reason in June 24.
Oh, she became aware of it in June of 2024 and then rescinded the contact, right?
I don't know that.
Okay, all we know is that she rescinded it in June of 2024, right?
Correct.
But we know for sure that the last time she had any contact with him in the facility was June of 2023, right?
The last visit he came to Winnebago was in June of 2023.
Okay. Now, have you ever yourself met with Morgan?
No.
Okay. And you are what is your educational background?
I have a bachelor's degree in psychology and a master's degree in social work.
Okay, so you're a LCSW.
APSW, Advanced Practice Social Worker.
So you're a social worker by training, right?
Yes.
And you talked before about Dr. Lundbaum's report, so I'm assuming you yourself have read the doctor reports that were filed about Ms. Geiser, right?
Correct.
Because that's an important part of your job is to read those reports and know what the doctors are aware of, right?
It's not part of my job, but I did in this case.
Okay, why'd you do it in this case?
In order to understand the situation better.
Because of the high profile nature of it?
No, because of the concern brought to me by the team.
Okay, so with respect to Ms. Geiser's artwork, you're aware of the fact, aren't you, that Dr. Lundbaum that Winnebago itself was aware that Morgan has part of her therapy is her artwork. You know that, right?
Yes.
In that it's been a method that they've used to help her cope with her trauma, right?
Yes.
In that, in fact, it's been known for quite some time. It was known even to Dr. Lundbaum that the artwork is disturbing. That's not new information.
No.
And Dr. Lundbaum, despite that and knowing that.
Well, that was a double negative.
Okay, then let me be precise with it. You because I should ask the question. You know that Ms. Geiser has drawn artwork of a disturbing nature in the past, right? You know that?
I read that, yes.
Okay, you read that in Dr. Lundbaum's report?
Yes.
Okay. Now, with respect to the book, Rent Boy, are you aware of how Ms. Geiser got that book?
I was told that it was mailed to her.
Is that all you know?
Yes.
Okay, someone mailed it to her.
Yes.
And the reason you know about it is because she said that she read it, right?
Yes.
She brought it up. It wasn't like it was discovered. Right?
I don't know.
Oh, you don't know. Ms. Geiser stated she just finished a book titled Rent Boy by Gary, Indiana, which she stated was about prostitution and black market organ trading. Are you aware of that sentence in the WCS report?
Yes.
Okay. So Ms. Geiser was the one who disclosed that she read the book.
Yes.
Don't we want, as part of DHS, don't you want honesty?
Yes.
So it would be a concern if somebody wasn't honest about reading a book like that, but it's,
Yes.
but it's also a concern when they are honest about it.
If the concern was that upon further investigation and looking into the themes of the book, when they asked her about it, her response was, "Oh, I forgot that part," which is also indicated in the memo.
She stated that it was darker and disturbing, right?
I mean, I wasn't in that meeting.
Okay. And really, you don't have any personal familiarity with Ms. Geiser as an individual because you've never met her, right?
Correct.
And the when you talked before about the sexual piece that wasn't addressed in treatment, what we're talking about is Jeffrey Pagel, whoever that is, his sexual interest in whatever, right?
And sexual sadism, the combination of that.
That he's interested in sexual sadism and?
No, the book related, the Rent Boy book had themes of sexual sadism.
Right.
So
the concern is, as I understand it, the concern is one book that she read, one book in 11 years, one book.
Okay.
Had some themes of sexual sadism.
Okay.
That's a concern, right?
Yes.
And then there's another concern that someone named Jeffrey Pagel is sexually interested in her crime. That's another concern, right?
The concern is the combination of that and
Right.
whether or not the treatment team has addressed that and what they think about it. The concern is a question of risk. It's not a determination of risk.
What is there to address about Jeffrey Pagel's sexual desire over a crime that happened? What can Morgan do about Jeffrey Pagel's problems? Other than contact?
I do not believe Morgan has any responsibility to address Jeffrey Pagel's concerns.
Okay. So all the stuff he's posting on the internet about his own behavior, that has nothing to do with Morgan, right?
I don't agree with that because the content of what is posting does have to do with Morgan, but that he's posting is not Morgan's fault or responsibility.
Right. And what would be your role, ma'am, in Morgan's future when she goes to the group home? Do you play a role in her life, or would you play a role in her life?
I oversee the forensic specialists that work at the Department of Health Services that oversee the contract for conditional release case management and supervision.
So when a person is, in other words,
go ahead, sorry.
So when a person is released to a group home and they have their rules, if they violate the rules, then you oversee the treatment providers who would address that. Is that what you're saying?
Me?
Yeah.
No.
Okay. So really you would play no role in Ms. Geiser's life going forward. You wouldn't be involved in treatment or anything.
Very rarely would I be involved in any conditional release person's day-to-day life.
Did you ever ask Ms. Geiser to provide you with a list of books she's read over the last year? To
No.
see what topics, no? Did you ever reach out to this Pagel person to ask him any questions of her?
No.
And you did say before that the treatment team did know about him. You're aware of that, right?
They knew his name. They indicated they did not know about the visits or any other details.
Yeah, so the visits at the facility, right?
Do you have an answer?
Yes, sorry. Yes.
Thank you.
And between the time that the judge ordered, so I'm sorry, you're a part of DHS, right?
Yes.
And so it was actually your job to make sure that a conditional release plan gets filed with the court for the judge to either approve or not approve, right?
Personally?
Yeah.
No.
You're not involved in the drafting of that report?
No.
Or that plan, I should
Correct.
say?
No. I mean, yes, you are correct that I am not involved directly in the drafting of that plan.
And Morgan, between the time that judge ordered that plan to be drafted and now, she hasn't done anything violent, right?
No.
And neither to herself or others, right?
I think that's true. I believe Winnebago would have reported that.
Right. If she was doing something violent to
Right.
herself or others, you'd know about that.
I think so.
And before you put together, when Ms. Nicolai was questioning you about exhibit 2 that you have in front of you, you are the one who wrote the conclusion section. Was that your testimony?
Yes.
So starting with conclusion and recommendation, did you write all that?
I did.
And you say that Ms. Geiser only provided the information about the book when prompted, but that's because she was asked about it, right? The specific question was asked what she's read recently, and she brought up Rent Book. Is that right?
That refers to the
Rent Boy.
Right. That refers to the detail of the content of the themes of Rent Boy. But Morgan did bring up the book name itself. That's how WCS knew to Google the contents of it.
Right. And you said in your conclusions that reading horror and murder-related books is not by itself necessarily a risk to the community.
Yes, I did write that.
And you feel that there wasn't full disclosure of the book, is that what, or the contents of the book, right?
Correct.
That's what that comes down to.
That's true. Sorry, can you repeat that question?
You're concerned that there was, in your opinion, a lack of full disclosure about the contents of that book, right?
Yes.
There's no other book she's read that you're raising today as a red flag for the court, right?
Correct.
That's the one.
That's an example, yeah.
Well, that's the only one you're aware of that's the concern, right?
The concern is about, I'm talking about that specific book, so yes.
Okay. You mentioned that in your conclusions that living in the community through conditional release, there is inherently less structure and supervision when compared to a state mental facility, meaning she theoretically has more freedom to leave if she wanted to, right?
Exactly.
And Morgan hasn't tried to escape from Winnebago that you're aware of, right?
No.
And you say that group homes are not locked, typically not staffed by individuals who understand complex mental health problems, and even with GPS could not guarantee prevention from absconding, right?
Correct.
That's true for everybody. That's nothing unique to Morgan.
Correct.
And that somebody could form a bad relationship that would exacerbate a risk, that's not unique to Morgan. That's anybody.
True.
And that's just something we have to deal with, isn't it? That's part of the nature of somebody going into conditional release, is that it is a gradual process to give that person more freedom, and there will be potentially more things that could happen, right?
That is true. The recommendation was to monitor social contact, social relationships from one of the independent evaluators. So so we monitor different things depending on individual needs and risks.
And treatment doesn't stop for a person once they're released from a Winnebago Institute.
No, it doesn't.
In fact, it might change because that person now has a different set of challenges that they have to confront, right?
Yep.
And so part of the job at DHS is just making sure that part of the contract, if you will, is to make sure that those treatment providers are in place and available to the released person, right?
Yes.
And treatment remains something that if there's a concern about a book, for example, a rule can be put in place that a person not read a particular type of book, right?
A rule could be put in place. That's true.
And then if a person violates that rule, then as you know, petition to revoke gets filed with the court, right?
Yes.
So if we,
well, possibly.
Right. It doesn't have to result in revocation. You could choose to do some alternative approach.
If we found out about it, yes.
Right. So, and so the way you work through things is to establish rules, right? Rules get established for a person when they're released.
Yes.
And in this case, no rules have even been really, other than the ones that exist in Winnebago, there's really been no set of rules that's been provided to Morgan to say, here's what you can read and here's what you can't read, right?
I don't know that.
Well,
I have no idea actually of that.
Well, you said before she's not here because she violated any rule. We already established that, right?
Yes.
Meaning,
because there's a standard set of rules.
Right. Meaning there's no rule that prohibits her from reading Rent Point, for
Right.
example.
Yes.
There's no rule that prohibits any type of reading against her.
Right. Yes. Correct.
She discloses what she's read as part of the release plan, and she gets served with revocation papers. Do I have that right?
Objection argumentative.
No, that's
No, overruled. It's cross-examination.
right. That's what happened. She has no rule prohibiting her from reading any genre at all, right?
Correct.
She then reads Rent Point. That's what sends her and discloses it, right?
Correct.
And then she's served with revocation paperwork and told she won't be released for 6 months. That's how
The
it was handled.
revocation is not based on rule violation.
Based on
Safety concerns.
safety concerns over something she read that wasn't prohibited.
Yes.
Okay, that's all.
Any redirect?
You were asked a lot of questions just now about why the petition to revoke was filed. And those questions seem to suggest the only reason was because of one book that you guys have read. Is that true?
Yes.
That's the only reason that this.
Oh,
was
sorry.
filed?
Sorry. Go ahead.
Is that the singular only reason that she said, I read this book, and so you said, I'm going to file this petition?
Oh, no. No.
Is it fair to say that it's a much more complex analysis that was done before the determination to file this was made?
Yes.
The discussion that was had regarding this Mr. Pagel person, you agreed with defense counsel that he certainly seems to have some issues, right? And that they're not Ms. Geiser's problem.
That she shouldn't be punished for or responsible for dealing with his issues.
Right. But there's still a concern that the department has because this is a person that Ms. Geiser decided to have a relationship with for some period of time, right?
That's true, but I would say the crux of the concern is that her current treatment team was not aware of the extent of their relationship, the extent of the content of the post. It's that they might have been aware on some level that he exists, but they weren't aware of the detail. The same with the book. They weren't aware of the extent of the details of the book. And that without their perspective on what that looks like in terms of risk mitigation or treatment intervention, we had no choice other than to file a petition for revocation because we cannot write a treatment plan that addresses risks that we're not aware of, that we've asked about, and the treatment team said, well, we haven't addressed it because we were not made aware of this level of detail.
And when you talk about level of detail specifically with this Pagel person, did the detail include the fact that some of the content of correspondence Ms. Geiser sent to him?
Yes.
What specifically?
The postcard that indicated a desire to be intimate with him?
Was that information that the Winnebago treatment team had?
No.
Do you think that it's a distinction for the treatment team to be aware of someone's name versus to be aware of a fact like that?
Yes.
Why?
Details that around the specific details around the nature of their relationship could exacerbate risks to the community. And I think it would be important for them to have explored that in order to indicate what current interventions are in place and how we might be able to address that in the community.
If if the department became aware that there was someone out there in the world who seemed to be fixated on Ms. Geiser and was sending her things and wanted to come see her, but there was no evidence that she ever reciprocated any communication, would the department have filed revocation papers?
Probably not.
Again, there are some things inherent about this case that are going to be outside of Ms. Geiser's control, right?
Yes.
Are those aspects the reason that the department has filed the motion to revoke here?
This has been asked and answered numerous times about why they filed their petition.
Overruled.
Can you repeat it? Sorry.
These aspects of things that are outside of Ms. Geiser's control, just based on the nature of this case, are those the reasons that the department has concerns about risk in this matter?
No.
Okay. Are the concerns about risk specific to Ms. Geiser's actions and behaviors?
Yes.
That's all I have. Thank you.
Further cross.
You said a postcard that Ms. Geiser wrote Pagel, where she expressed a desire to be intimate with him, right?
Yes.
One postcard, right?
You're asking, sorry, what is your question?
You're aware of one postcard, one time.
One postcard, yes.
Where she wrote someone who had visited her and said she wanted to be intimate with him.
Yes.
She's an adult woman, right?
Yes.
Wanting to be intimate with someone is not a risk factor, ma'am.
Wanting to be intimate with someone who is sexually aroused by an index offense, maybe, and that is the question that I had to the treatment team.
And there's no evidence that when she wrote him that postcard saying she wanted to be intimate, that she was aware that he was aroused by the index offense. Agreed? There's no evidence of that. Agreed?
I have no idea.
Okay, thank you. And it was Ms. Geiser who cut off contact with Jeffrey Pagel, not the other way around.
Objection asked and answered.
Sustained.
You can't write a treatment plan to control for risks we are unaware of. That's what you said?
Yes.
You can, if to be clear, you can put in theory, you can put any rule in place you want. If you want to prohibit Morgan from having contact with someone, that can be a specific rule that gets put into her plan, isn't it?
The treatment plan indicates treatment interventions and is distinct from the rules of supervision for conditional release.
Okay, but it's already, but
yes, we can
right.
put any rule we want, I guess.
And
it would be subject to review by the court, but yes.
Right, because she doesn't get released until the judge reviews the plan, right?
Correct.
So Okay, so when you said treatment plan, you weren't talking about a conditional release plan. That's a separate thing.
The conditional release plan does not indicate the rules of conditional release supervision, but it indicates treatment interventions and also placement, location of placement and that kind of thing.
Got it. Those are all my questions.
Any further direct?
No, thank you.
All right. Thank you, ma'am, for being here. Have a good day. Thank you. Indicated that Ms. Groff was present.
She is here, yes.
Is any significance to her testifying?
I was not going to call Ms. Rock.
All right, all right. Any further witnesses at this stage?
There is.
Sorry. So I think I'm going to call it on that one because it's got another, I think it's got another hour and a half on it. And it's getting later than I'd planned on being on tonight. But you guys, y'all wanted to watch the Walrus talk, his interview? Is that what y'all said? You want to see Marshella's attorney talk? I can't believe y'all want to hear him go on and on. All right, let me see if I can find it. Teresa. I can't believe you sat through it, Teresa. I don't know. I thought y'all were tired of hearing him. I'm going to say press conference. We know there was a press conference, but I'm sure her attorney speaking will come up after that. Prosecutors hold this press conference. Chidester's attorney calls trial one-sided. It's a 5-minute. Yeah, it's only 5 minutes long. All right. He loves to talk, doesn't he? Okay, I'm getting there. Hang on. Y'all know I'm slow as molasses these days. So what I'll do is for those of you guys that were watching the Morgan Geyser, I always say it wrong. It's Geyser. I'm going to do a second video on this and pick it up tomorrow morning or maybe later tonight. But I got to go get something to eat. Okay, hang on. Let me do this.
Came out today. What did you think of that?
Well, it wasn't a surprise. I was aware. There wasn't any real testimonial evidence, just a video or videos, which even if you looked at the videos, what is it going to show? Is it going to show that somebody consumed enough to be a 0.18? And so it's to the jurors' interpretation of what they think happened during those hours. What does it look like? And it was edited. It was cut and paste and put together during certain hours. So certainly we think it's unreliable. The judge allowed it in. I have to respect the judge on all his court rulings. When you lose 8 out of 10 motions, I still respect the system, but I also will file an appeal and let the Court of Appeals or Supreme Court make a ruling and judgment on what the judge did.
Did you expect such a fast verdict?
No, I never expected such a fast verdict of, is it less than 3 hours?
I think less than 2.
And, they say quick verdicts are not good for somebody that's charged as a defendant. It's not quick. So that also concerns me that, did they truly deliberate? Was there already a decision in their mind? And it's just, the end justify the means. Was it that somebody's going to pay or the defendant's going to pay for the 2 children that died and that car went in the building? Let me get, one little example is I have a relative
that said, without knowing anything, before even the blood came back, results that they allege, said, well, her car went in the building, so she's responsible. It's not a strict liability crime. And I respect the jury for what they had before them. Some of that evidence, we say, we filed motions, was unlawfully obtained, unconstitutionally obtained. Acting that way can violate a lot of people's rights, including you and I. You know, that saying that when they come for you and come for this person, that person, you don't say anything, but when they come for you, then all of a sudden you say something. So it was very apparent with the court. I have respect for the judge, but it was very apparent that this was a one-sided case. This was going to be a conviction, no matter what it took, from all ends. There's going to be a conviction. When you lose 8 out of 10 motions, and they weren't frivolous, and it all dealt with constitutional issues, every one was no, denied, 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 denied. Been doing it 39 years. I've never had motions denied like that. So,
did you know specifically to get that video we saw today excluded?
yes. Yes.
Will you have a chance to talk to the jurors?
We could, or I could ask. I'm not going to. I'm not going to. You know, they've gone through a lot, and probably one of the last things they want is one of the attorneys to come in. I'm sure they're extremely emotional. I could tell when they came out that they couldn't make eye contact. And during the trial, I had a lot of eye contact. There was no eye contact at all. In fact, they looked down. I don't think they were happy that they had to deliver a verdict. Not at all. But they felt inside they needed to.
Was Miss Chidester surprised by the jury's verdict?
My client knew going into this case that the jury, to pick from the jury the people, it would be that it would be tough to do because they're so tainted. The community's tainted. I'm not saying you get tainted automatically. When you talk to somebody and you say, oh, 2 kids died. Oh, what happened? Did the car go in the building? Yeah. Oh my God, she's got to be guilty of something. So we had many heart-to-heart conversations, Marshella and I, very many heart-to-heart, including today. And she was well aware that certainly could go either way or split. Our most important issue was the murder 2 charge, because with 2 murder 2 charges at her age, you might as well give her life. Might as well give her life. And she was aware of what could have happened. And she was aware that if it's an early verdict. And, you know, she stayed strong.
Thanks, Bill.
And you know, just real quick, she's been out on bond. And a lot of people were saying, listen, her age, her sentence of multiple years if found guilty, just leave. Just leave and not come back. And no, she stayed, and she faced up to it.
What? What? Oh, I didn't realize I wasn't muted the whole time. She stayed and I'm sorry. What? I'm sorry. Oh, he cannot read a room. He cannot read a room, you guys. Yeah, I don't know I mean, like, I want to try to plan it out, but you don't like Clinty because of what a dirty girl she is. You took us through that apartment and it looked worse than a crime scene. Well, Barry, I don't even know when her trial's coming up. That's how bad it is. And Corey's is this month, isn't it? I just don't know what date. I got to look on my calendar. Richens is probably going to be this month. And then when is Adelson going into trial? I'm willing to watch that one or Vallow. Vallow's at the end of the month. No, I'm willing to watch a new one if y'all don't mind the fact that I may not know that much about it. I mean, it's bad enough I don't know anything about legal, but to come into a case where I don't know anything about what's going on in the case, I mean, what good am I? I'm basically a sounding board for the TV for y'all. That's all I bring to the table. So I don't know. We'll find something though. I think what I'm going to do is snip the end of this one where we did this trial and put it into its own video and cut it off the Marshella trial so it's on its own. And yeah, with Vala being pro se, but you know, she has a she's got an assistant or somebody, like a legal assistant, which I still don't understand how that works. Maybe she's paying for it. Is that how she gets one? But she's definitely got somebody helping her there because I saw it. But yeah, so but hers is the end of the month. Richard's, I think, comes up before that. I just don't know when. Lenny, do you know when the Adelson trial starts? When her trial? Because she just got arrested again, right? See, I know exactly what happened in that case. I know all about, you know, the red rum, their daughter was, you know, it's her divorced husband, and he was an attorney, very well liked man. And I know all about the son was involved. He hired somebody that worked at his dentist. I know all that, but I just don't know all the ins and outs of what's been going on with the case and trial since it all started going into court. I didn't watch Charlie's trial, which I wanted to, and I never got to it. I think he was in trial around the same time we were watching Sarah. Why did the prosecutor step down in the Clinty case? I did a video on that. Did you see the video I did? I just did it yesterday. I posted it yesterday. Hang on, let me look and see what it's. Or did it go up this morning? No, it went up on the 4th of March. Courtney Clinty pretrial drama is the name of the video. Traveling Teresa. Just watch it. It's only 3 minutes, 45 seconds long, and it explains everything. Let's see. Or if you've already watched it and you're still confused, that's going to bother me because I thought I covered it. Okay. Do you remember when they had all the files that came out with? Did you go back and did you watch it already? Okay, it is kind of short. Okay, I'll explain it really quick and then we'll get off. Remember when they arrested the parents and they put new charges on her for them breaking what they call breaking into his laptop? We're talking about the Courtney Clinty case now, you guys. Well, they dropped those charges. However, in doing all of that, while all of that was going on, I guess the prosecution got into some cloud files, or some files in the cloud, whatever. It was documentation that was private information. There was this big to do about it. Private information for the parents, and they said that there was some discussions and on some emails in there that were between the parents and Clinty's prosecutor that was talking about how they were going to move forward with the case and their strategy and all that. Well, they called their bluff on it and said, you know, they kept pushing and pushing, the defense did, to get the prosecutor thrown out for doing that. And the judge agreed and finally said, yeah. But really what happened was the prosecutor said, look, I'll just step down. I'm going to step down. I guess he was trying to save the trial from really going anywhere wrong, because I think he knew, look, it's easier for me to step away and let what's his name that's been here the whole time anyway just take over than to have more issues with this trial, because it's been delayed. They have never scheduled a date for the trial. It's like they keep getting into other stuff and talking about other stuff. And every time you think the state's ready, the defense isn't ready. And, you know, their defense attorney gets panties in a wad and starts going off about how, you know, he's so dramatic. So, yeah. But that's why. That's why. Does that help? So, yeah. So, my baby Frank is hungry, and I'm hungry. I want a burger. I want a big, fat cheeseburger with french fries. I've been craving one for several days. I hadn't had one in a while. I've been eating nothing but soup and I ate a grilled cheese sandwich this week. When I'm on the computer like this all day, I eat knick-knack stuff. I don't eat good stuff. So I want something really good. So anyway, I really appreciate you guys being here with me all day long. This was nice. We're going to do it again. Tomorrow we'll finish watching the rest of this trial or hearing that we were watching just now with Morgan Geyser. And then from there, we'll see where it goes. We'll just pick up, I don't know if we'll do, that might be all we do tomorrow, but by Monday, we might have something new to watch together. So just keep touching base, and I'll send out the emails on the Buy Me a Coffee. If you have ever donated or put like a tip in that Buy Me a Coffee website that I have, if you've ever bought me a coffee in there, then you're on the email list for me to send you an email every time I post something. So it does help some people if the YouTube algorithm is not getting to them. But you have to opt in on it. I don't have your stuff automatically. All right. Well, thank you, everyone. Have a blessed evening, and I will talk to you all very, very, very soon. Be good. Thank you, Laura and Bama.